ಬಂದ್ರು ಸಬ್ಮಿಟ್ ಮಾಡಿ.
Sorry? Pending or fresh, madam? Tuesday ಆಗ್ಬೋದಲ್ಲ? Tuesday it will come, give it. Fresh matters, unless somebody wants it at 2:30 urgency, idre wait ಮಾಡಿ ಮಿಕ್ಕಿದ fresh matters ಕೊಟ್ಬಿಡಿ. General fresh matters please give. Settlement memos all you give. Today whoever wants settlement please give.
125 minutes. Connected matters listed today also. 125.
Your Honor, fresh
Wait.
matter.
Special court ಇಲ್ಲ ಯಾಕೆ ಬರುತ್ತೆ? Successive special court ಬರುತ್ತಾ ಇಲ್ಲಿ? ಆಯ್ತು ಕೊಡಿ.
Your Honor.
ನಾಳೆ.
My lordship. My lordship.
Pending matters ಏನಿದೆ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. It will come on the designated days, give it. No, 2025 matters will come on the designated days according to seniority. ಅದ್ ಮಾತ್ರ ಚೇಂಜ್ ಮಾಡಕ್ ಹೇಳ್ಬೇಡಿ, ಕೊಡಿ. ಬರುತ್ತೆ, ಖಂಡಿತ ಬರುತ್ತೆ. ನೀವು ಕವರ್ಡ್ ಬೈ ಅಂತ ಹೇಳ್ತಾನೆ ಇದ್ದೀರಾ, ಬರುತ್ತೆ.
Being spoken to.
Wait, any mentioning please wait. ಯಾವ ವರ್ಷದ್ದು? 23 ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ, ಕೊಡಿ. ಆಯ್ತು, ಎಲ್ಲ 23 ಬರುತ್ತೆ, ಕೊಡಿ ಕೊಡಿ. ಇವಾಗ ಕೊಡಿ ಸರ್. 23 ಯಾವುದಾಗೆಲ್ಲ ಕವರ್ಡ್ ಹಾಕಿ ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಫ್ರೆಶ್ ಮಾಡಿ ಟುಮಾರೋ ವೈ ಸರ್. 2:30 ಕೊಡಿ. 2:30 ಕೊಡಿ. ಅದು 14% ಏನು? ಕೊಡಿ. ಅದರ್ ಕೋರ್ಟ್ ಡೇಟ್ ಇದ್ರೆ ನಾನು ತಗೊಳಲ್ಲ, ನನ್ನ ಕೋರ್ಟ್ ಪ್ರಕಾರ ನಾನು ಹಾಕ್ತೀನಿ, ಕೊಡಿ ಕೊಡಿ. 2:30 ಬೇಕಾದ್ರೆ ಒಂದ್ ನಿಮಿಷ ವೆಯ್ಟ್ ಮಾಡಿ. whoever wants it 2:30 please wait. ಅದು ತಗೊಳ್ಳಿ. ಮರಿಯಪ್ಪ ಕೊಟ್ರಾ? ಸರಿ. ಟ್ಯೂಸ್ಡೇ ಆಗ್ಬೋದಲ್ಲ? ಮಾಡೇ ಮಾಡ್ತಾರೆ. ಆಯ್ತು, ಟುಮಾರೋ. ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಸಾರಿ, ಫಾಲ್ಸ್ ಪ್ರಾಮಿಸ್ ಆಫ್ ಮ್ಯಾರೇಜ್. ಸೊ ವಾಟ್? Fresh matter. ಬರುತ್ತೆ, ಕೊಡಿ. Fresh matters, general fresh matters please give.
Lot for tomorrow.
Wait, whoever wants it at 2:30 please wait. ಮಿಕ್ಕಿದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ fresh matters.
Lot for tomorrow.
Order, the investigation officer has issued 2 notices.
Give it.
Kindly.
Other, which year?
My lord.
Tomorrow ಹಾಕಿದ್.
Tomorrow, the petition is a 8-year-old petition. In this case,
ಏನ್ ಬೇಕು? ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್?
My lords.
ವೇಟ್ ಮಾಡಿ. ಬೇರೆ ಕೋರ್ಟ್ 10:30 ಸ್ಟಾರ್ಟ್ ಆಗೋದು. ಸೊ ನೋ ಹರಿ ಅಟ್ ಆಲ್, ವೇಟ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಯಾಕೆ ಟ್ಯೂಸ್ಡೇ ವರ್ಗ ಆಗಲ್ವಾ? ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟ್ರಬಲ್ ಮಾಡ್ತಾ ಇದೆ. ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ಬೇಲ್ ಮತ್ತೆ ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ.
Lots for
What
tomorrow.
is the offense? What's the offense? Oh, give it. Tomorrow ಕೊಡಿ.
Lots for tomorrow, my lords. Lots entire.
You want it at 2:30?
Yes, my lord.
Give it.
45 application reject ಮಾಡಿದ್ರು. Day after tomorrow ಗೆ final agreement ಕೊಟ್ಟಿದ್ದಾರೆ.
2:30.
Warrant has been issued against the.
Great. Warrant ಯಾವ್ದು? 2:30 ಕೊಡಿ.
ED matter at 2:30 minutes. Copy has been served.
Wait, ಯಾವ್ದು?
the matter, my lord. Petitioner is an online gaming company. So the petitioners are summoned 18 times to the ED office, despite there being no predicate offense.
When, pending matter. Pending matter.
No, my lord, fresh matter. I'm requesting for
We wanted it 2:30.
2:30.
Kudi.
My lordship, the petitioner account freeze ಆಗಿದೆ, my lordship.
My lords, in trial court, the matter is set for framing charges on 29th, my lords. It may be taken on Tuesday, my lords. There is no stay.
ಆಯ್ತು ಕೊಡಿ.
My lordship, petition.
Enters in agreement and compromises the matter. 2 days thereafter, my lord's wife has registered a complaint. Now police lawyers are wanting to seize my vehicle.
All right, give it.
2:30.
When do you want? 2:30. Give it.
My lordship, petitioner account freeze ಆಗಿದೆ, my lordship.
ಆಗ್ಲಿ ಬಿಡಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲ ಮುಗೀತು, my lordship.
ಪೆಂಡಿಂಗ್ matter.
Date ಕೊಡಿ. Any
ವಾರಂಟ್ ಯಾವ್ದು ಕೊಡಿ? 2:30ಗೆ ವಾರಂಟ್ ಯಾವ್ದು ಇಶ್ಯೂ ಆಗಿದೆ ಎಲ್ಲ 2:30 ಕೊಡಿ.
Your Honor, warrant.
Give it, give it.
My lordship, any date, my lordship?
Warrant
Yes,
2:30.
138, madam.
2:30. Yes.
Vacating stay,
Pending matter ಅಲ್ಲ ಡೆಸಿಗ್ನೇಟೆಡ್ ಡೇಸ್ ಬರುತ್ತೆ ಕೊಡಿ.
My lordship,
ಡೇಟ್ ನಾನು ಕೊಡ. ಡೆಸಿಗ್ನೇಟೆಡ್ ಡೇಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೀನಿಯಾರಿಟಿ ಇಟ್ ವಿಲ್ ಕಮ್. ಡೋಂಟ್ ಡಿಸ್ಟರ್ಬ್ ದಟ್. Just keep it. ಕೊಡಿ. 2:30. ಅದು ಅವ್ರದ್ದು 2:30 ತಗೊಳ್ಳಿ. Sorry? Fundamental rights, human rights. ಸರಿ, ಆಯ್ತು 2:30.
my lordship, tomorrow, my lordship. Madam, at 2:30 ಅಲ್ಲ?
No, I'll take every memo, please wait. What is it? One person? One person, third person. You are what, second person? ಮತ್ತೆ? Sorry. Calling me for? Don't know for what purpose. Then why are you moving the memo? Give it. Tuesday.
My lord,
My lordship, tomorrow, my lord.
Vacating stay ಏನೇನಿದೆ ಎಲ್ಲ ಕೊಡಿ.
all office objections are complied with, my lord.
It will come, sir. Extension of parole, take it, madam.
End of the list, my lord.
Don't wait. ಇವತ್ತೆಲ್ಲ end of the list I will take. ಮಧ್ಯಾಹ್ನ ಇಂಟರ್ವ್ಯೂಸ್ ಇಲ್ಲ, ಸಾಯಂಕಾಲದವರೆಗೆ ಕೂತ್ಕೋಬಹುದು.
My lord, vacating.
ಹಾ?
Lookout circular has been issued.
ಲುಕ್ಔಟ್ ಸರ್ಕ್ಯುಲರ್ ಇಲ್ಲಿ ಹೆಂಗ್ ಬರುತ್ತೆ? GM ಹಾಕ್ಬೇಕಲ್ಲ. GM ಎಲ್ಲೆಲ್ಲಿ ಬರುತ್ತೆ? ಲುಕ್ಔಟ್ ಸರ್ಕ್ಯುಲರ್ ಫಾರ್ವರ್ಡ್ ಬರಲ್ಲ. ಚೆಕ್ ಇಟ್. ಅಲ್ಲಿ
Application also filed, my lord, to release of the passport. Passport has
ಆಯ್ತು
been
ಕೊಡಿ
released.
ನೋಡ್.
2:30.
ಆಯ್ತು.
And also for.
But if it is a pending matter, it won't come. It will not be fair. ಕೊಡಿ.
All office objections have been complied with.
Give it.
My lord, vacating stay has been filed.
Vacating stay, please give. Those years dates will ಬರುತ್ತೆ. Tuesday, Wednesday, Thursday.
25 matter.
Then it is Thursday. All right, give it.
Thursday.
Fresh matter. 2:30 ಬೇಕಾ? ಕೊಡಿ. ಹಾ. ಯಾವ ವರ್ಷದ? Tuesday, Wednesday, Thursday ಎಲ್ಲ ತಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಒಟ್ಟಿಗೆ ಕೊಡಿ.
Lords, date is fixed for framing of charges.
ಮೇಡಮ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಆ ಇಯರ್ದು ಬಿಗಿನಿಂಗ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ.
Trial court has fixed date for framing of charges. my lord.
ವೆರಿ ಗುಡ್. ವೆನ್?
On the 30th.
We can take it on Tuesday?
Yes, please.
Yes. One ನಿಮಿಷ, ಏನು 14%? Who gave you the date? Who gave you the date? Earlier bench. All right. Which year is that? It will come next Thursday. You come. No worries. Next Thursday you come. We will hear it and close it. No problem. 1 year, nothing. 1 week, nothing is going to happen. Give it. Next Thursday, kodiyal. Bedwa memo. You don't want next Thursday? Give it. Memo move ಮಾಡ್ಬಿಟ್ಟು ತಗೊಂಡು ಹೋದ್ರೆ ನೀವೇ? ಗೌರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯಿ. ಇಲ್ಲಿ ಯಾಕೆ ಬರುತ್ತೆ? ಸರ್ವಿಸ್ ಬೆನಿಫಿಟ್ಸ್ಗಾ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರ? ಯಾವ ವರ್ಷದ? ಮುಂದಿನ ಗುರುವಾರ ಬರುತ್ತೆ ಕೊಡಿ. ನಿಮಿಷ. I'll speak to you. Wait. Yes. ಕೊಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. Not tomorrow, madam, Tuesday.
My lord, fresh matter, my lord.
Give it. No, I am not able to travel here. ಎಲ್ಲ ಈ ಕಡೆ ಬರ್ತಾರೆ ಕೊಡಿ. Sorry, when do you want? Tomorrow, give it.
Matter may be taken on Tuesday, my lord.
ಏನ್ ಫ್ರೆಶ್
Fresh, my lord.
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
My lord,
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
urgency ಇದೆ, my lord.
2:30 ಬೇಕಾ?
2:31 ಬೇಕಾ?
ಕೊಡಿ.
ಇನ್ನೊಂದು matter may Tuesday, because in
ಆಯ್ತು.
that matter GST is there, my lord.
ಆಯ್ತು.
Lord, fresh matter for 2:30, my lord.
Why?
Lord, the petitioner, Lord, this work is sub-registrar's office. Allegation of impersonation is done, Lord, and PTCL, SCST Atrocity Act also, Lord, is invoked. 2:30, Lord, some, great. 2:30.
I'll speak to you. Wait, sir. 2:30.
Lordship, the petition
My
is a
lordship.
senior citizen, lordship, based
Pending
on
fresh.
fresh matter, lordship. 2:30, lordship, the petition.
ಆಯ್ತು ಕೊಡಿ 2:30. Give it. Yes.
2:30,
My lordship,
lords.
in his case 9/12/2025, FIR has been registered. That time petition was not present, my lordship.
Who are you both? 14%? Which case? Huh? Wait, I'll hear you, wait. Yes.
9/12/2025, FIR has been registered alleging assault and molestation and trespass, my lordship.
So,
Subject is finality in Supreme Court on 19/11/2025, my lordship. That day, the incident happened, petitioner was not present, 9/12/2020.
You're an advocate,
They were in, they're engineers and MBA graduates, madam.
ಕೊಡಿ.
Have it tomorrow, madam.
Tuesday ಬರುತ್ತೆ.
Because of that, it's 8/12/2026.
Bail ತಗೊಂಡಿದ್ದೀರಾ?
Bail has been taken.
Then no. Tuesday.
Lords, 2:30, my lords.
Why?
Because I'm wife, lords, I'm also public servant. A case is filed against my husband initially alleging that he has, on the false premise of marriage promise obtained sexual, permission to, he had sex.
Wife has filed against
No,
husband.
not wife. A case is filed by a lady, my lord.
So, wife is
Then
the
I have
accused.
been roped in now.
2:30.
That's why, my lord. there's a-
2:30.
Lord, pending, my lord, fresh matter.
Wait, he wants to speak to me. Yes, sir. Being spoken to. ಏನ್ ಹೇಳಿ? ಏನ್ ಹೇಳಿ? ಅಷ್ಟೇನಾ ಕೊಡಿ.
My lord, 2:30.
Vacating state ಕೊಟ್ಬಿಡಿ.
Pending matter, my lord, is supposed to be listed yesterday.
Date given by whom? No, give it. It will come according to the dates of this court.
My lord, fresh matter, Tuesday.
Pending matter, my lord, vacating state. Next week, any
Sorry,
date.
Bobby.
Disposed matter, my lord.
Dispose matter ಏನಾಗಿದೆ?
I for correction, I have filed, my lords.
ಏನು?
My lords, in one matter, there is a district typographical error, my lords, the change of
Which is a
district.
salary matter.
Illa, electro-homeopathy, my lords. Covered by.
good.
And another ranking is changed, my lords, tomorrow, my lords.
Tomorrow. Madam, ಅದು correction ನಾಳೆ ಹಾಕ್ಬಿಡಿ.
Obliged, my lords.
For settlement tomorrow.
Settlement ಯಾವಾಗ ಬೇಕು?
Friday, reporting settlement.
Give it, sir. Settlement withdrawal ಎಲ್ಲ 2:30 ಹಾಕ್ಸಿ madam. Pending fresh. Next Thursday. I am not given date. Give it. Next Thursday. Stay ಇಲ್ವಾ? Entry ಮಾಡಿದ್ಯಾ? ಬರುತ್ತೆ. It will come Tuesday ಬರುತ್ತೆ.
Fresh matter, my lord. It is arising out of a sale agreement, my lord. Petitioner
Give
only
it.
misses the complaint into buyer, my lord.
Give it, sir.
Out of that, my lord, 420 has been registered and the petitioner is being asked to settle the matter, my lord. But no role, my lord. Tomorrow, my lord.
Where is your gown? Where is the gown? 14%. Then wear your gown and come. You can't come as and how you like. You're not in a restaurant. Go wear the gown and come.
Yes, 2:30 ground of arrest matter, lordship.
2:30.
My lord, 2:30.
It's
Prosecution has.
pending matter, lordship.
Pending.
No, lordship, date was given to submit the report.
10.
And the date was not, yesterday it was
How
there.
ವರ್ಷದ್ದು?
2025 only, 4 months.
ನಾಳೆ ಬರುತ್ತೆ. Pending matter, it's
Yes,
not fair.
for that reason I fairly submitted.
My lord.
Matter of deposit of the.
Sorry?
Deposit of the DD matter. Before this is a 138 matter. The matter has been compromised between the trial court.
ಆಯ್ತು ಕೊಡಿ.
My lord, 2:30.
To deposit of the DD matter.
ಕೊಡಿ.
My lord, for 2:30, my lord, the prosecution has filed an application under 173
Movement
clause.
is there.
Please, my lord.
2:30
My lord, the matter is posted for evidence.
Today there is no interview, so I am taking all the memos. Give it. 2:30.
Please.
Oblige me. When do you want it?
Tuesday.
Give it.
Anticipatory bail ಇದ್ರೆ arrest ಮಾಡಿದಾರಲ್ಲ.
Anticipatory bail
ಇದ್ರು arrest ಮಾಡಿದಾರೆ.
ಇದ್ರು ಅರೆಸ್ಟ್ ಮಾಡಿದಾರ.
ಮನಿ ರಿಕವರಿ ಸೂಟ್ ನಡೀತಾ ಇದೆ ಸಿಟಿ ಕೇಸ್ ಮೇಲೆ arrest ಮಾಡಿದ್ದಾರೆ.
Anticipatory bail ಇದ್ರು ಅರೆಸ್ಟ್ ಮಾಡಿದಾರ. ಬೇರೆ ಕ್ರೈಮ್ ಆಗಿರ್ಬೇಕು ನೋಡಿ.
ಇಲ್ಲ ಅದೇ ಸೇಮ್ ಕ್ರೈಮ್. Kindly have it tomorrow madam.
ಆಯ್ತು ಕೊಡಿ ನೋಡಿ.
Tomorrow.
ನಾಳೆ
One.
For disposal. ಅದು ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ತಗೊಳ್ಳಿ. ಗೌನ್ ಬಂತ ಈಗ ಹೇಳಿ. ನೋ ಎಸ್
ಲಾಸ್ಟ್ ನವೆಂಬರ್ ಅಲ್ಲಿ ಫೈಲಿಂಗ್ ಮಾಡಿದ್ವಿ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮೇಡಮ್.
480
ಎಲ್ಲ 482 ಅಫೆನ್ಸ್ ಏನು?
ಇದು ಗೌರಿ ಕೇಸ್
498 ನಾಳೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Both belong to SC/ST.
Where is your gown? Where is your gown? So you should not wear a gown, is it? Go wear and come. You can't come inside the court without a gown. Yes.
Both complaint petition belongs to same caste, SC/ST. Atrocity case.
ಕೊಡಿ.
ಇನ್ನೊಂದು 379 ಮೂರು ಜನ ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾರೆ ಸರ್. ನಾನು ಒಬ್ಬ ಇರೋದು ಇಲ್ಲಿ. ನನ್ನಿಂದ ಮೆಟೀರಿಯಲ್ ಏನಿಲ್ಲ ಸರ್.
ಆಯ್ತು ಕೊಡಿ.
The Lordship for respondents, we have filed vacating IA.
Which year?
It's 25, Your Lordship.
Thursday it will come.
Fresh matter pending.
Fresh matter pending ಎರಡು ಒಟ್ಟಿಗೆ ಆಗಲ್ಲ.
Pending, but the notice not issued, my lord.
Not issued Tuesday ಬರುತ್ತೆ.
My lord, in this case, atrocity case, my lord, entire.
ನಾಳೆ ತಗೊಳ್ಳಿ.
My lord, one matter pertaining to GM DRT, my lord.
GM?
GM DRT. But
ಇಲ್ಲಿ ಹೆಂಗ್ ಬರುತ್ತೆ?
partly heard by your honor.
Then it will come on only 6th February. Give it.
Lots, one pending.
My lord,
ಅದಕ್ಕೆ ಮುಂಚೆ ಆಗಲ್ಲ madam. See 3:30 I am getting up. I can't hear. So 6th
next
February.
Monday, my lord. Next Tuesday, 27th it may be taken.
27th also interviews are. Up to 30th don't ask. From 1st February we'll take it. Take everything.
Okay, 2nd February.
ಆಯ್ತು ಕೊಡಿ. Yes.
Monday.
Lots, today matter was directed to be listed.
ಯಾವುದು?
Lots, the art of living matter, your lordship had.
ಬಂದಿಲ್ಲ ಇವತ್ತು?
ಇವತ್ತು
Why madam? ಯಾಕೆ ಲೇಟ್ ಆಗಿ ಬಹಳ ದಿನ ಆಗಿದೆಯಲ್ಲ. 2:30 ಹಾಕ್ಸಿ. ನಾವು ಕೊಡಿ ಸರ್.
ಲಾಯರ್ ಚೇಂಜ್ ಮಾಡಬೇಕು. ಲಾಯರ್ನ ಚೇಂಜ್ ಮಾಡಬೇಕು.
Fresh matter.
ಲಾಯರ್ ಎಂಗೇಜ್ ಮಾಡ್ಬೇಕಾ?
ಬೇರೆ ಲಾಯರ್.
ವಿಚ್ ಮ್ಯಾಟರ್? ಸೀರಿಯಲ್ ನಂಬರ್ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ? ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಲಿಸ್ಟ್ ಆಗದೆ ಮ್ಯಾಟರ್ ಹೇಳಿ. ಯು ಕಾಂಟ್ ಮೇಕ್ ಅ ಮೆನ್ಷನ್. When it is listed, you make a mention. Call the case. ಸಾಕು ಸಿದ್ದರಾಮಯ್ಯ 18 ನಿಮಿಷ ಆಯ್ತು. ಇನ್ನೆಷ್ಟು?
Make a submission.
ಕೊಡಿ ಸರ್.
Pending branch.
Give it. It will come.
Take it as a old matter.
It will come. Give it. Yes.
Your lordship.
Tomorrow it may be called. My
Tomorrow. ಕೊಡಿ.
Your lordship.
My lords, may I make a submission?
Wait. We see. Wait.
ಮುಂಚೆ ಬಂದಿದ್ರು ಹಿಂದೆ ಬಿಟ್ಟಿರಲ್ಲ ನಮ್ಮನ್ನ.
ಸಾಕು ಎಷ್ಟು?
ಟ್ಯೂಸ್ಡೇ ತಗೊಂಡಿರೋದು ಮಧ್ಯಾಹ್ನ ಹಾಕೊಂಡ್ರೆ.
ಮಧ್ಯಾಹ್ನ ಏನ್ ಹಾಕೊಳಂಗಿಲ್ಲ.
ಟುಮಾರೋ
ಯಾವತ್ತು ಎಂಡ್ ಆಗ್ತಿರೋದು ಪೆರೋಲ್ ಯಾವತ್ತು?
ಉಮ್ರಾಗ ಹೋಗ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಅಯ್ಯೋ ಪೆರೋಲ್ ಎಂಡ್ ಆಗ್ತಿರೋದು ಯಾವತ್ತು?
ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ವಾಷಿಂಗ್ your lordship. Stay your lordship. Stay your lordship.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
Fresh matter your lordship.
ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. FR ನಂಬರ್ ಕಂಪ್ಲೈ
ಇಲ್ಲ
ಕಂಪ್ಲೈ ಆದ್ರೆ ಮಾತ್ರ
ಕಂಪ್ಲೈ ಆಗಿದೆ.
Yes, call the case.
My lords, may I make a submission?
Adjournment ಇಲ್ಲ when it is called. Yes.
My lords, may I make a submission?
When it is called. Yes.
Memo, my lords, pertaining to the road bench.
Memo if someone is here. Yes.
He submitted, my lords, pertaining to the road bench, my lords, for service matter, my lords.
Call the cases. ನೀವು ಬರ್ತಾನೆ call the cases fast. Nothing. Yes. ಏನಾದ್ರು ಇದ್ರೆ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. No. Call the case. Yes.
Lordship, I am appealing for the petition.
Yes, sir.
Lordship, the mother of the victim, Lordship, filed application under section 17.
ನೀವೆಲ್ಲ ನಾನು ಕೌಂಟರ್ ಇಟ್ಕೊಂಡು ಕೂತಿದ್ದೀನಿ ಮೆಮೊಗೆ ಅಂತ ಬರ್ತಾನೆ ಇದ್ದೀರಾ? Yes, sir. Yes.
Lordship, the mother of the victim filed application under section 17(2)
17(2)
of the ITP Act, my lordship.
She is not entitled.
Now she has attained majority, my lordship. The
Now,
victim
this
to-
is the victim that you have
Rescued
earlier under the ITP offenses.
Correct.
Now, the victim has to be given to whom?
No, she was given to mother. Thereafter, again, that victim has sent back to the prostitution.
lordship.
That's a-
Now she has
in
attained
fact,
majority, my lordship.
No,
So-
she has attained majority, she deal with it differently. my
So,
lord. Fact, my
Lordship.
lord.
who are, you are the mother, is it?
Yes, mother.
But
Could you
subsequently,
report, could you?
subsequently, mother of the
No,
victim.
no,
has
if the
also-
mother is indulging in the prostitution of the
No, no,
daughter, you
no.
think I will give?
In fact,
Give it,
yeah,
yes.
I have
could
asked
you-
them to, I have asked them to book against
As
her
on
also
the
for,
date of,
No, why have you left the mother simply?
I have asked them to look into that aspect. In fact, so in the Bombay High Court, my lord has dealt with this issue in
Today, how can
extensive.
how can you leave the mother like this?
It's an unfortunate scene, my lord.
Then,
And now they have, she has produced the rent agreement to show that I'm staying here, etc. All these
subsequently,
things,
sorry,
yes, one inch, sir, 1 inch.
all these things, my lord, goes to show that she is an active connivance. And she should be treated as an accused in this case. The question of releasing to the distinguished lordship means here, paragraph 28, my lord. 26 first, my lord, at page 112. Section talks about section 29, my lord. JJ Act, state can constitute a committee, child welfare committee. Thereafter, my lord, the lordship is said para 28. In almost all cases where girls are rescued from brothel, it is found that they are forced to submit prostitution by brothel keeper. Cases are not unknown where young women from far of the
This is
country.
also far corner of India. Ne?
Thereafter, your lordship may see at page 30, para 33. And para 37 is the directions issued.
Idರಲ್ಲಿ ಯಾವ್ದು material, Jagdish sir?
Really, earlier, the order, my
That
lord.
is, this is Spana to a lodge. Where was she rescued?
Large.
You are the mother.
Yes.
please, my lord.
Yes.
This is
But
the
subsequently, she attained majority, my lordship.
this is the earlier
Cannot
intimation to release.
keep it the victim girl as a minor girl, my lordship. Now she has attained majority.
This is the earlier
Minor
order of
ಇದ್ರೆ
release.
ಬೇಕಾದ್ರೆ ಇವಾಗ ಇಟ್ಕೋಬಹುದು ಬೇಕಾದ್ರೆ. Now subsequently in the month of January 2026, my lordship, she attained majority.
If she has attained majority, we'll deal with her separately. She don't have to interfere in this.
All right, we'll pass an order.
The earlier order of intimation, earlier order, my lord, releasing the
Namely, Nazma Prabhat Maiti, age 16 years, custody of so and so. Verifying beyond our compliance section, the report of this court. The petitioner is before this court calling in question an order dated 15/11/2025 passed in crime number 395 of 2025 on an application filed under subsection 2 of section 17 of the Immoral Traffic Prevention Act, hereinafter referred to Act with short. The petitioner heard sounds. The petitioner is said to be the mother of the victim child. The victim was rescued from a prostitution racket run by using her in a lodge. The state then rescues and keeps the victim with
She has been
State
now
welfare,
in the child welfare home. The petitioner mother files an application before the concerned court seeking release of the child, seeking release of her daughter on account of the fact that she has now attained 18 years of age, and once she has attained 18 years of age, the daughter cannot be kept under the child welfare home but has to be given to the parents, one of whom is the petitioner. The concerned court, after rendering detailed reasons, has rejected the said application on the score that the daughter was forced to prostitution by the mother. This is what is challenged before this court in the subject petition. The learned counsel appearing for the petitioner would submit that subsection 2 of section 17 of the Immoral Traffic Prevention Act can be pressed into service only against a minor girl and cannot, the victim girl, however, the victim girl cannot be kept in child welfare home or under the custody of the state once she attains the age of 18 years, and the mother is entitled to the said custody. The learned additional SPP on takes this court through the entire material that led to a raid in the lodge, which led to registration of a crime in crime number 395 of 2025. Sorry, 395,
Correct.
395 of 2025. The police, after investigation, filed a charge sheet against several persons. The learned additional SPP submits that a mother ought to have been booked for forcing the child for prostitution. That has not been done. That has not been done. It is an inadvertent omission. Be that as it may, the issue now is whether the child who is the victim who was rescued from a prostitution racket, who was at the relevant point in time, 16 years, 17 years, 17 years, should be released to the custody of the mother, who, on the score that she has now attained the age of 18 years. Subsection 2 of section 7, therefore it is necessary to notice the said provision. Subsection 2 of section 17 reads as follows. The subsection 2 of section 7, could you madam, ITP.
Page 13, my lord. High Court order. Extract.
17 mandates that the intermediate custody of girls removed under section 15 or rescued under section 16 can be kept only till they attain the age of 18. The petitioner therefore files an application that the petitioner mother therefore files an application seeking custody of the daughter on the score that she has now attained the age of 18 years. This comes to be rejected by the following order. Page 12 to page 15. The crime, to consider whether the child could be released or not, it is necessary to date back to the reason for registration of the crime. The crime comes to be registered in crime number 395 of 2025 for offences punishable so and so. Page FIR antide. The police conduct investigation and file a charge sheet. The summary of the charge sheet reads as follows. The issue in the list does not pertain to the merit of the crime in crime number so and so or the charge sheet so filed. The statement of victim statement.
Yes, produce the victim statement.
The statement of the victim or the statement of the victim and the statement of others would clearly indicate the mother had would prima facie indicate that the mother had forced the daughter to prostitution. The learned additional SPP is right in contending that when a child is rescued from a prostitution racket and is in the custody of the state in a child welfare home, if the allegation is that the mother is indulging in sending the daughter for the purpose of using the daughter for the purpose of prostitution, it cannot be that the child should be given to the mother. It is ununderstandable as to how the mother is left while filing the charge sheet, notwithstanding the fact that there is a lurking suspicion that she has indulged in sending the daughter for prostitution, albeit prima facie or an allegation that she could be left off while filing the charge sheet. In identical circumstances, the High Court of the Division Bench of the High Court of Bombay, considering this very aspect, has held as follows. In that light, I am of the considered view that the child cannot be handed over to the mother who is allegedly using her in the prostitution racket. Therefore, the petition lacking in merit stands rejected.
Lordship may also had in earlier occasion in crime number 332 of 2024, the victim was released to the mother. Thereafter, this case
additional SPP held. The learned additional SPP would further contend an earlier crime had been registered against the mother.
No.
Earlier crime had been registered for the very purpose of for the very offences under the ITP Act, and the application being filed by the petitioner mother, the child was released in favor of the mother. Mother again puts her back into the same racket of prostitution, which has now become a crime in crime number 395 of 2025. Amila. Yes.
Number 2.
For settlement, it may be taken up 125 minutes. Connected matter is listed for 125.
120?
1 o'clock, 1.
Settlement.
ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ನಮ್ದು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ ಕನೆಕ್ಟೆಡ್
Madam, ಆಯ್ತು.
Number 3.
ಆಯ್ತು ಗೊತ್ತು. Yes, sir.
The suit filed by them is dismissed, holding that this site which they claim is not the site which belongs to the defendant. The identification is defendant site, whereas throughout the evidence, it is said that is not his site is 629 and it comes in 17/4. Up to 17/4 only layout is made. In 17/3 no layout is made even according to the layout plan. The holding that the trial court after the holding a survey by ADLR office, it was held that the petitioner hearing failed to identify the site 629 instead of showing 29 only. And on that ground, the suit was dismissed in 2000, quite long back.
That dismissal has become final?
That they filed RFA. Now they have filed an application for amendment. On that basis, it is remanded. But there is no prima facie case to show that
They have trespassed.
No. Because taking the power, the financial power and the rowdyism, my party is a widow, and her site is to be. They are trying to enter into the site.
Yes, Sunil.
That's the lordship judgment on
Judgment
the
irli,
issue.
facts ಹೇಳಿ.
That's
Who is
facts.
in possession?
I'm only till today, my lords, I'm in position.
ಮತ್ತೆ
The
suit
order of
dismiss
the
ಆಗಿದೆಯಾ?
coordinate bench of the
Suit dismiss ಆಗಿದೆಯಾ?
suit is dismissed, my lord. Then we approached dishonorable court filing RFA. Now, my lords, dishonorable court with order dated 9th December 2025
ಈ case
remanded.
ಅಲ್ಲ?
Yes, my lords. In very same case, the dishonorable court has ordered for remand of the matter for fresh consideration.
ಕೊಡಿ.
Though, my lords, I have filed suit for permanent injunction. Now it has converted into a declaration. Now it is pending, my lords. Till today, I am in possession.
Possession ಗೆ ಅವರು, if it is found that alternative prayer is now only for possession, and even
that,
the 12 years period is also over.
One ನಿಮಿಷ sir. Dismissal of the suit is now set aside.
Yes, my lords. And very similar issue, my lords, civil lordship judgment in Shivaswamy's report.
ಕೊಡಿ.
And even, my lords, on page number 130, on the day of the alleged fixing the board, on that day, my lords, I was in Dubai.
Dubai?
Yes, my lords. I'm in Dubai. I'm working there only.
Oh.
And
Only,
I have
no,
arrived
this
in India
complaint
on
was given
15th
against
April.
the power of attorney holder of the person. And now the power of attorney is changed, somebody else has taken. And the person who claims the site is not in the scene at all. Whether they are claiming under with the proper the power of attorney is also not known. The earlier power of attorney is known. Now an ordinary power of attorney is produced before this honorable court. On the other hand, my learned friend says that he is in Dubai, and the power of attorney is executed in Bangalore.
ಅಷ್ಟೇನಾ?
22 ನಲ್ಲಿರೋ ದುಬೈ 23 ಲಲ್ಲ.
ಆಯ್ತು, ಇಲ್ಲೇ ಇದಾರೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ದುಬೈ ಹಾಕ್ಬೇಕು.
That's their allegation at page number 25. On 22/2/2023, some person has displayed the board.
NTA Housing Society.
NTA Housing Society. I am the original allotee, my lords.
ನಿಮ್ದೆಲ್ಲ ಹೋಗಿದ್ಯಲ್ಲ, ಇನ್ನೇನ್ ಬಂತು? ಅಲಾಟಿ ಆಫ್ ದ ಸೈಟ್.
Yes, my lords.
ಇವ್ರೇನು?
They are subsequent purchaser.
No.
At page number 27.
From whom?
From the another person, my lords. At page number 27.
Site number 629 ಯಾರ್ದು?
It is mine, my lords. At this page number 27. Page number 27 is the original allotment letter. And my lords, at page number 28 is the absolute sale deed.
ಒಂದು ನಿಮಿಷ. Absolute sale deed by the housing society.
Page number 38, possession certificate. Remaining documents, my lord.
ಇವರು ಯಾರು?
My site is 29, my lord. It is not in the layout, adjacent to the layout.
ಆಚೆ ಇದ್ದೀರಾ?
ಹೌದು, ಅದರಲ್ಲಿ ಈಗ ಅವರು ಕೇಳ್ತಾ ಇರೋದು, ಅವರು 629 ಐಡೆಂಟಿಫೈ ಮಾಡಲಿಲ್ಲ. ಈವನ್ ಸರ್ವೇಯರ್ said that he failed to identify that site. And 629, for that matter, my lord, it is not released till today.
That's all right.
And BDA filed a suit.
You are not the adjacent owner.
Pardon?
You are not the adjacent site owner.
I am the assistant site owner, 629.
You said you are outside.
No, this, my site is outside the layout.
Outside the layout?
Yes.
This is inside the layout.
He claims inside the layout. But that, when the surveyor went, he failed to identify that site at all there. And moreover, 629.
You can identify your site.
Yes.
Where is it?
It is in survey number 17/3. And that report also submitted, a BDLR report submitted.
Anything else?
And more than that, my lord.
If I observe something, your civil suit also will go.
629 site is concerned, the BDA has not released, they filed a suit against the society.
No problems.
Under.
The petitioner is before this court calling in question the proceedings in crime or CCNA?
Crime, my lord.
Registration of a crime in crime number 44 of 2023 registered for offence punishable under section 447 of the IPC. Heard so and so. The facts enumerated are as follows. The petitioner is said to be an allottee from the hands of NTI Housing Society of a particular site site number 629. The petitioner claimed to be in possession of the said property. Owing to certain disturbance from the hands of this present respondent, the defendant therein, the petitioner institutes a suit in OS.
Yes, my lord. OS number 4586 of 2012.
4586 of 2012, seeking permanent injunction against the defendant. It comes to be dismissed. The dismissal of which is called in question.
In RFA number.
Called in question in RFA 1368 of 2021. The coordinate bench of this court sets aside the dismissal of the suit seeking permanent injunction and remits the matter back to the concerned court for consideration afresh in accordance with law. In the interregnum, i.e. between the date of dismissal of the suit and the allowing of the petition by the coordinate bench, emerges this subject incident. On an incident that happens on 25,
On 22/3, my lord.
on 22/2/2023, a crime comes to be registered 3 days later on 25/2/2023 for offence punishable under section 447 read with 34 of the IPC. The registration of the crime is what has driven the petitioner to this court in the subject petition. This court, owing to the fact that prima facie, owing to the fact that the petitioner was in possession of the property, grants an interim order of stay of further investigation in the matter. The matter is thus heard. The learned counsel Sunil Kumar, appearing for the petitioner, would take this court through the documents appended to the petition to demonstrate that he is the lawful owner of a particular site, i.e. 629, it having been allotted by the NTI Housing Society. He is in possession of the property. The suit was erroneously dismissed and the dismissal is now set aside by the coordinate bench and the matter is at large before the competent civil court, yet again. He would submit that the petitioner cannot be hauled, hauled for offences under section 447 of the IPC for 447 of the IPC, which deals with criminal trespass of his own property. Per contra, the learned counsel appearing for the respondent complainant submits that the petitioner had lost the suit. He has no valid documents to show that he is in possession of the property. The property belongs to the complainant. Therefore, it is a matter of trial or investigation in the least that the police have to conduct for a criminal trespass. The learned additional SPP, B.N. Jagdish, should toe the lines of the counsel appearing for the respondent complainant in contending and contending that the investigation must be permitted in the case at hand. I have given my so and so, so and so. The afore narrated facts, dates and link in the chain of events are all a matter of record. The petitioner purchases the property from the hands of NTI Housing Society, who were in possession of the layout. The sale deed is executed on 5/11/2011 in favor of the petitioner by the society. The sale deed is appended to the petition. Possession certificate is also appended to the petition. All other contemporaneous documents which would prima facie demonstrate that the petitioner is the owner of the property are also appended to the petition. The second respondent complainant has a site not inside the layout but outside the layout, but claims to be an adjacent owner and is also in allotment of a site in 629 of 620. It's allotment of a site not 629 but 29 in the layout. The disturbance emerges.
Not in the layout, my lord. It is in the adjacent to.
Adjacent, not in the layout, outside the layout. What is missing is 6 such. This the disturbance emerges from the second respondent complainant. Therefore, the suit in OS so and so seeking mandatory injunction. The suit comes to be dismissed, dismissal of which is challenged before the coordinate bench. The coordinate bench, by the following order, allows the RFA regular first appeal and remits the matter back by the following order. Therefore, there is no order against the petitioner that he is not in possession of the property as on today. The coordinate bench clearly holds that the concerned civil court was in error in not looking into the documents and rejecting the said suit. Be that as it may, the petitioner has produced such documents that would prima facie demonstrate that he is in possession of the property. On a particular day, i.e. 22/2/2023, it is said that the petitioner has trespassed into a site bearing number 629. The complaint then emerges from the respondent complainant who has site 29 outside the layout. The complaint reads as follows. The gist of the complaint, certain paragraphs of the complaint reads as follows, page 24-25. This becomes a crime in crime number 44 of 2023 for offences punishable under section 447 of the IPC. Section 447 of the IPC reads as follows. Section 447 deals with criminal trespass. The ingredients of section 447 are found in 441 of the IPC. 441 reads as follows. Section 441 mandates that an accused can be alleged of criminal trespass if he is not in possession of the property. The documents produced herein would prima facie demonstrate that the petitioner is in possession of the property. Therefore, it cannot be that the petitioner has criminally trespassed into his own property. Therefore, the registration of the crime itself is on the face of it erroneous.
One submission, man. The suit, this appeal has been remanded back to on the basis of an application for amendment for possession.
There is no suit today. There is no decree that is against him today, sir. We will correct it.
No, what I want to impress upon the court is
I am not impressed.
Allah, this is amendment is sought for the possession only.
No problems. Anyway, civil suit alladre nodkondi. This court, considering identical circumstance, has held as follows. Para 8 to end. In that light, the registration of the crime, prima facie, registration of the crime is an abuse of the process of the law, which, if permitted to be investigated into even, would result in miscarriage of justice. For the aforesaid reason, allowed, quashed, it is made clear, the findings rendered so and so will not civil court, civil suit. Ordered according, next.
Much.
4.
ನಿಮ್ದೇನಾ ಅಲ್ವಾ? ಅದೇ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರಲ್ಲ ರಾಧಾಕೃಷ್ಣ. ನಿಮ್ದೇ ಸರ್, ಬನ್ನಿ.
ಈ ಕಡೆ
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ವಾ?
ಇಲ್ಲ, ನಾನು ತಪ್ಪು ತೋರಿಸಿದಾರಲ್ಲ ಅದರಲ್ಲಿ.
ನೀವು ಪೆಟಿಷನರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ತೋರಿಸ್ಬಿಟ್ಟಿದಾರಾ?
ಹೌದು ಸರ್. I represent Mr. Hariprasad, who is representing the. He has also given objection appear along with me. ಅದು oversight ಆಗಿ ತೋರಿಸಿದ್ದಾರೆ ಅಷ್ಟೇ. But here is this is a case where you may kindly observe. Petitioners are land developers. They have developed land property in Hunsur Taluk. Respondent number 2 applied for 6 sites. In all, they have paid a sum of rupees.
ಈಗ ಕೇಳ್ಬಿಟ್ರೆ ನೀವೇ ರೆಸ್ಪಾಂಡೆಂಟ್, ನೀವೇ ಪೆಟಿಷನರ್ ಆಗಿದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್
ತಪ್ಪಾಗಿದೆ.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ?
ನಾನು ಪೆಟಿಷನರ್ ಸರ್.
ಫಸ್ಟ್ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಸರ್. ಅದೇ in the meantime, because of litigations, he could not able to allot the sites. In the meantime, he has filed an application, suit, this what is called complaint before the first respondent police. They have registered the case. They could not able to take action. Then he has filed a private complaint. Learned magistrate took cognizance and they registered case. What has happened is that subsequent to registration of the case, the petitioners appeared before the court. Matter has been referred to Lok Adalat. Before the Lok Adalat, they have settled the issue. Let's may kindly turn to this.
ಆಯ್ತು, ಈಗ ಏನ್ ಸ್ಟೇ ಮಾಡ್ಬೇಕಲ್ವಾ?
ಸ್ಟೇ ಮಾಡಿ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು ಸರ್ ಅವ್ರಿಗೆ.
ಕೊಡೋಣ, ನೋಟಿಸ್
ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ರೆ ವರ್ಡ್ ಮ್ಯಾಟ್ರು will matter has been we have paid 30.
They heard the learned counsel Radhakrishna, A.N. Radhakrishna appearing for the petitioner. The registry is directed to correctly show the name of the counsel as appearing for the petitioner and not the respondent. The petitioner submits that the complainant has settled the dispute before the Lok Adalat. Even otherwise, what is projected in the case at hand is a purely civil dispute rendering a cloak of crime, which cannot be permitted in the light of plethora of judgments of the apex court, which clearly hold that civil cases which are rendered a color of crime should not be permitted. The apex court in Inderchand Bagri 2025 SSC online SC page 2529 has elucidated the said principle. In that light, there shall be an interim order of stay of all further proceedings in so and so till the next date of hearing. Emergent notice to the second respondent, one additional SPP, 2 emergent notice returnable by Yavatbek.
I may be permitted to serve, take out notice to respondent advocate also before the
criminal case.
He himself is the advocate. R2 himself is an advocate.
Sorry, the petitioner is also permitted to serve on the counsel, serve on the second respondent by way of hand summons.
Please, any date you let us please.
We'll take it on 6th February.
Oh, bless.
List on 6th. 23 da? ಹಾಗಾದ್ರೆ 3rd February.
Please.
5.
It's under section 504, 506, 295A. Connected matter, elevate report ಹೇಳಿದೆ. Connected matter. Last time notice.
ಗಣಪತಿ ಯಾರಿಗೆ?
I for respondent number complaint.
ನೀವಾ? ಯಾರ ಕಂಪ್ಲೇಂಟ್?
ಅಲ್ಲ, A1 ಫಸ್ಟ್ ಸ್ಟೇ ಆಗಿತ್ತು, ನೆಕ್ಸ್ಟ್ A2 ಸ್ಟೇ ಆಯ್ತು.
ಏನ್ ಪ್ರಾಬ್ಲಮ್?
He destroyed the temple and other stones.
Destroyed the temple?
ಇಲ್ಲ.
ಅಯ್ಯೋ, ಶ್ರೀಮತಿ ಸುಜಾತ ಅವರು ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಿದ್ರು.
She is the landowner.
ಆಮೇಲೆ
He is claiming, but the temple situated beside their temples, he is trying to grab the Kharab land. That is, she is only maintaining.
ನೀವ್ ಯಾರು?
I am public.
Public.
It is the ancient temple recognized by the Archaeological Survey of India. She is trying to,
Ancient temple, modern public. No permission under 196.
Page 30, lordship may remand it back. We'll get a
Remand
sanction.
ಯಾಕೆ?
I'll get a sanction and I'll sanction ತಗೊಂಡಿದ್ದಾರೆ.
ಹಾ,
From a wrong person.
196 sanction ಇಲ್ವಲ್ಲ?
From a wrong person.
sanction DC ಇಂದ ತಗೊಂಡಿದ್ದಾರೆ.
Yes.
ಅದೊಂದು ಸ್ವಲ್ಪ type
Close
ಮಾಡಿ.
it, please. The petitioner, if sanction is needed, then you can revive, yes. The petitioner is, ಆಮೇಲೆ ಬನ್ನಿ ಮತ್ತೆ, ತೊಂದರೆ ಇಲ್ಲ. The petitioner is before this court seeking the following prayer. The,
830 cognizance out ಒಂದು ಸ್ವಲ್ಪ
ಅದು ಕೋಟ್ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲಿಂದ blank.
A complaint comes to be registered on 27/12/2022, alleging that the petitioner has destroyed pillars of a temple.
Side,
or
correction
side,
ಮಾಡುವಾಗ ಇದಾಗಿದೆ, ಟಚ್ ಆಗಿದೆ.
has destroyed, or a crack is seen in the
Temple ಏನಿಲ್ಲ,
temple.
photographs ಇದೆ, ಕ್ಲಿಯರ್ ಇದೆ.
Crack is seen in the pillar of a temple. The complainant is a passerby or ಅದೇ ಊರಲ್ಲಿರೋ.
Public resident. ಪೂರ್ಣವನು ಅಲ್ಲ, ಅಲ್ಲೆಲ್ಲ ಅದು ಇವರನ್ನು ಡಿಸ್ಪೋಸಸ್
The complainant is said to be a passerby or a resident of the village, registers a complaint against the petitioner. The complaint then becomes a crime in crime number 234 of 2022 for offence punishable under 504, 506, 295A, read with 34 of the IPC.
Submission. He is from Gundlupet.
ಇದು ಎಲ್ಲಿರೋದು?
ಇದು ಇದು ಪಾಂಡವಪುರ ತಾಲೂಕು.
ಪಾಂಡವಪುರ. ಅಲ್ಲೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅಲ್ಲ,
ಗುಂಡ್ಲುಪೇಟೆಯಿಂದ ನೋಡಿದ್ರ ಪಾಂಡವಪುರಕ್ಕೆ?
ಕಂಪ್ಲೇಂಟ್ ಹೋಗಲ್ಲ ಎವ್ರಿ.
ಡ್ರೋನ್ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ರು, ಡ್ರೋನ್ ಸರ್ವೆ ಮಾಡ್ತಾ ಇದ್ರ?
ಅಲ್ಲ, ಇವ್ರುನು ಗುಂಡ್ಲುಪೇಟೆನೆ.
ಹೌದು, ಕಂಪ್ಲೇಂಟ್ ಗುಂಡ್ಲುಪೇಟೆ.
ಕಂಪ್ಲೇಂಟ್ ಗುಂಡ್ಲುಪೇಟು.
ಏನ್
ಅದು ಟೆಂಪಲ್ ಇರೋದು ಪಾಂಡವಪುರ.
ಗುಂಡ್ಲುಪೇಟೆ ಪಕ್ಕನೆ. ಪಕ್ಕ
ಪಾಂಡವಪುರಲ್ಲಿ ಗುಂಡ್ಲುಪೇಟೆಯಲ್ಲಿ
ಅಲ್ಲ ಅಲ್ಲ, ಚಾಮರಾಜನಗರ. ಇದು ನಾಟ್ ಪಾಂಡವಪುರ ಆಫ್ ಮಂಡ್ಯ.
ಓ, ಅದು ಬೇರೆ ಇದೆಯಾ? ಮಂಡ್ಯದಲ್ವಾ?
ಅಲ್ಲ,
ಸರಿ, ಆಯ್ತು. ಎಸ್, so sorry, IPC, yes. The registration, charge sheet ಹಾಕ್ಬಿಟ್ರಾ? The police after investigation file a charge sheet. On the charge sheet, cognizance is taken by the learned magistrate for the aforesaid offences. The taking of cognizance has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would submit that for an offence under section 295A, the sanction as necessary under 196 of the CRPC is imperative, without which the concerned court could not have taken cognizance of the offence, and therefore would submit that the proceedings be quashed apart from the fact that the order of taking of cognizance does not even bear even a semblance of application of mind. The learned counsel appearing for the complainant, Ganapati, yes, would vehemently refute the submission in contending that it is a matter of trial and the plea of sanction can be projected before the court at any point in time. Therefore seeks dismissal of the petition. The learned additional SPP would admit the fact that sanction is obtained under section 196 CRPC, but not from the competent authority. Therefore, liberty should be reserved that if sanction is obtained from the hands of the competent authority to continue the proceedings. I have given my anxious consideration soon. The four narrated facts are a matter of record. The registration of the crime triggers registration of complaint triggers the registration of the crime. I therefore deem it appropriate to notice the complaint. The complaint reads as follows, page 22. On the complaint, police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows.
Page 43.
Page 43.
ನಾಗರಿಕರ ವೀರಕಲ್ಲು ಹಾಗೂ ಇತರೆ ದೇವಮೂರ್ತಿಗಳನ್ನು ತೆಗೆದು ಭಗ್ನಗೊಳಿಸಿರುತ್ತಾರೆ.
ಆಯ್ತು. On the said page 43 mark ಮಾಡಿದೆ. The concerned court takes cognizance of the offence by the following order. Page
30.
Yes, ಯಾವ page?
ಇಲ್ಲ ಇದು ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಕಾಪಿ.
Page 30.
29 ಇದೆ, 30.
Page 13.
30.
30.
ಏನಿದೆ ಇದರಲ್ಲಿ ಏನಿಲ್ವಲ್ಲ? The concerned court takes cognizance of the offence by the following order. The a perusal at the order of the concerned court indicates blatant non-application of mind, as it does not bear even semblance of reasons for taking cognizance of the offence. It is time and again indicated by this court that the orders of the learned magistrate or the concerned court must bear reasons while taking cognizance. But the orders of cognizance by the learned magistrates are taken in the aforesaid manner as if it is a frolicsome act on the part of the court, while it is not. It is a serious matter of taking cognizance and issuing summons. Be that as it may, the issue now would revolve around whether there is sanction under section 196 CRPC or otherwise. Section 196 CRPC reads as follows. For an offence under section 295A, the sanction under 196 CRPC is imperative, is by now too well settled a principle of law. Right from the too well settled principle of law in the light of the following judgments. In that light, the petition deserves to succeed with the order of cognizance being set at naught. For the aforesaid reasons, the following order. The order taking cognizance of the offence as it is taken without at the outset sanction being placed before the court as obtaining under section 196 stands obliterated. It is open to the state to place the order of sanction before the concerned court, and the concerned court, in the event sanction is placed, to regulate its procedure thereafter. In the event there is no sanction, there are no proceedings before the concerned court. Ordered accordingly. Liberty is reserved to the petitioner to avail of such remedy as is available in law in the event of need in future. Please. Both.
Seal number 6.
My lord, 306 and 498 AM.
A3.
My lord, A3 and A4, my lord.
A4 ಎಲ್ಲಿದ್ರಿ ನೀವು?
My lord, ಬೇರೆ ಮನೆ, my lord.
ಬೇರೆ ಮನೆ?
Yes, my lord.
ಬೇರೆ ಮನೆಯಿಂದಾನೆ ಟಾರ್ಚರ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
No, my lord. Accused number 2 ಬಂದು and accused number 1 had illicit relationship, my lord.
Accused number 2 and accused number 1.
Yes.
ಅದನ್ನ ಯಾಕೆ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ನೀವು?
Lord, ನಾವೇನ್ ಫೋನ್ ಮಾಡಿಲ್ಲ.
ಅದನ್ನೇ ಅಲಿಗೇಷನ್ ನಿಮ್ಮ ಮೇಲೆ ಇರುತ್ತೆ.
Accused number 2 is not before this court, my lord. 3 and 4, my lord.
ಇದು ಗೊತ್ತು ಸರ್. Who has told the victim?
Accused number 2, my lord.
ಅವ್ರು ಹೇಳಿದ?
ಅವರೇ ಫೋಟೋ ಕಳಿಸಿರೋದು.
ಫೋಟೋ ಕಳಿಸ್ಬಿಟ್ರ?
Yes, my lord.
Discharge application pending is. Application is.
That does not tie this hands of this court anyway, but A3 and A4 ಮೇಲೆ ಏನಿಲ್ಲ. ಅದು 306 498 ಅಂತೂ ಏನೂ ಇಲ್ಲ. ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಮೇಡಮ್ ಯಾವ್ದು ಸರ್ವ್? await ಹಂಗಾರೆ await ಸ್ಟೇ ಇಲ್ವಾ?
ಇಲ್ಲ ಮೇಡಮ್.
The petitioner is before this court. Petitioners are accused 3 and 4 who are at the doors of this court calling in question registration of crime CC na.
Charge sheet.
Calling in question proceedings in CC so and so registered for offence punishable under section 306 and 498A of the IPC. The petitioners are accused, as observed, petitioners are accused 3 and 4. A telephone call to the victim, to the daughter of the complainant, leads the daughter of the complainant to daughter ayano. Complainant yaru?
Complainant is the mother, my lord. Mother of deceased, my lord.
Ade tane helidna.
Yes.
Leads the daughter of the complainant to commit suicide. The call was regarding sharing of a photograph of alleged illicit relationship of accused number 1 with
accused number 2, my lord.
Accused number 1 with accused number 2. The photograph is said to have been sent by accused number 2 to the mobile of the daughter of the complainant. The petitioners admittedly did reside elsewhere and did not have anything to do with the abetment, goading or coaxing the victim, coaxing the daughter of the complainant to commit suicide. In that light, further proceedings, if permitted to continue, would prima facie become an abuse of the process of the law and result in process of the law and run foul of the judgment of the apex court in the case of so and so 2025 SCC online SC page 1938. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner accused number 3 and 4, petitioners accused number 3 and 4 till the next date of hearing, post immediately after service of notice upon the respondent. Next, yes.
7.
Here for the respondent. We'll file our objection.
ಯಾವ್ದಕ್ಕೆ?
This is
Lordship,
the
in 7.3.
engineered case. SBI, fake SBI website has been opened.
Correct, correct, yes.
Convinced
You are
the-
appearing in which matter, madam?
In, for accused number 3, who is the wife,
No, no, all right. Accused number 3, which petition?
in
There are 4
7.3.
petitions.
7.2.
7.1,
7.2
your
is,
Lordship. 7.1 is the accused number 2 wife.
Seba Jeevan.
Please.
Ada?
Yeah, for that.
Sylvia.
7.3.
7.3 is Vinay Kumar, sorry, Srimati
Sylvia,
Selmia.
please.
Then who appears in, yes, Vidyashri? Ready? Start. Senior counsel is there, yes. Yes, madam.
Please. Your Lordship, page 97.
Hmm.
Lordship is the FIR.
Madam, aap it kodi. 7.3 kodi.
7032 petition number. Your Lordship.
Yes, yes. That's 7.3, right? 7.3. Hmm.
7032, 7.1. In cause list, it shows 7.1, but it was actually 7.3. So the
No, no, anyway.
petition number is
Criminal petition
7032.
7032 kodi.
Please.
Yes, madam.
Your Lordship, page 97, Your Lordship.
Your accused number?
Accused number 2, who's the wife. Your Lordship may kindly see the complaint which is at page 101. The allegations as against the wife can be seen at the last paragraph. Lordship has page 101. During the same month, Vinay Agarwal arranged a meeting with Niaz at Shangri-La, Vasant Nagar, offered to get 225 crore loan in the month of October so-and-so. So-and-so asked me to come to Chennai to meet in State Bank of India officials and went to Park Hyatt Hotel in Chennai, where Niaz and his wife, Silmia. Your Lordship, this is the only place where they say that I was part of all these other 3 men who met up with the complainant. All of them promised to get a loan of 225 crores. In the next page, Your Lordship may kindly see, they say they demanded me to pay 7% as commission. The next paragraph, again, the last line, it says, Muzib Abdul Mian and Silmia, Vinay Agarwal, Krishnamurthy, Balaji, all of them. Here her name is there. Your Lordship, where they try to bring in a twist is the last.
It's the
but
same
one.
complaint in all these cases?
Please, Your Lordship, but where this lady comes in, ultimately, Your Lordship, this is a highly conservative family. She's a housewife. She's clueless about any of these transactions. Reason this lady is brought in is, he is an accused in another CBI matter where he's convicted.
Who?
Accused number 1.
A1. Since he's convicted.
Wife of A1.
Wife of A1. Since he's convicted and they realize that they cannot probably get anything back from him, they bring in this lady by filing this fresh FIR. Now to get the jurisdiction, Lordship may kindly see page 103. At 103, last but one paragraph, Your Lordship. By these affairs, it's clear so-and-so had the intention to cheat me since the beginning. Thus, all of them have conspired to cheat. This is the portion. When I was in Chandra Layout Bus Depot in Bangalore, I telephoned Silmia to find out the whereabouts of Niaz. She abused me and told me that since I am vehemently pursuing the matter, they have decided to eliminate me. Now, Chandra Layout Bus Depot he seems to be in. The reason he simply says this is, he wants jurisdiction of Chandra Layout Police Station since the inspector is Hatti over there and he wants this registered with somebody he knows. So conveniently, he was in Chandra Layout Bus Depot.
Yes.
This is the only allegation. Now, if your Lordship turns to the preliminary charge sheet, which is at page 119.
Paragraph 13 is against you in the charge sheet.
Please, Your Lordship. In paragraph 13, Your Lordship, I will That is in fact critical where there would be no case. Your lordship, he says that I have purchased two properties. Now one property which is about 35 lakhs, one property which is 40 lakhs. One is a 50-60 site, one is the other apartment. Your lordship, both of this was purchased in 2012 and 2013. Whereas this entire issue arose in 2017. He claims that he met them and paid them the money in 2017.
There's
So
an interim order, is it?
there is an interim order. Your lordship, therefore, the small amounts of apartments that we have purchased with her parents' amount in 2012 and 13, how can that be an amount that I have purchased subsequent to these people purchased? So that para 13 itself goes.
So that
They don't mention
they
the
have
date.
nothing to do with this, is your submission.
Absolutely nothing to do, your lordship. And this, both the details of the purchases that they make, if they had just put the date of the sale deed, it would reveal everything. But they've conveniently brought this in. Reason being a CBI case of conviction against A1, in which he is right now in 7 years in jail. They realize in 2020 post conviction, they cannot get anything out of him. So the idea is to bring in the wife and file this in 2022 of a complaint that he claims in 2017. Next is 3 cash payments that he's claiming. All 3 there is no proof of. And for that, he would have to pursue as against the 3 or 4 men that he claims to bring in this ladies to only put in pressure, your lordship. There is absolutely nothing else as against her.
Others?
Please.
So this is A3.
A2.
Sorry. A2. Yes, Pratik, whom are you representing?
With regard to A4, my lord.
Your 55539 is A4.
5539. In addition to the points that senior counsel mentioned, my lord, here the allegations are all omnibus. There is no specific allegation with regard to A4.
Oh.
The primary grievance, my lord, is that 7 crores has been paid. In the charge sheet does not reflect any bank statement. There's no withdrawals or anything to show that.
A4 and A5, paragraph 14.
Please. A4 and A5.
Page 38, 39.
Please. In that, they mentioned what they have seized, and again, all the cash payments that they've referred to. There have been no proof of receipt of any of these cash payments. There's no, he's claiming to have made 95 lakhs as payment through bank transfer, but that has been made to A1.
The Volvo, BMW, Benz,
These are businessmen who have been in Chennai for 20 plus years. They're not new to this transaction.
In this business?
No, not businessmen. 2018 only they claimed to have made cash payments, but in 2022 they have filed this complaint. If they have lost the 7 crores that they've alleged, for 4 years they have not approached any forum. As senior counsel mentioned, with regard to A1, because the CBI case is pending, they have dragged in all of the other accused.
So A4 right. Now, who is this? 9272? No adjournment, no passover. Yes.
We already heard last time.
All right.
Senior counsel. A3. That's A3.
This is A3, right?
Yes.
So A2, A3, is 7416.
That is A5.
Who is that? Yes, madam.
My lord, in this, the A5 is a citizen of Germany.
Germany?
Yes.
Yes.
He wasn't there in the Bangalore when all these things took place. He was
They're
there.
in Bangalore.
No, he was in Germany. He's a citizen of Germany. Germany, my lord.
German citizen, na?
Yes, my lord.
Sri Lankan virgin.
His family is based of Sri Lanka. He is in
ನಮ್ಮ
Germany.
ದೇಶಕ್ಕೆ ಸಂಬಂಧನೇ ಇಲ್ವಾ?
ಇಲ್ಲ.
So he is a director
married to
of.
Britain lead.
ಅಂದ್ರೆ ಯಾವ ಸಂಬಂಧನೇ ಇಲ್ಲ.
He is a director of a pharma company.
ಅದಕ್ಕೆ ಬೆನ್ಸ್ BMW ಎಲ್ಲ ಇದೆ. ಜರ್ಮನ್.
My lord, through a common friend, through a common friend, he got to know about the petitioner and the A1. Then this A1 borrowed 3.9 crores from us, the accused one. So that's when we came to Bangalore to collect that money. Then without our knowledge, without giving any intimation, we were being arrested. We had nothing to do with this case.
You, where were you arrested?
In the Bangalore Kempegowda International Airport.
Oh, from the airport you were taken.
From the
You're out on bail.
Yes, my lord, we are out on bail.
Yes, sir.
Sir, we'll file
4 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ? 2017 ಅಲ್ಲಿ if you have lost money, 2022 ವರೆಗೂ what were you doing?
There was a delay, my lord. It
There was a delay, 5 years delay.
It was reasonable, my
I'll
lord,
come
because
to you.
all these petition, the accused number 5 was a citizen of England, and we were not about to track the fake email IP addresses.
ಆಮೇಲೆ ಅದೇ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಡಿಲೇಗೆ
No, my lord.
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತಾ ಇದ್ದೀರಾ?
We'll file our objection.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದ ಟೈಮ್. ಐ ವಿಲ್ ನಾಟ್ ಗ್ರಾಂಟ್ ಟೈಮ್ ಲೈಕ್ ದಿಸ್. ಎಸ್.
Pass over.
No pass over also. Yes.
One submission, senior counsel made a statement with respect to accused number 2.
Wife.
That she is a
innocent lady.
No, not innocent.
ಏನ್ ಹೇಳಿದ್ರು?
ರಿಲಿಜಿಯಸ್ ಸೆಂಟಿಮೆಂಟಲ್ ಅವರ ಮನೆಯಿಂದ ಹೊರಗಡೆನೆ ಬರಲ್ಲ ಅಂತ.
ಆತರ
specific word senior counsel, I missed it, my lord.
No. If he's missed it, then he has missed it, because I didn't say she doesn't come out of home. I said this is from a conservative family.
Conservative family. I stand correct.
And if I have to even proceed further, it is even with
case of
respect to
mistaken identity.
their clothing, all of that, it is very clear that these are not people who are going to be in a park hotel with 4 other men dealing all of this.
I understand.
Yes.
Now, may I request, my lord?
Conservative.
Yes, my lord. Para 13, your lordship has seen it.
Yes, I have seen.
First 4 lines of the para 34 will speak how conservative.
Para 13.
13. Sponsor ಅವರು ಮೂಲತಃ
ಶ್ರೀಧರ್ ಎಂಬುವನು ವಿವಾಹ ಮಾಡಿಕೊಂಡಿದ್ದರು. ಶ್ರೀಧರ್ ಅಂತನಾ?
ಹೌದು. ಅವರ ಹೆಸರು ಬೇರೆ. ಆಮೇಲೆ ಇಲ್ಲಿಗೆ ಬಂದಿರೋದು.
2 ವಾಸವಾಗಿರುತ್ತೆ, ಬಾಲ್ಯದಿಂದಲೂ ಪರಿಚಯ ಇಲ್ಲ. ಎಷ್ಟು ಸರಿ ವಿವಾಹ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ? Irli, that's not the issue here.
So that is the conservative family we are talking about, Mela. The investigation against her could not be completed. Anticipatory bail was obtained. She was not cooperating with the investigation. No, then we move for a cancellation. Anticipatory bail was cancelled. Subsequent to cancellation of anticipatory bail, they obtained a stay in this case. The property they're talking about, this 2 property, doesn't mean that there are multiple properties where the accused number 1 used accused number 2 and accused number 1 and 2 are together doing all these things.
But he is in custody.
He is in jail. Similar identity, similar modus of operandi.
He is in custody since when?
Convicted in Mumbai.
2020. Oh, ಇದು ಮುಂಚೆ ಆಗಿರೋದು.
ಹೌದು. Convicted in Mumbai. Similar identity of a different kind of scam.
So this is fake website of SBI.
Fake website of website. Lordship may see. I also got confused saying that they send a OTP.
Oh.
Account, you can log into your website. You can open your account. OTP will come to you. Log into OTP. It will show you that you received money. And thereafter, they've taken 7+ crore rupees to their account. And the accused number 5, my lord, is accused number. Accused number 5, my lord, is the person who developed this website.
Oh, Germany.
Sri Lankan version, living in Germany, married to London lady. And all these things was done at his instance. And accused number 3, my lord, receives 50 lakh rupees cash in his shop. Then when he wanted to, the complainant wanted to withdraw money, money was not coming. Thereafter he says that no, don't worry, there is some issue with the bank account, it will be rectified. And I'll give you ICICI Bank debit DD. And ICICI Bank DD was forwarded to complainant by the accused number 3 through WhatsApp. And that DD is also fake. So similarly, my lord, accused number 4 also, accused number 4 behaves as a bank employee, as a SBI bank employee, and he goes as a bank employee and convinces the complainant saying that I'm a bank employee. The
total ಎಷ್ಟು transaction ಆಗಿದೆ ಇದರಲ್ಲಿ?
7.5 crore rupees has been received.
For a deal of 225 crores.
225 crores loan.
225 crores loan ಕೊಡಿಸ್ತೀರಾ? ನಿಮಗೆ ಯಾಕೆ ಬೇಕಾಗಿತ್ತು ಅಷ್ಟೊಂದು?
I wanted to establish a sugar factory.
How many sugar factories?
3.
3 sugar factories. ಎಲ್ಲಿ?
ಗದಗಲ್ಲಿ. 7.5 crores. How did he get it? No trail. Entire cash transaction. 5 years later, suddenly the police is very interested.
Website which they've created and the emails which are forwarded, ಅದರಲ್ಲಿ OTP ಬಂದಿರೋದು ಎಲ್ಲದನ್ನು. That now the instead of the website name is just IN has been added. .co .in is the website. Everything is SBI.
ಯಾರ ಅಕೌಂಟ್ ದುಡ್ಡು ಹೋಗಿದೆ?
To all these people.
Of the accused, ಯಾರ ಅಕೌಂಟ್ ಹೋಗಿದೆ?
A6 and A7 receives the money. A5 receives 5 lakh rupees cash in the shop, in his shop. So A6, A7 money has gone to their account. Subsequently, ultimately money has come to this.
2, 3 and 4?
2, 3 and 4, 2 is wife, my lord. She has a major role to play in this entire episode.
All right, but money has not gone to the account.
Money is gone. After them, the money has gone to her also.
That is by cash or by?
By cash. That
cash.
has to be a subsequent.
ಎಲ್ಲ cash transaction ಏನ?
95 lakh rupees online transaction. That has gone to 95 lakhs, A6 and A7.
Might I just pass on the sale deeds, which will then.
Property.
Property. This
even
is what
nothing in
they're
the-
referring. Para 13, this is what they say. Now to cover that up, he says there are many more. How come we don't find that? And then he says the lady doesn't cooperate in the investigation. This lady is made to sit.
Tamil alida?
Translated is also
Tamil.
along with that. Lordship, from morning to evening, she's made to sit entire day without a single line of questioning. At any point of time, your Lordship says we'll be present, but nothing. They just ask her to sit morning to evening. Idea is to pressurize her so that the man from within the jail directs somebody at least to come up with the amount. Your Lordship, this is a lady who was in fact
Why, if
converted.
I'm not, none of the accused have received anything, why, where is the question
They
of
have not received anything.
No, where is the question of repayment? Why should you be pressurized?
No. They are attempting that. If they keep the wife here and trouble her throughout in the police station, maybe the man from within inside will probably ask somebody to pay so that they.
What payment? You have not received any amount, what payment?
Their idea is that if the wife is troubled, maybe some money will come out. This is their intention. And now from morning to evening, she's made to sit. No questioning, absolutely. They have no material against her. The properties that they say are all purchased in 2012 and 2013. 2017, he claimed 7.5 crores paid in cash. The amount that is transferred is only 2 lakhs or whatever to those other people. 5 years later, all of a sudden they want to come. They want to get Vijayanagar Chandra layout jurisdiction. So he's supposedly in a bus depot. Just so that he says that he has called me and I have threatened. Now, if he wants to also, my good friend Mr. Jagdish wants to again cast aspersions against on the lady stating that supposedly from conservative but isn't. Your Lordship, she is in fact converted, a Hindu converted to Islam.
That's all right. Why
No,
do you get religious
he
overtones
brought this
here?
up and therefore I'm saying.
All right.
Your Lordship, now this
That's
lady.
besides the point.
This lady has in fact, this man is always in jail. She's taking care of her 2 children
See,
and
that's
making a
all right.
living. Asked to be
No.
in the court, asked to be in the
Religious
police
overtones.
station from morning to evening for no reason. Absolutely no material except paragraph 13. Para 13, I have produced the sale deeds, Your Lordship.
This court cancelled the anticipatory bail considering that she not cooperated with
Where
investigation.
is that order?
I'll place that order. This court has cancelled anticipatory bail.
ಇದ್ರಲ್ಲಿ ಇಲ್ವಾ? ಇದರ material ಇಲ್ವಾ?
No, not cooperating, Your Lordship. Then idea of cooperation is to sit from morning to evening in a police station
ಈಗ
every single day.
charge sheet
probably.
ಹಾಕಿದಾರಲ್ಲ ಇದರಲ್ಲಿ?
Please, Your Lordship.
Charge sheet ಹಾಕಿದ್ದಾರೆ.
Charge sheet, your preliminary charge sheet is there.
Further investigation order ಮಾಡಿದಾರಾ? ಜಗದೀಶ್, further investigation order ಮಾಡಿದಾರಾ?
Pending ಇದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಪರ್ಮಿಷನ್ ತಗೊಂಡು.
ಪರ್ಮಿಷನ್ ಇದ್ದೇ ಇರುತ್ತೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ. 173(8) ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ. Because all the stays obtained in between.
ಎಲ್ಲದರಲ್ಲೂ ಸ್ಟೇ ಇದೆಯಾ?
We'll
see. Yes. Heard.
I'll place that cancellation.
Heard the learned senior counsel Srimati Lakshmi Iyengar appearing for the petitioner and counsels ellardu ಹಾಕ್ಬಿಡಿ. ಹಸ್ಮತ್ ಪಾಷಾ ಸರ್ ಹಾಕ್ಬೇಕಲ್ಲ. So and so appearing for so and the counsel with the complaint. Heard reserved. The matter subsisting in the case at hand will continue to the next till the disposal of the petition.
Great.
Yes. ಅದೊಂದು anticipated bail cancel.
Number 8.
ಮೇಡಮ್ ಅದಿಸ್ಕೊಡಿ ಪಿನ್ ಮಾಡಿ.
8 IPM. First things first, Malad.
7
A small more
note.
than that.
a small note connecting the page numbers where the demand, acceptance, all of it is.
Successful trapper.
Successful.
Let's,
Where is the demand? Yav page number ella sheet.
now that the trap is successful.
Your VA.
VA.
Village account.
Yes, I might also be successful here, Manoj, but the point is, Manoj, if your lordship were to,
Charge
I
frame
understand the
ಆಗೋಗಿದ್ಯಾ?
pleadings, Manoj. I understand.
Charge frame ಆಗೋಗಿದ್ಯಾ?
ಇಲ್ಲ, charge frame ಆಗಿದೆ. I understand, Manoj, the
Don't worry
constraint.
about the pleading, sir. Case in ಹೇಳಿ.
Manoj, there is really no ground, Manoj, that is enumerated in
Close
the.
it.
Manoj, may I make this request?
ಪರವಾಗಿಲ್ಲ, argument ಮಾಡಿ.
I'll file in a note, Manoj,
Don't
with all
worry,
the
you
grounds.
argue the matter. ಅದು ತಗೊಳ್ಳಿ. ಅದು ಬೇಕದು. Argument ಮಾಡಿ ತೊಂದ್ರೆ.
I thought I'll place it on record and then
No
make.
problem, sir. You argue.
Would
Entry
your
ಮಾಡ್ರಿ
lordship-
ಇದ್ರೆ vacate ಮಾಡ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ. Entry
There's-
ಮಾಡ್ರಿ ಇದ್ರೆ vacate
There's no interim order. The interim order is not to file charge sheet, Manoj, which was granted after the charge sheet is filed.
Then it's no interim order.
There's no interim order as such.
Trial is on. Then you take time. When do you want? 3
Malad.
weeks, 4 weeks?
Malad, I'll file it, Malad, within a day or two.
No
Malad, if may I just draw your lordship's attention to page 170, Malad. The order taking cognizance.
You forget about that, sir.
Malad,
Now, where is the
I'm taking your lordship's
demand and acceptance?
Malad, can I just draw your lordship's attention to the page number
PC Act cases
60.
cognizance and ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ, cognizance ಯಾಕೆ ಅಂದ್ರೆ, Malad, in the charge sheet, the voice recording, Malad, the material through which they establish demand, Malad, that is not filed along with the charge sheet. They say, Malad, the FSL report is still awaited. It is there. I can't produce it here. Therefore, Malad, there's really no material that the trial court could have looked into while taking cognizance, Malad.
1 minute, sir. Amount was seized from whom, sir?
Malad, amount they say, Malad, is seized
Say
from
ಅಲ್ಲ, fact ಏನ್ ಹೇಳಿ ಸರ್?
Malad, the
ಅಲ್ಲ 5,000 ನಿಮ್ ಕೈಯಿಂದ ಸಿಕ್ತಾ ಪಕ್ಕದಲ್ಲಿ ಸಿಕ್ತಾ?
ಅಲ್ಲ, ನನ್ ಕೈಲಿ ಸಿಕ್ತು
ನಿಮ್ ಕೈಲಿ ಸಿಕ್ತಾನೆ.
ಅಲ್ಲ, ಫಿನಾಫ್ಥಲಿನ್ ಟೆಸ್ಟ್ ಅದು
ಪಿಂಕ್ ಆಗ್ಲಿಲ್ವಾ?
ಅಲ್ಲ, ಅದು FSL ಹೋಗಿ ಅದ್ರದ್ದು ರಿಪೋರ್ಟ್ ಬರ್ಬೇಕು.
ಅಲ್ಲಿ ಪಿಂಕ್ ಆಯ್ತಾ ಇಲ್ವಾ?
ಅಲ್ಲಿ ಪಿಂಕ್ ಆಗಿದೆ ಅಂತ ಮಾಜರ್ ಅಲ್ಲಿ.
ಆಯ್ತು, ಎರಡು ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್. ನೆಕ್ಸ್ಟ್
ಅಲ್ಲ, both demand and acceptance. For demand, the charge sheet must prima facie say that there is demand, for which FSL report.
Why did you accept? Why did you accept?
The charge again, the
That's
conversation.
All right. See,
yes,
either the law is,
yes,
there should be demand and acceptance.
Please.
But if there is acceptance, it's a matter of trial because
yes,
it amounts
20
to
presumption. Yes, but the admitted case, Malad, unfortunately, in the trap master is that I made a request, Malad, to get the documents registered. It was for the registration of the sale deed, and that is established. Can I just produce the relevant material before your lordship? I'll extract it and make a note and file it. Your lordship may have it.
What was the work? Correction in the revenue records.
No. Malad, the allegation is that the lady, Malad, not the complainant's relative, had purchased for change of khata, against which, Malad, a case was filed in the court of the Tahsildar. Competing interests were presented before the court of the Tahsildar, which was pending. Now, Malad, they expect me to change the khata. I said that the matter is pending in the court. Please get the documents registered and the registration fee. Can I just show from the conversation, Malad? 20,000, Malad, is the registration fee. They said, how can the registration fee be 20,000? I said, Malad, the stamp duty that has to be collected is so much. Malad, the voice recording itself is unavailable, Malad, for the trial court to take cognizance. Well, that is pertaining, that is not in terms of the illegal, and that is not the case also.
Why did you take 5,000?
Malad, that 5,000 is towards the registration, Malad. Can I just point out, Malad, the fees that was to be collected and they have admitted.
Cash kotra?
Yeah, the
registration fee.
Yes, Malad.
Why did you take it in
Malad,
cash?
that is, it is shown in the order sheet, Malad. It is shown in the trap measure, Malad. The complainant, Malad, the alleged conversation is on 18/1, Malad. 2 weeks later, Malad, the registration, Malad, when they are asked to appear for registration, they say, Malad, that illegal gratification, khata is not yet changed. Malad, can I?
No, sir.
Very well.
Yes. The petitioner, you have come on record now, is it?
Yes, Malad. Yes. Malad, can I just point out the order of cognizance? Cognizance is
please,
not
sir.
taken,
Page,
Malad.
page, sir, page.
Malad, your lordship may kindly refer to page 170, Malad. Malad, 2110, Malad. That is by the CAO. he puts up everything, my lords. Per use charge sheet, cognizance of the offense. It doesn't even say cognizance is taken, my lords.
ಆಮೇಲೆ yes sir.
My lords, the charge sheet, can I just point out the charge sheet, my lords?
Yes sir.
Let's charge sheet, would your lordships come to page 60, my lords. Beginning of the charge sheet is also available, my lords, but I'm only taking.
Not necessary. Yes.
Let's last
You are the
column
sole
just
accused?
before 17, my lords.
Sole accused.
Let's
Sole
please,
accused.
Sole accused.
Yes.
ಈ ಪ್ರಕರಣದ ಪ್ರಾಯೋಗಿಕ ಪಂಚನಾಮೆ ಹಾಗೂ ಟ್ರ್ಯಾಪ್ ಪಂಚನಾಮೆ, your lordship got it, column 16,
yes.
second paragraph.
Is that?
To establish, my lords, that it was my voice and it was me who was demanded, my lords, some material have to be available in the charge sheet. They say, my lords, that charge sheet, we have not yet received it from the FSL, therefore we can't establish.
The petitioner is before this court calling in question the proceedings in special C within bracket PC 5 of 2023 arising out of crime number 1 of 2022 registered for offences punishable under section 7A of the Prevention of Corruption Act, hereinafter referred to as the Act for short. Heard so and so. Facts in brief germane are as follows. The petitioner at the relevant point in time was working as a village accountant. Elli idu?
Chitradurga.
Village accountant in the office of the Tahsildar. In the office, which office is that? How are they separated? As village accountant in Chitradurga. In Madadakere circle. The complainant is the one who was wanting the name in the khata or the revenue records to be changed pursuant to certain transactions. It is said that he approaches the petitioner for the purpose of change of entries in the revenue records or the change of the name in the khata without the communication from the hands of the village accountant. It could not have been done. The petitioner is said to have demanded bribe of rupees 20,000, out of which 10,000 was agreed to be paid at the time when the work would be done and the remaining later. The complainant pays 8,000 rupees and what remains is 2,000 rupees. 5,000 kotra? Correct. Complainant pays 8,000. The complainant pays 5,000 rupees and what remains is 5,000 rupees to be paid. The complainant then approaches the Lokayukta who would prepare a pre-trap proceedings and lay a trap upon the petitioner. The petitioner is caught red-handed by while accepting the tainted currency of rupees 5,000. The phenolphthalein test that the prosecution undertook on the same day was also successful in as much as the hands of water. Hands have turned pink. After this comes the registration of the crime. The crime had been registered in crime number 1 of 2022 and the investigation leads to the filing of the charge sheet. Filing of the charge sheet, the cognizance is taken by the concerned court on this charge sheet so filed, and the taking of cognizance has driven the present petitioner to this court in the subject petition. The learned counsel Prithvish, appearing for the petitioner, would put up a valiant effort in seeking to contend that there is neither demand nor acceptance in the case at hand, nor there was any work pending at the hands of the petitioner for him to demand bribe or accept bribe. There is no demand at all in the case at hand, and the recordings are not sent to FSL. FSL report is yet to be received, and therefore would submit that the charge sheet is short laid against the petitioner, and the order of cognizance also does not indicate that cognizance is taken for the offence under section 7A of the Act. On these submissions, the learned counsel seeks quashment of the entire proceedings. Per contra, counsel for the respondent B.B. Patil would vehemently refute the submission in contending that the petitioner is caught red-handed. The trap was successful. It becomes a matter of trial in such circumstances whether there was a demand or otherwise, as there is clear acceptance in the case at hand. The presumption under section 20 would kick in once the acceptance is found or the petitioner is caught red-handed on receiving the tainted currency / bribe amount. The learned counsel would submit that the charge sheet is clear and the order of cognizance need not be reasoned as is necessary need not be reasoned once the concerned court is taking cognizance on the charge sheet. He would seek dismissal of the petition. The four narrated facts are not in dispute. The issue revolves around corruption. The petitioner is a village accountant, is alleged to have demanded bribe of rupees 5,000 for performance of particular action from the hands of the complainant. The voice recording is the conversation between the two is recorded. The recording leads to a pre-trap proceedings being laid against the petitioner. The petitioner is a trap is laid against the petitioner later. In the trap, the petitioner is found is caught for receiving a bribe amount of rupees 5,000 and the tainted currency. The test that is necessary to be undertaken, i.e., the phenolphthalein test, is also positive. On these circumstances, the police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 60. On the charge sheet, the concerned court takes cognizance of the offence, page 170. The issue now is whether this court at this juncture should interfere in a case where a public servant is caught accepting bribe amount. If the petitioner had not received any amount or somebody else had received the amount, then it would have been a different circumstance to be considered. Here the petitioner himself has received the amount, the tainted currency / bribe amount, and the procedure followed by the prosecutor. I do not find anything wanting in the procedure followed by the prosecution, i.e. the lokayukta, in laying the trap or in filing the charge sheet. In the charge sheet being in detail and the issue being of corruption, it would mask the order of cognizance, though it does contain some reasons which would not be enough reasons for in the eye of law. But the petitioner being caught red-handed, this court would not lend its protective hands to a person / public servant who has been caught red-handed of amount of rupees 5,000. It is for the petitioner to come out clean in a full-blown trial. Petition lacking in merit stands rejected.
Obligation. I seek for one indulgence. The observation made.
It is made clear.
Your lordships have observed that the trap is successful. I was caught. That would influence the trial.
Prima facie. The observations made, it's made clear that the observations made in the course of the order would not bind or influence the trial against the petitioner. The concerned court shall independently apply its mind and regulate its procedure thereafter.
Please. Deeply
regulate its procedure thereafter.
Obliged.
Yes.
My lord, seek adjournment in this.
No, madam.
Petitioner
Namita Mahesh,
counsel-
avarte helidde nanu. I am
Petitioner
not
coun-
going to grant any adjournment. You said you will produce the check. If she is coming, I will pass it over. Otherwise, this goes today.
My lord.
You are the
petitioner-
signatory to the check. You cannot
Proxy
escape.
counsel in this.
Then interim order vacate ಮಾಡ್ತೀನಿ.
My lord, it
If
is
you
a
want
request.
pass over, I will grant. No adjournment.
Counsel father-in-law expect today morning.
Sir, ಇದರಲ್ಲಿ
Short accommodation. please.
ಇವ್ರು ಯಾರು?
Respondent, sir.
ನೀವ್ ಯಾರು?
I am the proposed impeding.
Applicant.
Impeding.
ನಿಮಗೆ advocate ಇಲ್ವಾ? Are you party in person?
ಇಲ್ಲ sir. ಅವರು
Stay away. Only if you are party in person, you can submit. Trial court ಅಲ್ಲ ಇದು. I'll take it as the learned counsel for the petitioner submits that the father-in-law of the petitioner has expired. Therefore, as a last chance, list this matter on 3rd February in this same stage. So 4th February, adik matra beku. Yes, 4th February. It is made clear the interim order would stand automatically vacated if no submissions are made on the said date. Indulgence is shown only on the bereavement in the family. Yes. Interim order succession would continue to the next date of hearing. Next.
Serial number 10.
Idu success ah?
ಇಲ್ಲ actually failure because
Case failure ah?
ಅಲ್ಲ
Yes sir.
actually failure because
sheet
what happens in one element of the trap, one aspect of the trap, they go inside where the petitioner is sitting in his office. ಏನಿದೆ? Okay.
Dates and events.
And then what happens? The decoy witness is outside. So certain things happen. Allegation is he has received 6,000. After the complainant comes out, that is PW1, who is the chief person who gives the money. They ask him, where is the recording of the voice? He says, Gabrinalli nan voice recording madilla. So that has failed. To that extent, the voice recording fails. The decoy witness is not inside. In Supreme Court, Shantamma's case.
Shantamma is after trial.
I know, Shantamma is after trial, but one foundational fact that they found there was that the decoy witness was not inside. I'm using your lordship's words in one of the related judgments. The decoy witness was not inside. And therefore, on the sole testimony of, it now stands on the sole testimony of the person who went inside and said that I have given him the money. There could be a possibility that the recording itself has been suppressed by them because he did not demand. And that's why they said that he did not record it.
But
pre-trap separate
the pre-trap, ದುಡ್ಡು ಇಸ್ಕೊಂತಾ ಇದ್ರಾ?
He was caught red-handed,
Caught red-handed ಅಂತಂದ್ರೆ
red-handed.
ಅಲ್ಲ, caught red-handed ಅಂತಂದ್ರೆ the tape recording is not there.
ಪರವಾಗಿಲ್ಲ, ದುಡ್ಡು ಯಾಕೆ ಇಸ್ಕೊಂಡ್ರೆ?
And then the decoy witness.
Why did you take money?
But decoy witness.
But why did you take money?
The trap.
To take money, everything goes into the oblivion. Only money.
But there is so many persons in the trap squad.
What to do, sir?
It is very difficult.
Why did you take money, sir?
It may have been inserted by them.
Once money is taken, section 20 kicks in.
But the decoy witness who stands outside.
Tell a trial.
He says, he does not say there was demand. The decoy
Why
witness.
did you accept?
That is the situation. In a case where
in 7A, sir, let me make it clear. If the trap is successful and the public servant is caught receiving money, I am not going to show any indulgence. If somebody else has given some trap, some ido allitro, illitro, 2-3 sari trap hodru agilla, antadralli will consider. But the public servant is caught receiving money, we should not show indulgence.
What has happened here is, it stands on the sole testimony of the complainant.
All right. So
the person outside also does not say there was demand.
You may get acquitted, sir.
He says, I didn't see what.
You may get acquitted.
And can you see recording this person? He records the transcripts in the pre-trap. But during this point, he says, Gabri I to record madilla anta.
Aitu avrige en Gabri agide.
That would have been a failed.
But why did you take?
It is a failed trap.
Why did you take money?
That is their version, Lord. That they have.
ತಗೊಂಡು ಎರಡು ಕೈಯಿಂದ ಎಣಿಸಿ ಎರಡು ಕೈ ಕ್ಲಿಯರ್ ಆಗಿದೆ ಅಂತ ಟ್ರಾಪ್ ಪೇಜ್ 29.
ಇಲ್ಲ.
ಪೇಜ್ 29 ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಹೇಳ್ತಾರೆ.
ಎರಡು ಕೈಯಿಂದ ಎಣಿಸಿ ಎರಡು ಪಿಂಕ್ ಆಗಿದೆ.
ಎಷ್ಟು ಅಮೌಂಟ್?
6,000 rupees.
6,000.
ಜಾಸ್ತಿ ಇಲ್ವಾ? ಇನ್ನು 6,000 ಇದೆ.
29 ಪೇಜ್ ನಂಬರ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Just 6,000. But
unjust 6,000.
See, the decoy witness is outside. ಯಾರು ಇಲ್ಲ, nobody to accompany him.
ಅದಾದ್ಮೇಲೆ ಟ್ರಯಲ್ ದುಡ್ಡು ತಗೊಂಡ್ಮೇಲೆ ಮುಗೀತು.
Suppose, Lord,
I would only say, even
ಈಗ see, Vivek Reddy sir, the many instances where accused number 2 takes on behalf of accused number 1. There is some semblance because he is the one who has received, whether he has received on behalf of this or not. Examination is a little more in that, not in this case. ತಗೊಂಡ್ಮೇಲೆ ಮುಗೀತು.
The mere existence of that money in the pan could not in my
ಇದು ಇದರಲ್ಲೂ ಪಿಂಕ್ ಆಯ್ತಾ? No.
I would say, my
ಅವ್ರು
lords,
ಹೇಳ್ತಾರೆ.
even assuming the contentions of the learned senior counsel were
ಡಿಸ್ಚಾರ್ಜ್
accepted.
ಹಾಕೊಳ್ಳಿ ಬೇಕಾದ್ರೆ, ಡಿಸ್ಚಾರ್ಜ್ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ.
ಚಾರ್ಜ್ ಶೀಟ್
ಕ್ವಾಂಟಿಫೈಡ್ ಡಿಸ್ಚಾರ್ಜ್, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ, ಆಮೇಲೆ ಬನ್ನಿ ಬೇಕಾದ್ರೆ.
ಆಯ್ತು.
Otherwise, this finding will definitely lead to a charge. Whatever I found in that case, if I repeat.
ಬೇಡ.
ಅಲ್ವಾ?
ಬೇಡ. But that absence of recording this.
ಅದೆಲ್ಲ ಈಗ ನೀವು ಡಿಸ್ಚಾರ್ಜ್ ಅಲ್ಲಿ ಎಲ್ಲ ಅರ್ಜಿ ಮಾಡಿ.
ಆಯ್ತು. Yes.
Heard the learned senior counsel Shri Vivek Reddy appearing for the petitioner. The petition is at the stage of crime. The offence is under section 7A and B of the Prevention of Corruption Act. The learned senior counsel projects various grounds, but would submit that he be reserved liberty to approach this court or approach the competent fora once the charge sheet is laid against him, comma, if it is laid against him. The learned counsel for the respondent submits that this is a case of successful trap, be that as it may. In the light of the submission of the learned senior counsel, the petition stands disposed, reserving liberty to the petitioner to approach the appropriate fora at the event of need.
Please.
Interim order of any kind.
And seek discharge ಮಾಡಿ ಅದೊಂದು ಮಾತು.
Whatever, ಏನ್ ಬೇಕಾದ್ರೆ.
ಅದು ಹೇಳದೇ ಇದ್ರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಲ್ಲ, ಆದ್ಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್ ಇರೋದು. Yes. The interim order of any kind subsisting shall stand dissolved.
Please.
11.1. That the entire case is that the complaint appears to be a rowdy sheeter. No, he has a financial understanding with accused.
ಯಾವ್ದು ಇದು ಸೈಲೆಂಟ್ ಸುನಿಲ್ಲ?
ಇಲ್ಲ.
ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಯಾರು?
ಸರ್ ನೋಡ್ಲಿಲ್ಲ. ಇಲ್ಲ ಸಾರಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಬರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಿದು?
11 minutes.
ಕರೆಕ್ಟ್ ಬಸ್ ಸರ್, ಇದ್ರಲ್ಲೇ ನೀವು ಇರೋದು. ಸರ್ ನೀವು ಸೀನಿಯರ್ ಇಸ್ ಅಪಿಯರಿಂಗ್ ಇನ್?
Yes, my lord, I am in.
ಕಂಪ್ಲೇಂಟ್ ಗ ನೀವು? Yes, sir.
Without going into the merits of the matter at this point of time.
ಕಾಗ್ನಿಸೆನ್ಸ್ ಆರ್ಡರ್ ಸರಿ ಇಲ್ವಾ?
ಅಲ್ಲ 156(3) reference.
ಎರಡಿದೆ, ಎರಡು legal issue ಇದೆ.
Yes, sir.
The first legal issue is, may I just request your lordship to kindly turn.
Sir, ತಾವು ಅಪಿಯರ್ ಆಗ್ತಿರೋದು ಯಾವ ಕೇಸ್? ಫಸ್ಟ್ ಒನ್, ಸೆಕೆಂಡ್ ಒನ್. 11.1 ಒಂದು. 11.
CH-16.
First matter 11 also.
Yes, sir, yes.
May I just request your lordship to kindly turn to ink page 18, the proceeding sheet of the case.
Ink page?
18.
Yes, sir.
That is the order sheet. But the complaint is filed on 24/4. My lord gets it.
I am here, sir.
The same day he would proceed to pass the orders.
24/4 referred on 25/4 or 24?
24/4.
24.
25/4. 25.
Next.
The very next day. May I just request your lordship now to kindly turn to ink page 19 now. But in view of the law laid down by the Honorable Supreme Court in Priyanka Srivatsava, there should be a compliance with 154(1) as well as 154(3) with necessary or supporting documents. That is what the Supreme Court has said in paragraph 31 of Priyanka Srivatsava. Well, nowhere in the complaint he makes a reference to he having gone to the police station and filed a complaint. The policeman not receiving the complaint or acknowledging the complaint, and then, my lord, he going to the superintendent of police and filing a complaint, and superintendent of police also not initiating any action. Therefore, he would approach the magistrate, and the magistrate passing an order under section 156(3). Well, may I just request your lordship to kindly turn to the complaint? Nowhere he would say.
Page.
But the complaint starts at page 20. Or kindly go to page 32. ಎಲ್ಲೂ ಇಲ್ಲ. Throughout the complaint. ನಾನು ಯಾತಕ್ಕೆ ಲಾಸ್ಟ್ ಪೇಜ್ ಓದ್ತಾ ಇದ್ದೀನಿ ಅಂತಂದ್ರೆ ನಾರ್ಮಲಿ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಅಲ್ಲ, ಜನರಲ್.
ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ. Your lordship may take it from me that I have read it in third bear. I have read it and
no affidavit. No affidavit also.
No affidavit also, nothing. Well, what baffles me is this. Now kindly have a look at page 19 now, the order which can be passed to the learned judge. Go back to page
Oh,
19.
is in accordance with Priyanka Srivatsava.
Priyanka Srivatsava. Where does he find it? Who told him that 154.1 and 154.3 has been complied with? Well, I can understand, because that is why I invited my lord's attention to the date of filing of the complaint is on 24/4. Then immediately he would post it for orders on 25/4. He could not have, subsequent to the filing of the complaint, he could not have filed a memo and brought it to the notice of the court about the compliance with 154.1 and 154.3. Where does he find this? Who told him? God knows. But the next is, have a look at the last line in the order at page 19. You would order the reference of the complaint to the DSP of Anekal. Number of.
Is it the officer in charge of the police station?
Well, DSP Anekal is an officer who is superior in rank to the
No,
officer.
he's not the officer in charge of the
He's
police
not the
station.
officer. In fact, the Supreme Court has said time and again in umpteen number of judgments, even if he is an officer who is superior in rank to an officer in charge of a police station, the magisterial powers would not extend.
Only to the jurisdictional police.
Only to the police. He can, at the worst, my lord, after reference under section 36 of the CRPC, he can take over the investigation. Beyond that, nothing else. Well, this can't be remitted back, would be my submission. That is how the Supreme Court also has said.
What's the allegation?
Well, that is worst, my lord. If I were to invite my lord's kind attention to the last paragraph, the prayer, he is himself an extortionist.
Oh, the complainant.
Complainant is an extortionist who is into umpteen number of criminal cases against him. Kindly have a look at page 32. He virtually acts like a pro bono publico, that's all. Para 24, my lord. His name came to be made use of. The second accused is the Director General of Police, ADGP, Additional Director General of Police. Have a look at paragraph 24 minutes. ಆರೋಪಿತರು ಬೇರೆ ಬೇರೆ ವ್ಯಕ್ತಿಗಳನ್ನು ಬ್ಲಾಕ್ ಮಾಡಿ ಅವರಿಂದ ಹಣ ವಂಚಿಸಿ ಮತ್ತು ಫಿರ್ಯಾದಿದಾರನು ಮೋಸದಿಂದ ದೂರು ದಾಖಲು ಮಾಡಲು ಉಪಯೋಗಿಸಿಕೊಂಡು ಬೇರೆ ವ್ಯಕ್ತಿಗಳಿಂದ ಹಣ ವಂಚನೆ ಮಾಡಿ ಪಡೆದು ಮತ್ತು ಹಣ ಪಡೆಯುವ ಉದ್ದೇಶದಿಂದ ನನಗೂ ಮತ್ತು ಬೇರೆ ವ್ಯಕ್ತಿಗಳಿಗೆ ವಂಚನೆ ಮಾಡಿ ಬ್ಲಾಕ್ ಮೇಲ್ ಮುಖಾಂತರ ಹಣ ಸಂಗೀತ ಆರೋಪಿ ಎಕ್ಸೆಟ್ರಾ ಮೇಲೆ ಮಾಡಿದ್ದು. The offense which you would comply is one under section 388, 384, 365 and 420. 388 and 384 are extortion. But the 365 is kidnapping. And then 420 is cheating. He is himself the culprit. He says he came to be made use of. But that is why I said without going into the merits of the matter. Otherwise, my lord, if my lord directs me that I should take your lordship to the merits of the matter, I'm ready to do.
So far as I'm concerned, but I seek your lordship's indulgence.
My lord,
to read.
three judgments, if it is necessary, three judgments of the Supreme Court. But the first judgment of the Supreme Court is in 2001, Supreme Court 668. I don't think it is necessary.
For officer in charge of the police station. That's yes.
In fact, in Musa Haji's case, again, my lord, the Supreme Court would say, although the superior officer is an officer superior in rank to an officer in charge of, it can't refer to it only. But other then probably your lordship may pose a question to me. Look here, for the mistake or the blunder that is committed by the court, why should a party be made to suffer? No. Here, my lord, the Priyanka Srivatsava would come into play because ignorance of law is no excuse. He ought to have gone under 154.1 and he ought to have gone under 154.3. He having not chosen to go under 154.1 and 154.3, he can't go to the magistrate and do it. Now the Supreme Court would quash it in Priyanka Srivatsava. Because that is not a mistake on the part of the court.
Correct, that's all.
Ignorance of law is no excuse.
Yes.
Lord, I'm the Assistant Director General of Police Internal Security. Now, kindly see, my lord, paragraph number 19 of my petition. There appears to be financial transaction with the complainant, who himself is a rowdy sheeter. I have produced 3 documents to show that. And the accused number 1. That is reflected in paragraph 19. That there is a loan transaction between the complainant and Mr. Vijay Tata regarding the 5 crore
para 19.
and all that.
Which petition, sir?
But
Para 19 illa?
petition 11.1 minutes, 6125.
There is no para 19, it ends at 15.
But page 19, minute,
Page
19, page 19 of, this is the complaint.
Complaint.
I'm sorry, I'm sorry.
All
Page
right.
19,
Yes,
paragraph.
you are
19.
right, 1919.
Yes, yes, 1919. There appears to be financial transaction between accused number 1 and the complainant. Several amounts are mentioned, 5 crore, 2 crore, 35 crore and all that. Then paragraph 20, this is the grievance against accused number 1. He went to collect the money and he was sent back dishonorably and all that. Then comes the petitioner. ಹೀಗಿರುವಾಗ ನನ್ನ ತಪ್ಪಿನ ಅರಿವಾಗಿ ನೋಡಿ, he was used to file the complaint by several persons against several other persons to extract money. Now it appears his commission was not paid. That appears to be the real grievance. ಹೀಗಿರುವಾಗ ನನ್ನ ತಪ್ಪಿನ ಅರಿವಾಗಿ ಇವರಿಂದ ದೂರ ಇರಬೇಕು ಅಂತ ನಿರ್ಧಾರ ಮಾಡಿ ನಾನು ಸುಮ್ಮನೆ ಇದ್ದಾಗ ನನ್ನನ್ನು ಅವರ ಬಳಿ ಹೋಗದೆ ಇದ್ದರೆ ಎನ್ಕೌಂಟರ್ ಮಾಡುವುದಾಗಿ ಅಥವಾ ಬೇರೆ ಬೇರೆ ಸುಳ್ಳು ಕೇಸುಗಳನ್ನು ದಾಖಲು ಮಾಡಿ ನನ್ನ ಜೈಲಿನಲ್ಲಿ ಇಡುವ ಬಗ್ಗೆ ಬೇರೆ ಬೇರೆಯವರು ಹೇಳಿಕೊಂಡು ಬರ್ತಿದ್ದು. ಆದ್ರಿಂದ ನಾನು ಭಯಪಟ್ಟು ADGP ಚಂದ್ರಶೇಖರ್, ದಟ್ ಇಸ್ ದ ಪಿಟಿಷನರ್, ದಿನಾಂಕ 3/2/24 ನನ್ನ ಕುಟುಂಬ ಸದಸ್ಯರ ಸಮೇತ ಹೋಗಿ ಎಲ್ಲಾ ವಿಚಾರ ತಿಳಿಸಿ ನನ್ನ ವಿಚಾರಕ್ಕೆ ಬರದಂತೆ ವಿಜಯ್ ಟಾಟಾರ್ ಅವರಿಗೆ ಸೂಚಿಸಲು ಮನವಿ ಮಾಡಿಕೊಂಡು ಹೋಗಿದ್ದು. ಅವರು ಸಿಗದೇ ಇದ್ದ ಕಾರಣ ಮತ್ತೆ ಸೋನ್ಸೋ ಬರೋದು ಹೇಳಿದರು. ಅದರಂತೆ ನಾನು 14/2/2024 ಸಂಜೆ 4:30 ಗಂಟೆಗೆ ಅವರ ಕಚೇರಿ ಬಳಿ ಹೋದಾಗ ನನಗಿಂತ ಮೊದಲೇ
ನೋಡಿದೆ.
This is what I have done. What I have done is there are several cases against him, but he says he used to visit the police station. Now when he came to the police station, we arrested and produced before the magistrate. Now kindly see the paragraph 24. It's like a public interest litigation, as the seniors are saying. ಆರೋಪಿತರು ಬೇರೆ ಬೇರೆ ವ್ಯಕ್ತಿಗಳನ್ನು ಬ್ಲಾಕ್ ಮೇಲ್ ಮಾಡಿ ಅವರಿಂದ ಹಣ ವಂಚಿಸಿ ಮತ್ತು ಫಿರ್ಯಾದಿದಾರರನ್ನು ಮೋಸದಿಂದ ದೂರು ದಾಖಲು ಮಾಡಲು ಉಪಯೋಗಿಸಿ ಬೇರೆ ವ್ಯಕ್ತಿಗಳಿಂದ ಹಣ ವಂಚನೆ ಮಾಡಿ ಮತ್ತು ಹಣ ಪಡೆಯುವ ಉದ್ದೇಶದಿಂದ ನನಗೂ ಮತ್ತು ಬೇರೆ ವ್ಯಕ್ತಿಗಳಿಗೂ ವಂಚನೆ ಮಾಡಿ ಬ್ಲಾಕ್ ಮೇಲ್ ಮುಖಾಂತರ ಹಣ ಸಂಗ್ರಹಿಸಿದ ಆರೋಪಿ 1 ಸೋನ್ಸೋ. All I have done is arrested him because he was involved in other cases. That's all. There are 3 cases filed against him that I have reflected in paragraph number 6. Crime number 344, 37 and 50. This is the only, in between the petitioner and the complainant and
caught in the crossfire. Yes. All right. Yes.
Let's say 4 contentions that have been taken, my lords, by Lieutenant Senior. The first is the complaint is dated 24/4/2024. Reference on 25/4. My lords, I don't think that could be a legal contention, so I don't propose to deal with it. Second is, my lords, Priyanka Srivatsa not being complied. There is no affidavit annexed with the complaint. This, my respectful submission, is not a correct statement, my lords. An affidavit was annexed to the PCR that has not been produced here. They point out the, we just have this, I'll just pass this on. And the complaint which was given to the SP is dated 22nd April.
It was produced along with the PCR.
It was produced along with it, and if my lords would notice, the court observes it.
Along with the complaint, it is produced.
Out. Along, my lords, the court observes it. If my lords would have.
There is an observation in the order.
This
But
was,
show it.
this was
Pleading,
there.
Allegation is there, document produced.
Factually, at least let me point out what has happened. My lords, page 19, from the perusal of the complaint, same is annexed with the affidavit of the complainant, and also an information has been given as per 154(3) to the superintendent of police. What is produced here is the affidavit and the complaint which is given on 22nd to superintendent of police. So that part of the order, my lords, is in. My lords, the third contention that was pointed out, my lords, reference to DYSP. I mean, respectful submission, they're right, my lords.
It can't be.
It can't be done. Now, if it is not going to be a case which can't be referred to DYSP, because under 156(3) itself,
Only
it
to
is
the
very
officer
clear
in
to
charge of
the,
the police
yes, my lords, to that extent, there could be an interference in the order of sending it back for reconsideration, my lords.
But now you tell me that's, what is the role of accused
My
number
lords,
2?
so far as the fourth aspect, now, 1 minute, my lords. My lords, so far as the fourth aspect is concerned.
Because you have an axe to grind, you can't draw.
My lords, could I just?
You have something against the accused number 1. Let's see the
So my respectful submission is, my lords, if this order of reference is to go, then, my lords, the complaint is before the magistrate. There is no cognizance, there's no process, there's no 156(3) order. The magistrate will have to apply his mind independently. In a 482, my lords, without there being an application of mind by the magistrate, an interference would not be called for. Now, if my lords would want to know in the merits, is there any allegation?
Against accused
I will
number
just
two.
point it out, my lords. Kindly have the
The
complaint.
officer should not be drawn into the.
No, this is not a case of just being drawn in. There's allegation, my lords. If
What
my,
allegations?
my lords should notice
Para
a
19
complaint.
and 24, just see.
My lords,
ಅಷ್ಟೇ ಅವ್ರ ಬಗ್ಗೆ ಹೇಳಿರೋದು ಅಷ್ಟೇ.
this complaint consists of 3 parts in it, my lords. The first part of the complaint is how the complainant was being pressurized to sign into complaints so that the complaints are given as against persons who are inimical to the present petitioners. This is the first set of it, my lords. So a complaint had first been signed by the present respondent number 2 in a complaint given against B.S. Manjunath. If my lords should kindly notice now the complaint at page 35 for a minute, my lords. I will just segregate it.
What is the role of accused number 2?
My lords, at present, when it's a composite complaint, it is to go back to the magistrate
In the
concerned.
complaint, you show what is your allegation against accused number 2.
Please, my lords. My lords, if my lords should have paragraph 4 at page 36
Of the complaint?
My lords, this 2, 3 and 4 goes together. Paragraph 2, 3 and 4 goes together. Where, my lords, I have been forced to give a false complaint against one Manjunath. Now, to give that false complaint against Manjunath, please notice the role played by accused number 2 at paragraph 4.
What became of that?
A complaint was given, a crime number.
What became of that complaint?
My lords, it was registered as crime number.
All right. What happened to that?
What's happened to that? It is, I'm given to understand that it's pending investigation. It's pending. So, my lords, what the allegation
so
is.
tomorrow, anybody
please
can
notice.
come and say against a police officer that he harassed me to give a complaint. So accepting?
Not accept. Now, my lords, all I'm going to be requesting the court is, if my lords feels 156
Accused
order-
number 1, we will see. Because
But
senior has
accused
not
number
submit-
2, my lords.
Senior has not submitted anything on the merit of the matter, and it is an admitted fact that it could not have been sent to the DYSP.
My lords, kindly notice paragraph 4, my lords, whether there's an allegation against accused number 2 or not. Allegation, prima facie, my lords, the allegation is, I was forced to sign a complaint against Manjunath, in which the role against A2, then accused number 2, Chandrasekhar, called Rakesh, police inspector, in his IG office and asked to sign on the complaint prepared by accused number 2, Chandrasekhar, without allowing complainant to read, and complainant signed the same under coercion. This is the allegation we get insofar as Manjunath is concerned. Now, kindly notice thereafter, my lords.
ಇನ್ಯಾವುದು?
My lords, I'll point it further against Kishore. My lords, paragraph 10, that's a allegation when they made me sign against Kishore, my lords. In paragraph
That is
10.
quashed by the coordinate bench, Supreme Court affirms it.
Yes, my lords.
Anything-
Kishore's it's quashed. Manjunath's is still pending.
No, Kishore, Supreme Court has set aside the order, which a coordinate bench of this honorable court.
Had quashed,
Yes,
Supreme Court
quashed the
sets it
complaint
aside.
against Kishore.
And
the
sends it
honorable
back, is
Supreme
it?
Court will set aside that order. Incorrect.
But even Supreme Court, Kishore's matter is over. Manjunath's matter is pending.
Manjunath's
Matter is pending. Kishore's is quashed. Let's take that.
ಇಲ್ಲ, quashed and sent back. It is not quashed.
Sent back. Sent back. Then, my lords, kindly notice, my lords, the
See,
other.
tell me,
The other
why would
allegation.
why would someone go and register a crime against him? ಹೇಳಿದ್ರು ಅಂತ.
My lords, I had a lot of cases against me. I had a lot of cases against me. In fact, my lords will
Oh,
pass.
you're talking of quid pro quo.
My lords, the threat is, if I am not going to be signing this complaint.
Not quid pro quo, threat pro quo. Yes.
My lords, the complaint is, if I am not going to be signing this complaint, I will be sent behind bars. Please notice the nature of complaint. And in the process, I have been extorted of certain amount which has been spelt out in the complaint, and that amount, my lords, my allegation.
Number 1.
Yes, my lords, they shared the amount is the allegation. My lords, the allegation in the complaint is the amount which has been extorted has been shared by the accused. Now, if that is the allegation, my lords, and the matter is to be remitted back for consideration of this allegation afresh to the magistrate, in my respectful submission, without the magistrate passing any orders on it, the question of interference in 482 doesn't apply. My lords, 482 will come against an FIR because investigation. But if it's a complaint, my lords, where there's no investigation at all, it goes back to the magistrate for him to apply his mind. This would be my submission, my lords.
Will answer. Heard
One
reserved.
date, my lord, the alleged coercion, if at all, is on September 2022, 20th of September 2000. He files the complaint on 23rd April 2024. But 2 years he did not realize the so-called coercion.
The coercion effect ಆಗದ್ ಸ್ವಲ್ಪ late ಆಗುತ್ತೆ.
Adu when the money, when his
Coercion, the effect
My lords,
ಯಾವಾಗ
share was not paid.
Sorry, my lords, in a case, my lords, where I'm an accused, there's a constant threat that if you're not going to be part of this, you'll be put inside. It could happen later. It could happen later. My lords, it's not that.
Yes,
So,
sir.
I'm going by the allegations in the complaint, my lords.
Absolutely.
If,
2 ವರ್ಷ coercion ಗೊತ್ತಾಗಕ್ಕೆ 2 ವರ್ಷ ಆಯ್ತಾ?
Anyway, my lords, I leave to.
He
ಅಲ್ಲ,
waited for 2
coercion
years
ಗೊತ್ತಾಗಕ್ಕೆ
for
2
his
ವರ್ಷ
share.
ಆಯ್ತಾ?
His
My lords,
share
I am
Accused
going
number
by,
1,
I'm
you
sorry,
have
my
some
lords, I am
allegation,
going by
grievance.
the allegations in the
Allegation and
complaint.
grievance against accused number 1, no problem. Drawing officers just like that because they have registered crimes against you.
They have forced him to sign and they have shared the extortion money is the allegation in the complaint.
2022 is the force. Why did you wait till 2024?
My lords may draw an inference, but I have to bring to the notice of the court.
Why did you take
My lords,
sir, why did you take 2 years to register?
I
the crime?
have to bring to the notice of the court what is in the complaint. I leave to the
I
court
will
beyond
also
that.
answer what is in the complaint.
Yes, my
not a
lords,
problem.
I leave to the court. I leave to the court.
ಇಲ್ಲ ಇದ್ರ ಡಿಲೇ ಅಂತಂದ್ರೆ ನೀವು ಈ ಕಡೆ ಬರ್ತಿರಲ್ಲ ಅವಾಗ ಎಲ್ಲದಕ್ಕೂ ಡಿಲೇ ಇಲ್ವೇ ಇಲ್ಲ ಅಂತ
My lords,
ಡಿಲೇ will not
my
vitiate
lords,
anything.
when I am standing on this side,
That's
what
why-
best that I could do from
Now,
the complaint, I have
when
to
you come
bring it
this
to the
side and
notice
say
of the
there is a
court.
delay of 3 months, I will not answer at all. 2 years ಗೆ ಡಿಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಇದು ಮುಗೀತು.
My lords, what can I say here other than what is in the complaint? And I want to make certain that what is in the complaint is conveyed to the court. That is all I'm trying to do.
You have conveyed
That's
it.
it.
No worries.
That's all, my lords. I leave it to the court beyond that.
Yes, sir. Additional SP ನಿಮ್ದೇನಿದೆಯಾ? ಇನ್ನು ರೆಫರೆನ್ಸ್ ಆಗಿದೆ ಏನು ಆಗಿಲ್ವಲ್ಲ? Sir, anything in reply?
On the merits of the matter, if my lord wants that I should make my submission.
No, not necessary. As far as accused number 1 is concerned, we'll see.
ಅಲ್ಲ, I am A1.
ಅದು ನೀವೇ A1. ಮೆರಿಟ್ಸ್ ಅಲ್ಲ. ವಾಪಸ್ ಹೋಗ್ಬೇಕಲ್ಲ ಹೆಂಗು?
ಅಲ್ಲ, ವಾಪಸ್ಸು ಹೋಗಿಲ್ಲ ಅಂತ ನನ್ನ ಸಬ್ಮಿಷನ್ ಅಷ್ಟೇ.
ವಾಪಸ್
ಪ್ರಿಯಾಂಕಾ ಶ್ರೀವಾತ್ಸವ ಎಲ್ಲಿದೆ ಅದ್ರ ಅಲ್ಲಿಗೆ?
ಎಲ್ಲಿದೆ? It's already there.
ಅಲ್ಲ, ಪ್ಲೀಡಿಂಗ್ಸ್ ಇಲ್ಲ. ಅದು ಎಲ್ಲಿಂದ ಬಂತು ನನಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. Have a look at the pleadings.
That will, I'll look into that and answer it. That's not a problem. But the officer in charge of the police station only should have been directed. That I will.
ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಇದಿಲ್ಲ, on merits of the matter, if the case of setting at not the order of the trial magistrate and the matter were to go back to the court, then my lord, probably in the second round of litigation, if it is warranted, I may have to urge on the merits of the matter. ಯಾಕೆಂದ್ರೆ 388 to 384 extortion. He should have been extorted, not someone else in para 24. That is what he says.
Allegation of him being extorted.
ನಾನು ಅಲ್ಲ ಅದನ್ನ.
Is it one paragraph only? 2 crores has been extorted from.
But we'll see. Heard reserved. Heard senior counsel so and so reserved. Interim order ಇದೆಯಾ? Interim order subsisting will continue till the disposal of the petition. ಸುನಿಲ್ ಈ ಕಡೆ ಬಂದು ಗಲಾಟೆ ಮಾಡ್ತಾನೆ.
ಇಲ್ಲ,
7 days delay in registering the crime.
ಮ್ಯಾಟರ್ ಆ ಕಡೆ ಬರ್ತೀನಿ.
Yes.
Most of the time we are together.
ಸೀನಿಯರ್ ಜೊತೆಗೆ ಅಲ್ಲಿಂದ
Chota sir, that's in the lighter way. Don't because you're both you're all over ಅಲ್ಲ ಅದಕ್ಕೆ.
Each case, what happens?
You have done your job. It's not bad.
That's what I said. In most of the cases we are together.
Yes. Yeah. Next time.
Serial number 12.
171E.
Yes. But I was traveling from Anantapur to Bangalore.
ಇದು judgments ಕೊಡಿ 171E.
I provided the judgments also.
Where ಕೊಡಿ? Yes, Jagdish sir.
Lecture B, Malad. Page number 15.
Now, what is the allegation, sir?
allegation is, I was traveling from Anantapur to Bangalore. There are 2 carton boxes. In that 96 watches were there.
96 watch.
Watches.
ಹಾ
ಆ ವಾಚ್ ಒಳಗಡೆಗೆ YSRCP ಜಗನ್ಮೋಹನ್ ರೆಡ್ಡಿ ಫೋಟೋ ಇತ್ತು ಅಂತ.
ಸರಿ.
ಆ ವಾಚ್ ನಾನು ಬೆಂಗಳೂರಿಗೆ ತಗೋ ಬರ್ತಾ ಇದ್ದೆ ಅಂತ ಅಲಿಗೇಷನ್.
ಏಕೆ ಮಾರಾಟ ಮಾಡಕ್ಕ? ಮಾರಾಟ
ಮಾಡಕ್ಕಲ್ಲ. During the time of elections, I was getting them. But there is no YSRCP in Karnataka. I cannot induce anybody.
ಬೇರೆ ಯಾರು ಯೋಚನೆ ಮಾಡ್ಬೇಕು ತಾನೆ? ಲೋಕಲ್ ಯಾರು ಹೇಳ್ಬೇಕಲ್ವಾ?
ಇಲ್ಲ ಬಾರ್ಡರ್ ಇದು ಕರ್ನಾಟಕಕ್ಕೆ ಬಂದಿದೆ.
ಬಾರ್ಡರ್ ಸರಿ. ಇಲ್ಲಿ ಯಾವ ಪಾರ್ಟಿ ಇದೆ? ಇಲ್ಲಿ ಯಾವ ಕ್ಯಾಂಡಿಡೇಟ್ ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲ ಅಲ್ಲಿಂದ ಪಕ್ಕಕ್ಕೆ ತಗೊಂಡೋಗಕ್ಕೆ.
ಎಸ್, ಇಟ್ಸ್ ಕವರ್ಡ್ ಬೈ ಮೈ ಆರ್ಡರ್. ಜಗದೀಶ್ ನೋಡಿದೀರಾ?
Yes.
The petitioner is before this court calling in question the proceedings in registration of a crime in crime number 118 of 2024 registered for offence punishable under section 171E of the act of so and so act. IPC, sorry.
IPC.
Of the IPC. The heard so and so. The petitioner, the second respondent is the complainant, the election officer. The vehicle of the petitioner was intercepted at Bagepalli checkpost, which is the border between the states, states Karnataka and Andhra Pradesh. The allegation is that the petitioner was carrying 96 wrist watches of holding the photo of the YS so and so leader. Therefore, the offence springs under section 171E. The registration of the crime is what has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner submits that the ingredients necessary under section 171E is not found even to its semblance in the case at hand. Therefore, would seek the proceedings be quashed. The learned additional SPP would, however, defend the action and contend that the trial in the least must be permitted to be continued. I have given my source. The aforementioned narrated facts are a matter of record. The complaint is registered on 20th March 2024. Since the entire issue has now sprung from the complaint, I deem it appropriate to notice the complaint. Page 11. Section 171E is alleged pursuant to the complaint in the crime number 118 of 2024. The purport of section 171E need not detain this court for long or delve deep into the matter. This court in 2025 SSC Online Karnataka 19647, while considering an identical fact situation of the offence under section 171E. Section 1 has held as follows. As observed, section 171E punishes bribery. Bribery is defined under 171B. A person who gives gratification to any person with an object of inducing any other person in exercise of an electoral right would become an offence. The petitioner was caught with watches, not with distribution of watches. That too of a candidate that was not contesting that had no representation in the state of Karnataka. In that light, the registration of the crime itself, permitting investigation into the registration of the crime itself, would become an abuse of the process of the law and result in miscarriage of justice for the aforesaid reasons. So on. Yes, next. Written arguments idike. Ayyo.
Serial number 13.
ಹಂಗಾರೆ ಇದು ಟ್ರಯಲ್ ಆಗ್ಬೇಕು. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪರ್ಮಿಟ್ ಮಾಡೋಣ. ಇದು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ದೀರಾ? ಅದು ಏನೇನೋ ಇದೆ.
SRP ಅಲ್ವಾ?
ಹಾ,
ವಾಚ್
ಡೆಫಿನೆಟ್. Will permit investigation in this. Yes. ಅಲ್ಲಿದ್ದಾರೆ.
Petitioner. I am for 13. You are 13.
You are for 13. ಅಂದ್ರೆ
Serial number 13.
Serial number 13.
Lordship, is the petitioner is arrayed as accused number 3. crime number. Registered in the crime number, let's face that at page number. The complaint is lordship is page number 20, typed copy. 24.
Yes, sir.
Your lordship is that there is a.
ಸ್ವಲ್ಪ ಮೈಕ್ ಹತ್ರ ತಗೊಂಬಿಡಿ.
There is a delay of 62 days, lordship.
ಎಷ್ಟು?
62 days. And it's in a counter case, lordship. Kindly peruse the next page 25, lordship.
ನೀವು ಹಾಕಿದ ಕೇಸ್ ಯಾವುದು?
Please, lordship.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರಲ್ಲ?
Yes.
ಅದ್ಯಾವ ಕೇಸ್?
That is kindly peruse at
13, ನೀವು 13.1 ನಾ 13?
Non 13, sir.
13.
That is a case is registered by us, let's say, on crime number 24 of 2021. Kindly now it is in CC number, evidence is recorded. Kindly peruse at page 63, lordship. Wherein lordship is that the petitioners, that is the petition, my elder brother, that is Lakshmi Narayana Gowda.
ಇವೆಲ್ಲ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್?
ಹೌದು. ಇಲ್ಲ ನಾವು ಅವ್ರಿಗೇನು ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಅಲ್ಲ, ಅವ್ರು ಬೇರೆ ನಾವು ಬೇರೆ. Kindly peruse one line, sir. Kindly peruse in the page 25. Page 25 typed copy. One line ಹೇಳ್ತಾರೆ.
Yes.
ಅಂದ್ರೆ ಇಲ್ಲಿ R2 ಹೇಳ್ತಾರೆ, ನನ್ನ ಪತ್ನಿಯ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲದ ಕಾರಣ ನಾನು ನನ್ನ ಪತ್ನಿಯ ಆಸ್ಪತ್ರೆಗೆ ತೋರಿಸುವರಿಂದ ನನ್ನ ಮೇಲ್ಕಂಡವರು ನನ್ನ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದರಿಂದ ನಾನು ನನ್ನ ಪತ್ನಿಯ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ತೋರಿಸಿ ನನ್ನ ಮೇಲೆ ದಾಖಲಾಸಿದ ಕೇಸ್ನಲ್ಲಿ ನಿರೀಕ್ಷಣಾ ಜಾಮೀನು ಪಡೆದುಕೊಂಡಿದ್ದು ಈ ದಿನ ತಡವಾಗಿ ಬಂದು ದೂರು ನೀಡುತ್ತೇನೆ. This version is if it's true. There is no question of medical karkondu hogodu submission baralla, because the wife is R2 wife has filed against him in MC. That is kindly peruse the MC case also I mentioned herein.
Wound certificate ಇದೆಯಾ?
ಇದೆ. That is MC case under section 9 she has filed.
All right.
That also I have given the copy.
Yes, sir. Wound certificate is here.
And also he is not in a direct complaint to say the visual of anything. The mother, she say on hearsay.
Yes, sir.
And my grievances, lordship, is that I am residing in Bangalore city. I am not at all participating in the crime.
This happened in which city?
In Doddabellangala. Doddabellangala.
Bangalore rural. You are in urban.
Yes.
For petition.
ಅಷ್ಟೇನಾ? ಬನ್ನಿ.
13.1 million. Delay in lodging and 64 days delay in complaint.
ನೀವು ಅರ್ಬನ್ ಇರೋದ ರೂರಲ್?
Rural. 64 days lodging a complaint.
64 days.
Delay.
ಅವ್ರು ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ರಲ್ಲ ಏನ್ ಮಾಡ್ತಾರೆ?
No, no custody.
ಇಲ್ವಾ?
Custody ಇಲ್ಲ.
Absconding. Anticipatory bail wait ಮಾಡ್ತಾರೆ.
ವೇಟ್ ಮಾಡ್ತಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ಕಾಸೆ ಇದು.
ಅದೇ ನೀವು ಒಂದು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರಲ್ಲ ಕೇಸ್, ಮತ್ತೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಅಲ್ವಾ?
Counter blast milad.
Counter blast.
First complaint file for the petitioner milad. Under respondent but to file a complaint against the petitioner's milad. Crime number. $54 million. In 24. Crime 24. Kindly it is wound certificate milad, my charge sheet page number 36 milad. Similar injury milad.
ಎಲ್ಲ ಸೇಮ್ ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಕಾಪಿ.
36 milad.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ?
Notice are issued milad. Interim orders operating milad.
ಮುನಿಗಂಗಪ್ಪ ಅಂತ ಯಾರೋ ಇದಾರಲ್ಲ.
Statement of elections of filed milad.
ಆಮೇಲೆ discharge rejected.
No, me. Nandu.
Oh, yeah, what discharge is rejected.
But ಅಲ್ಲಿ discharge application Lakshmi is kindly, ನಾನು ಅಲ್ಲಿ ನನ್ನ observation now kindly peruse the sessions court has taken the observation in the kindly peruse page 59 and 266 Lakshmi. Para 8, 10, 11 and 12 and 14. Para 16 are very important.
Very important.
ಇದರಲ್ಲಿ ನಾನು ಆಕ್ಚುಲ್ ಅದು ಹೇಳೋದು ಅಬ್ಸರ್ವೇಷನ್ ಬೇರೆ ತರ ಇದೆ ಇಲ್ಲಿ kindly page 5 and continue ಕೆಳಗೆ sir. Moreover, the time of offense is 9:30 PM Kodigehalli, so it is argued that he was in a presented at the court. Generally, the court begins at 11 AM. There is 1.5 hour differences. Hence, the plea of alibi cannot be taken. ನಾನು ಹೇಳೇ ಇಲ್ಲ, ನನ್ನ ಪಿಟಿಷನ್ ಅಲ್ಲಿ plea of alibi ಈ ತರ ಇಲ್ಲ,
ಬೇರೆ ತರ ಇದೆಯಾ?
ನನ್ನಲ್ಲಿ ಇಲ್ಲ.
ಈಗ ಹೇಳಿದ್ರಲ್ಲ ಬ್ಯಾಂಗ್ಳೂರ್ ರೂರಲ್ ಸಿಟಿ,
ಇದು ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಹೇಳ್ತಾರೋ. ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ kindly peruse Lakshmi is application. Kindly peruse.
ಈಗ ಡಿಸ್ಚಾರ್ಜ್ ರಿಜೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಹಾ ಸರ್, ನನ್ನ kindly peruse
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ ಅನ್ನೋಂಗೂ ಇಲ್ವಲ್ಲ.
ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಸರ್, kindly peruse the page 10, sorry, page 63, para 10, para 12, para 14, 15 and 16. Nowhere I have stated is kindly peruse Lakshmi is kindly. See, para 14, it is submitted that on the perusal of the complaint CW1, the mother of the CW1 stated the entire facts. The allegation against the A3 states that one Mr. Yogesh Kanchegoda, accused number 3, the present petitioner, both of them may assault to the mother of the CW1 on the face of the and hip ant ಹೇಳ್ತಾರೆ. Next sir, very important, it is submits that on the perusal of complaint, the name of Nogesh and Kempegoda arrayed as ಇಲ್ಲಿ ಇವರೆಲ್ಲ ಅಲಿಗೇಷನ್ಸ್ ಇರುತ್ತೆ, ಇವ್ರದೆಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇವ್ರ ಹೆಸರೆಲ್ಲ ತೆಗೆದು ಬಿಡ್ತಾರೆ. ಸೊ ಕೈಂಡ್ಲಿ ದೇ ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ ದ ಚಾರ್ಜ್ ಶೀಟ್. ಕೈಂಡ್ಲಿ peruse at A5, A6, A7, A8, A9. Their name is deleted after taking the further statement of the ನಾನು ಕೈ ತಪ್ಪಲಿಂದ ಅವ್ರ ಹೆಸರು ಹೇಳಿದ್ರು. And also I have taken the another grounds in my court below.
ಈಗ ನಿಮ್ಮ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರಲ್ಲ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ನೀವು?
ನನ್ ಮೇಲೆ ಹಾಕಿಲ್ಲ.
ಮತ್ತೆ ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ಅಂದ್ರೆ?
ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ಅಂದ್ರೆ ದಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಟು ನೋಟ್.
ವೆರಿ
the allegation is that petition number 3, accused number 3, his brother, younger brother, wife filed a case against the
matrimonial dispute. ಅದಕ್ಕೆ ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಎಸ್.
ಕೌಂಟರ್ ಅಂತಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಏನಾಗಿದೆ ಪಿಟಿಷನ್ ನಂಬರ್ ಇಲ್ಲ ಆಗ್ಲ ಸ್ವಾಮಿ, ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ಬ್ರದರ್ ಇದಾರಲ್ಲ ಲಕ್ಷ್ಮೀನಾರಾಯಣ್, ಅವರ ವೈಫ್ CW2 ನಲ್ಲಿ ಕೇಸ್ ಹಾಕಿದಾರೆ ಔಟ್ರೀಚಿಂಗ್ ಮಾಡೆಸ್ಟಿ ವುಮೆನ್ ಅಲ್ಲಿ.
ಅದಕ್ಕೆ ಇದು
ಅದಕ್ಕೆ ಅವ್ರು ಹಾಕಿ ಆಫ್ಟರ್ 2 months ಮೇಲೆ ಈ ಕೇಸ್ ಹಾಕಿ
ಆರ್ಡರ್ ಬರೀಲ್ಲ.
ಅದರಲ್ಲಿ ನಾನು ಅಲಿಗೇಷನ್ ಮೇಲ್ಸ್ ಕೈಂಡ್ಲಿ peruse, ನಾನು ಆಲ್ರೆಡಿ para 16 ನಲ್ಲಿ ಅದರ ರೆಫರೆನ್ಸ್ ಹೇಳಿದೆ.
The petitioner, both these cases, same crime, same special season, both these cases, the cases at hand are preferred by different accused. In special CC 329 of 2021, criminal petition 8404 of 2023 is preferred by accused number 3, while criminal petition, the companion petition in criminal petition 12903 is preferred by accused number 1, 2, 4 and 11. For the sake of convenience, the facts in criminal petition 8404 of 2023 have been narrated. Heard so and so. Judgment is kodi sir. ಹಿತೇಶ್ ವರ್ಮಾ, ಅದು ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಆಯ್ತು. ಮಿಕ್ಕಿದೆಲ್ಲ ಅದು ಅಟ್ರಾಸಿಟಿ ಇದೆ ಗೊತ್ತು, ಮಿಕ್ಕಿದೆಲ್ಲ
ಕಾಂಪ್ಲಿಮೆಂಟರಿ.
ಇದರಲ್ಲಿ even atrocities act is found. The petitioner, a crime, the second respondent is the complainant. A complaint comes to be registered on 6/4/2021 on an incident that takes place on 2/2/2021 in the at about 9:30 p.m. After the said complaint becomes a crime in crime number 54 of 2021 for the following offences, page 19 ಅಲ್ಲಿ mark ಮಾಡಿದೆ. The police then conduct investigation and file a charge sheet against the accused in the cases at hand. The filing of the charge sheet has driven these accused to this court in the subject petition. The learned counsel appearing for the petitioners in both the cases would project similar contentions of the issue being the crime being registered as a counterblast. It transpires that CW2 had registered a crime. CW2 ಯಾರ ಮೇಲೆ ಮಾಡಿದ್ದು? 354 ಯಾರ್ದು?
354 against the petition, the present, that is accused number 3's.
The learned counsel submits that several proceedings are instituted, including a matrimonial case, again, due to which the present complaint is a counterblast. Apart from the said fact, the learned counsel submits that the complaint is registered on 4/4/2021 for an 6/4/2021 for an incident that allegedly takes place on 2/2/2021. There was a delay of 65 days in registering the complaint. The learned counsel submits that if at all there was an assault that has happened in the case at hand and a hurling of abuses happened, the complainant ought to have registered the crime immediately. Therefore, would submit that the petition be allowed, the proceedings be quashed. The learned additional SPP representing the state would take this court through the documents appended to the petition, which are the charge sheet material and the charge sheet itself, to indicate that the matter would require a trial, as there are serious allegations of assault and hurling of abuses in broad daylight in a place of public view or a public place, as the case would be. He would submit that the discharge applications filed by the petitioners before the concerned court have also been rejected, and this court should not interfere in cases where the allegations are grave in nature. I have given my source. The aforenarrated facts are a matter of record. The petitioners are the accused as indicated herein above. On 6/4/2021, a complaint comes to be registered by the second respondent complainant, one Manjunath. The complaint reads as follows, page 24-25. The complainant clearly narrates that on 2/2/2021 at about 9:30 p.m. the accused come in a vehicle, assault the complainant and harass petrol surdra.
Assault the complainant, assault to the mother of the
assault the mother of the complainant and assault the mother of the complainant and intimidate or threaten the complainant or his mother for their lives. The complaint becomes a crime in crime. The complaint becomes a crime in crime number 54 of 2021. The police, after investigation, file a charge sheet. Summary of the charge sheet as obtaining in column number 17 reads as follows, page 41. A perusal at the complaint or the summary of the charge sheet. During the investigation, the police have also recorded the statement of the accused, statement of the victim and the independent witnesses, and have drawn and have also placed the wound certificate wound certificate, which shows that there are injuries, though not grievous in nature, but there are injuries that is a result of the brawl between that is a result of the assault by the petitioner on the mother or the complainant of the mother. Sorry, mother of the complainant. Mother of the complainant. The learned counsel, sorry, in the light of the aforesaid circumstance that there is assault and there is hurling of abuses, it is for the petitioners to come out clean in a full-blown trial, for the reason that what is projected before this court is a maze of facts, maze of facts which would amaze this court for interference in exercise of its jurisdiction under section 482 of the CRPC. If interfered in such cases, it would run foul of the judgment of the apex court in the case of Kaptan Singh versus Union of India, 2021 10 SEC page 446. In that light, the petitions lacking in merit stand rejected for the petitioners to face trial and come out clean in such trial. The observations made in the course of the order are only for the purpose of consideration of the cases of these petitioners under 48 of the CRPC, would not bind or influence the proceedings before the concerned court. Ordered.
Case and counter case.
Family members,
Yes, co-person is my lord.
settle ಮಾಡ್ಕೊಳ್ಳಿ.
There is no partition between the joint family property.
ಆಯ್ತು ಸರಿ.
2.5, but the main issue, 1 minute. The issue,
324 is the allegation.
All right. Survey number 31/1 is belonging to the petitioners measuring 1 acre for 2 guntas. Plus survey number 31/2 measuring 18 guntas belonging to the respondent number 2 and his family. 2.5 guntas of land has been encroached and put up the compound. But I have suggested my client to settle the issue. Requires 2.5 guntas. That land which has been encroached, if left to the respondent number 2, is ready and willing to settle.
Suit is pending with respect to the property.
The report, the encroachment is supported by the adverse sketch, made by the revenue. That's the offer was given to.
Own certificate idea.
Taste.
Page number 45.
8 injuries are there.
Page number 45. 42.
Head injury.
Respondent number 2 and his son both are injured.
ಟ್ರಯಲ್ ನಡೀಲಿ.
Same offense my lord, counter case also my lord.
ಎರಡು ನಡೀಲಿ ಬಿಡಿ. ಎರಡು ಕ್ಲೋಸ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Civil suit is pending my lord.
ಆಯ್ತು ಮಾಡ್ಕೊಳ್ಳಿ, ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಒಂದೇ ಸರಿಗೆ. ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಲಿವ್ ಹ್ಯಾಪಿಲಿ. ಯಾಕೆ ಬೇಕಿದಲ್ಲ? ಎರಡು ಕಾಲ್ ಗುಂಟೆ ತಾನೇ ಕೇಳ್ತಿರೋದು.
Pertains to this land, no dispute.
No, there is a dispute my lord. There is a dispute my lord.
ಆಯ್ತು, whatever. ಪ್ರಾಪರ್ಟಿ ತಾನೇ ಹೊಡೆದಾಡ್ತೀವಿ.
Yes ma'am.
So sit and settle. ಎಲ್ಲಾ ಕೇಸು ಒಂದೇ ಸರಿ ಆಗೋಗ್ಬಿಡುತ್ತೆ.
My lord, one of the petitioner is waiting for the job my lord because he has selected as constable my lord.
Waiting for the job.
Because of this my lord,
then
he is not getting
I
to
will
the.
permit trial to be conducted. He will wait for his job for another 10 years.
For the past 3 years he is waiting my lord.
Another 7 years ಮಾಡ್ಲಿ ಬಿಡಿ.
My lord. No,
Family members.
It's not involvement.
No problem. You want to settle it? I will give you 10 days time. You will get your job also.
I'll secure the instruction.
If you have secured the job, now secure instructions. How to protect the job. Please. The parties to the list, the warring parties to the list are members of the same family, are before the civil suit hakidira. Suit hakidira.
Yes, madam.
Are before the
There are 5 to 6.
concerned civil court seeking partition of the property. The learned counsel of the respondent complainant submits the issue is only with regard to 2.5 guntas of land and the dispute subsists only with regard to that. The counsel for the petitioner, however, would dispute it. Since the issue is case and a counter case between the parties to the list, I deem it appropriate to permit the parties to the list to explore the possibilities of a settlement, if any, and report the same on the next date, list the matter on 4th February.
Next week itself, ma'am.
ಅದೇ next week ನಿಮಗೆ ಜಾಬ್ ಬೇಕಲ್ವಾ? Yes.
This disproportionate asset case, in this, I just highlight 3 points. That's all. One is in page number 17, page number 17 source report is there. In that, they have mentioned a property and that property, they themselves specify that this property came from gifted.
Danapatra.
Danapatra. Okay. So that is accounted as an asset. And second, I highlight in page number 19, page number 19 ali salary. Salary is at least the known sources of income that they cannot deny.
Correct.
While considering the salary, they have taken only 65 lakhs. And out of that, in same page number 19, serial number 6, they say, ಸಂಬಳದ ಉಳಿತಾಯ ಆದಾಯ ಅಂತೇಳಿ 8 ಲಕ್ಷನ ಖರ್ಚು ಅಂತ ತೆಗಿತಾರೆ. So 65 lakhs is the income what they take in the salary. Out of that 8 lakhs they deduct. That means they account only 57 lakhs. Wherein which I have drawn the salary.
Percentage.
I have drawn the
percentage ಎಷ್ಟು?
Percentage. Disproportionate allegation 141%.
ಈಗ 8 ಲಕ್ಷ ಸೇರಿಸ್ಬೇಡಿ.
ಇಲ್ಲ. That's not my contention. Even if 8 lakhs are ಬಿಟ್ಟು what I am trying to highlight is what the salary I have drawn is 1 crore 8 lakhs net salary. And net salary they have accounted only 57, means 50% of the salary is being deducted. If 50% of the salary is deducted of any government official, every case becomes a fit case for raid. At least salary they should have accounted in a proper manner. That's my highlight, man. And apart from I have produced all the salary certificates along with my petition. And the third contention what I have raised is that the petitioner's son is working in a company. And from that he has drawn the salary. And for that he has paid the income tax also. And that salary has come to the account. Irrespective of that, that is not taken into account. For that, I had in last hearing date, I had submitted Nirankar Nath Pandey case, and that's the 3 contentions what we are highlighting.
My lords, taking into consideration the daughter-in-laws and the son's IT return, I have only given a draft calculation, accepting all those income tax. Even then, the disproportionality comes to 57%.
Why did you project 141%?
That was in the source report. Now, my lords, this honorable court, while admitting this petition, was pleased to direct us not to file charge sheet without the leave of the court. But we have kept the investigation on. During that, we have prepared a draft charge sheet where we have taken all his contentions, which he is now espousing before this court. Income tax report of daughter-in-law, son, wife also, though he is not part of the pleadings here in the petition, we have taken the wives as well. And now the disproportionality, my lords will find, it comes at 48%. It's at page number 119 of the draft charge sheet. Page number 199. That's the entire draft charge sheet, which has the whole all the income tax, all his salary slips, everything is considered as he has said.
ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Anything to me.
ಎಲ್ಲ all your grounds are over.
No, whether they have considered it or not.
ಎಲ್ಲ ಹೇಳಿ.
ನೀವು
ಗ್ರೀವೆನ್ಸ್ ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡುವಾಗ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟೆ ಮಾಡ್ತೇವೆ ಅವರಿಗೆ.
At the time of filing the FIR, charge sheet is something different. Whether the validity of the FIR is in question. One small submission. At least the salary, if they had looked into, there was no occasion to.
ಈಗ look in ಮಾಡಿದಾರಲ್ಲ.
ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲ ಮಾಡಿ
everything is looked into. Now before the court you seek discharge once they file the charge sheet.
Made by submissions.
All these they heard the learned counsel appearing for the petitioner is before this court calling in question registration of a crime in crime number 6 of 2023 registered for offence punishable under section 13(1)(b) and 13(2) of the Prevention of Corruption Act. Here now, Coercion Act, hereinafter referred to as the Act for short. The learned counsel appearing for the petitioner would project 3 principal grievances. That the income first. The salary income of the petitioner is short taken while drawing a source report. The income, the house that is received, which is now found in the source report, is by way of a gift.
Agricultural land.
Agricultural land which is now taken as income is received by way of a gift. And the third one is that the son of the petitioner is working elsewhere from whom he has received the amount and the said amount is reflected in the income tax, therefore would seek to place reliance upon several judgments that there is lacunae. Counsel for the respondent B.B. Patil has now placed the charge sheet material on record as investigation was directed to be continued by this court. The charge sheet material, prima facie perusal at the charge sheet material would indicate that all the three instances that the petitioner has now projected has merited consideration during investigation, but the disproportionate assets still remains, but is largely reduced from 141% to 57%. 48% to 48%. Therefore, the learned, the respondent Lokayukta is permitted to file the charge sheet before the concerned court, upon which it is open to the petitioner to seek discharge from the concerned court by producing all material. It is needless to observe that the concerned court would consider the issue on its merit and pass necessary orders in accordance with law in the event the petitioner would prefer such an application seeking discharge. Ordered accordingly.
Much obliged.
Take the file.
ಎಲ್ಲ ತಗೊಂಡ್ಬಿಡಿ ಫೈಲ್ ಕೊಟ್ಬಿಡಿ ವಾಪಸ್.
Obligation, deeply.
16, appearing for the petitioner, my lord, the offences under 376 and 46 of POCSO Act, the
486 of POCSO
petitioner
Act.
was at age of 19 years.
19 and 17.
Yes,
They were in
19
love.
and 17. They were in love for
That's why
9
I've
years.
granted an interim order.
So I would request the court to set a date so the parties, both the petitioner and the complainant, will be present with their parents.
When do you want?
Anytime in the next week.
I'll post it on 3rd February at 4:30 p.m.
Much of.
List the matter at 4:30 p.m. on 3rd February. Interim order granted on 13/9/2024 shall continue till the disposal of the petition.
Please.
17,
Petitioners. Protest to 7 in row. I want to place it some documents.
My order dated 18/9/2024. None interim order.
17.
ಅಲ್ವಾ ಯಾವ್ದು
17.
Oh, sorry, 17 mistake. ಇದು PC Act.
78. I need to place some documents on record.
Yeah,
I have it
7
in next week.
7.
Which is not.
Successful.
Please, my lord, we filed our counter.
Oh, ಇವರೇ ಇಸ್ಕೊಂಡಿದ್ದಾರಾ?
Please, received by someone else.
ಅದು ಸ್ವಲ್ಪ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋಣ.
Please.
Yes, we'll list it on 31st.
Please.
List on 31st. Interim order ಇದೆಯಾ?
That's not to proceed.
File charge sheet. List the matter on 31st. Interim order / protection grant subsisting shall continue till the next date of hearing. Yes.
But I stand corrected. My contention is, my lords, he has only received it. Petitioner number 2 only has received it.
ಹೌದಾ? ನೀವು ಇಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ನಾನು ಇಂಟರ್ಫಿಯರ್ ಆಗಲ್ಲ. Straight away.
The complainant himself is not interested party in the matter.
Not interested party. ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ.
ಅಲ್ಲಿ ರಿಟರ್ನ್ ಹಾಸ್ಟೈಲ್ ಬಿಡಿ.
Complainant himself is stated to be a contractor grade 2, where he is supposed to be.
ಇವರು accused number
2.
Accused number 1.
Accused number 1, petitioner.
Accused number 1, Mr. Raju.
Mr. Raju. Yes.
Number 1, Lord, the complainant himself is a electrical contractor grade 2.
Contractors ಎಲ್ಲ ಮಾಡೋದು.
Lord, demand is made by accused number 2 and received by accused number 2.
But I'll place it that, Lord, I have considered.
Received by accused number 2. Demand is by accused number 1.
Made by the accused number.
Accused number 1 ಏನಾಯ್ತು ಕೇಸ್?
Accused number 1 ದೇ ಇರೋದು.
ಇದು 1.
And my lords have considered the same point when petition number 6769 of 2020.
It may require my lords.
That's what, yes, 31st. ಅದೇನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ.
Please.
ಯಾವ್ದು ಕಾಂಟ್ರಾಕ್ಟರ್ ಅದ? ಅದು ರಿವರ್ಸ್ ಆಗಿದೆ. ಕೊಡಬೇಡಿ ಅದು. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಸ್ ರಿವರ್ಸ್ಡ್ ಅಂಡ್ ಪರ್ಮಿಟೆಡ್ ಮಂಜುನಾಥ ಏನದು?
ಜಗದೀಶ್.
ಜಗದೀಶ್.
MN Jagdish.
It is reversed. ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ?
No, my lords, I have.
But since
That's reversed. The postpaid case,
agreement has to be entered by the civil contractor between the applicant.
But if you're relying on that, sorry.
The agreement is not forthcoming.
That's my judgment. That's reversed by
Please, my lord. But this point was not considered. The very in my matter, the agreement entered by the contractor of grade 2, which is supposed to be the applicant. There is an absence of such agreement, and it is to be supported by rules also. Rule 16 of Critical Contractor Act, where that is not at all in the picture.
And without there being any formality, he cannot represent someone, be a contractor in the entire business. And that is lacking in this matter. My lord, in that case,
ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಕೊಡಿ.
that I am producing along with the rules. Please.
We'll take it on 31st.
Please, please.
List on 31st. Next to PC Act, ಅದೇನು?
Lords, fail trap.
Fail trap.
I want to place reliance on judgments. More than a few.
Fail trap, I will not permit.
Now, I don't want to eat into the time of this court, my lords. I only want to show, firstly, there is demand.
ಎಲ್ಲಿದೆ?
My lords, my statement of objections, my lords, may please have. Running page number 10, it forms part of the
ಯಾರು ಇಸ್ಕೊಂಡಿದ್ದಾರೆ?
trap. ಇಸ್ಕೊಂಡಿಲ್ಲ. ಡಿಮಾಂಡ್ ಇದೆ.
ಯಾರು ಮಾಡಿದ್ರು?
ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
ಏನಂತ?
ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ.
ಓದಿ.
ನೀವೇ ಇಷ್ಟು
ಇದು 1905 ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಸರಿ ಆಯ್ತು ಮಾಡು. ಆಮೇಲೆ
now otherwise also, my lords, what my respectful submission in terms of the compilation that I am filing is, my lords may please permit me to, please my lords may peruse the said compilation. I have given, my lords, the 1860 PC Act, IPC, where 161 was the original provision that held forth. From there, section 5 of the 47 Act, from there 88 section 7, and today the amended one in section 7 again after 2018. Everywhere, my lords, the word which undeniably used remains is attempt to obtain. What is the implication of that word, my lords? Attempt to obtain.
Implication ಇಲ್ಲ, complication ಅಷ್ಟೇ. ಏನೂ ಆಗಲ್ಲ.
ಇಲ್ಲ, ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಅದು ಬೇಲ್ ಮೇಲೆ ಇದೆ, ತಾವು ನೋಡಿದ್ದೀರಾ? Because I want to point out only one thing there, my lords. I would say,
admittedly, nobody has received the amount.
No.
Nobody. No. That is why I am saying, my lords, now it is an attempt to obtain. It is not obtained.
ಇದು ಬಿಟ್ಬಿಟ್ರೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಡಿಮಾಂಡ್ ಇರುತ್ತೆ, ಯಾರು ತಗೊಳಲ್ಲ.
ಅಲ್ಲ, ಡಿಮಾಂಡ್ ಮಾಡೋದು ತಪ್ಪು ಅಂತ.
You will hound all officers. ಒಂದು, ಯಾಕೆಂದ್ರೆ if somebody is eligible for promotion, the other candidate will set up someone to register a crime. No demand, no acceptance.
No demand iddre I fully agree, my lords.
There is no acceptance. Crime registered. Promotion deferred for 10 years.
ಅಲ್ಲ, ಅವರೇ
crime ಮುಗಿಯಲ್ವಲ್ಲ 10 ವರ್ಷ.
ಅಲ್ಲ, ಅವರೇ ಕೇಳಿದ್ರೆ ಹೆಂಗೆ? At least let him, to the satisfaction of this court, say and prove that he has not asked at all. Now, why I am saying this, my lords, is
ಇವರು ಯಾವ ಕೇಳರು?
Not my lord.
ನೀವು ಯಾರು?
I am accused number 2, my lord.
ಡಿಮಾಂಡ್ ಯಾರು ಮಾಡಿದ್ದು?
Demand, because they say that because I have demanded to
junior health inspector in Department of Urban Development, Tumkur Mahanagara Palike.
ಇಲ್ಲ, propensity ಇದೆ.
Now, I'll only try to prevail on my lords in terms of one judgment. My lords,
ಅದೇ 1905.
ಅದು ದೇವೇಂದ್ರ ಬನ್ಸಲ್ ಅಲ್ಲಿ.
Correct.
My lords, may please permit me, they say, and 1879 ಒಂದಿದೆ.
ಹೌದು, 1879 ಒಂದಿದೆ.
That also, my lords, they say, both of them, they say, are reaffirmed. And in both those cases, 1879 and 1905, there is no acceptance at all. ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ ತಾವು ಒಂದು ಬಾರಿ
ನೋಡ್ತೇನೆ,
ಪ್ಲೀಸ್. Now, my lords, it wouldn't have now been considered good law if the Honorable Supreme Court consciously in 2025 cites those two judgments and says they are affirmed. And the only excuse would, in as much as this judgment would be concerned, is, my lords, it's given in a bail proceedings. But a renunciation of law, if that is the case, my lords, all those judgments which are given in a full blown trial cannot be cited in 482. No, that would be a fallacy.
But ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ, full blown trial ಅಲ್ಲಿ principles are drawn. Bail is on the periphery.
No, but nevertheless, here, my lords, may read the tenor of the order.
No, tenor is only considered in the periphery. Bail is bail. Like how contempt ಅಲ್ಲಿ many observations are made, it remains to contempt.
In that case, my lords, they wouldn't have had to affirm the earlier position of law where that was a full blown trial. Then.
We'll see.
1879 ಒಂದು, 1905 ಒಂದು, ಇವೆರಡು ಜಡ್ಜ್ಮೆಂಟ್. My lords, I'll only read that.
We'll also answer everything. but not reserving. I'll take it on another day.
Please.
List the matter on 6th February.
I'll also file a brief synopsis
Yes,
so that my lords would.
ನೀವು ಹಾಕಿ.
Yes. Along with the citations as,
Even better.
because, your lordship, I have raised 3 counts. Because there is inquiry is initiated against me.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ
ಹೌದು.
ಅದು ಹೋಯ್ತು.
ಅದು exonerate ಆಯ್ತು.
ಅದು ಹೋಯ್ತು.
Yes.
ಅದು ಕಾನೂನೇ ಅಲ್ಲ ಈಗ.
Yes, my lord, I do
Latest
understand.
judgment ತಗೊಳ್ಳಿ.
Yes, your lordship. And insofar as trap.
Please.
PD 26 SEC online page 13.
13 now.
Chandrasekhar.
I've seen that. Recently,
yes.
I've seen that.
And demand is, it's here's a demand. The complaint, he says that his person went and through him, your lordship, he demanded the money because there is no direct evidence.
Through him?
He says that, your lordship, the complaint says that.
ಅಲ್ಲ, but telephonic conversation ಇದೆ. Now, I'm not saying, my lords, fact finding endeavor
We'll
be
see.
conducted.
Both of you files, you know.
Please, your
Please.
We'll take it on 6th.
Only reliance is that 1905 and 1879. And they stand affirmed by this judgment.
We'll do it.
That is all.
Yes.
Obliged.
Next.
Interim order may be.
So to hear them further, list the matter on 6th February. Interim order subsisting would continue to the next.
Obliged. Deeply.
Yes, next.
My lords, 44 also is a failed trap. So it may be tagged
Bandhan
along with this.
has-
As and when
Bandhan
it comes, we'll mention it. Obliged.
Next.
19.
Lord, I seek to appear for the petitioner in this case, my lord. I'm so sorry that I'm compelled to appear through VC today.
Yeah, no problem, sir. Tell me.
My lord,
ಅಂದಂದೆ ನಮ್ಮ VC ಬಿಡಲ್ಲ ಅಂತ. Yes. ಹೇಳಿ.
My lord, this is a case wherein, you know, my lord, an order was passed directing me to deposit 25 lakhs and to be paid to the complainant. But my lord, the bank had refused and did not.
No, I passed an order on 28/11/2025. What happened after that?
That, my lord, seek instructions, my lord. The government had to seek instructions, SPPA to
This court
see
on
by the bank.
28/11, one nimisha. This court on 28/11/2025 had passed the following order. The learned HCG to secure instructions as to whether the investigating officer has directed the acceptance of deposit as was directed. List the matter on 4th February.
My lord, interim order may be
Order subsisting would continue till the next date of hearing. Next, please.
20.
And for the petitioners, this is the matter. The jailer and assistant jailer, that's the.
ಇದು ಜಗದೀಶ್ ಸರ್ ಬೇಕು.
further
ಜೈಲಲ್ಲಿ ಆಗ್ತಿರೋದೆಲ್ಲ.
ಹೌದು. further investigation ಗೆ PC Act ಅಲ್ಲಿ invoke ಮಾಡಕ್ಕೆ
ಅಲ್ಲ 2024 ಅಲ್ಲಿ ಹೇಳಿದ್ರಿ ಅದನ್ನ ನಂಗೆ.
ಮಾಡಿದ್ದಾರೆ.
ಏನಾಗಿದೆ ಹೇಳಿ.
Latest status.
What is the status now?
I'll secure the latest.
The learned additional SPP to secure instructions as to what has become of the order dated 22/10/2024. The final report was directed not to be filed without the leave of the court. Therefore, the state shall place on record the report of investigation, complete report of investigation as conducted till date. Next. Fourth, yes.
21.
Petition.
I appear for the respondent number 2, my lord. The statement of objections is ready, my lord. I will just serve it to the petitioner and file it at the registry, my lord. So far as the previous date, my lord, the
Lord will see the orders passed 2008.
I know, 16 years.
Yes.
No, this again Jagdish sir. 16 ವರ್ಷ charge sheet ಹಾಕಿಲ್ಲ.
ಇದರಲ್ಲಿ ನಾವು proposal has gone to take action against the officer.
This is 26/9/2024. 2 years ಏನ್ ಮಾಡಿದಿರ?
Now the proposal, the sub-inspector then has been promoted as an additional SP. So therefore the proposal has to go to the government.
Yes.
It is, I've been told, my lord, it's pending with the DG office.
Yes.
Have it tomorrow, day after tomorrow, I'll secure.
List the matter on 4th. This, first thing barkodi. Heard the learned senior counsel Dhananjay V. Joshi appearing for the petitioner and the counsel for the complainant. This court on 26/9/2024 had passed the following order. The crime is registered in crime number 168 of 2008. As on 26/9/2024, not even a summon is issued or charge sheet was filed. Their charge sheet was filed till the said date. 16 years had passed by. There is absolute carelessness on the officers of the jurisdictional police to whom the matter was referred for investigation. The learned additional SPP submits that the departmental inquiry, na? Departmental inquiry is sought to be instituted against those officers and the proposal is pending with the hands of the Director General of Police. As the officer in charge of the police station then others have been promoted further. Therefore, the instructions be sought as to what has become of the order dated 26/9/2024 or the proposal for holding departmental inquiry, failing which the DG and IG na idu present table. Yes, next time I'll list the matter on 4th, instructions be sought and submissions be made on the next date.
Interim order.
Interim order subsisting will continue till the next date of hearing.
Great.
Great.
Next.
22.
May please, my lord. My lord, the first and second petitioners are the power of attorney holders. And the third petitioner is the assistant, please, my lord. They are respectively arraigned as accused number 1, 2, 3.
You really complainant, Swaroop.
Last time also, my lord, they sought time.
Bandidro,
they sought time.
10 days time to.
This matter I
And the-
I informed police to secure the FSL report.
But in case illa.
There is nothing. May I take my lord's attention to
nothing,
the
yeah.
allegation, please, my lord.
Nimga complainant ga.
Complainant ಏನು case ಇಲ್ಲ.
ಹೌದಾ? Oh, sorry.
May I take my lord's attention to the findings of the investigator, please, my lord, in page number 32, please, my lord. The case is essentially arising out of the civil transactions, please, my lord. Please come to page number 32, please, my lord. Page 32. ಮಧ್ಯದಲ್ಲಿ ದಿನಾಂಕ 24/6/2023 ಕಾಲಂ ನಂಬರ್ 12ರಲ್ಲಿ ಕಂಡ A1, A2
Interim order ilva?
ಇದೆ. There is an interim order in this case, please, my lord.
Heard the learned counsel KVK Swami appearing for the petitioner. There is no representation on behalf of the complainant, though had sought 10 days time to go through the papers and make his submissions on 7/1/2026. Therefore, as a last chance, list this matter on 4th. In the event he would not be present, the petition would be answered. Hearing the counsel for the petitioner, interim order subsisting shall continue till the disposal of the petition.
Obliged.
Next.
23.
Doctors,
Petitioner in this matter, my lords, I praise time, my lord.
praise time, no grants time.
Lords, have this matter on next week, my
No,
lords.
no, madam. Yes. Yavudidu? Serial number?
23, my lords.
No, madam. National Honors Act.
As last chance may be granted.
No, last chance, madam. ಎಷ್ಟು ಸರ್ತಿ ಕೇಳದ್ ನಿಮ್ನ?
ಇಲ್ಲ, last
ಅವ್ರೇನೋ
time
ಇದ್ ಮಾಡಿದ್ರು, ಅದ್ ಮಾಡಿದ್ರು.
first respondent ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Next. Interim order ಇದೆಯಲ್ಲ?
Yes, ma'am.
Interim order subsisting would continue till the disposal of the petition.
Name ಇದೆ.
ಇದು ಡಾಕ್ಟರ್ಸ್. ಎಸ್ ಜಗದೀಶ್ ಸರ್. ಅದೇ ಫೇಕ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ಹಾ ಗೊತ್ತು. ಈಗ ಆನ್ ಮೆರಿಟ್ಸ್ ಬನ್ನಿ ಸರ್.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ
ಏನ್ ಕೇಸ್ ಇಲ್ಲ.
ನನ್ಗಲ್ಲ, ಅವ್ರಿಗಿಲ್ಲ ಅಷ್ಟೇ.
ಅವ್ರಿಗಿಲ್ಲ.
ನಂದಿದ್ದೆ. I just want to, my lord, bring it to your lordship's notice.
ಪೊಲೀಸ್ನವ್ರನ್ನ ಸ್ವಲ್ಪ ಕರೆಸಿ.
Investigating officer, though he had both the own certificates in his hands, Lord, he does not look into this, and charge sheet is filed in this case.
Charge sheet is also filed, is it?
Charge sheet is also filed in this case, and then, my lord,
Investigating officer ಸ್ವಲ್ಪ ಬರಕ್ ಹೇಳಿ.
Unfortunately,
41A notice is also issued to me. They record my
misdeed
statement.
is done by the superior officer.
What is done?
Misdeed. But now a charge sheet is filed with the PSI. On record, it is done by PSI, but it is.
How do we demonstrate? Interim order ಕೊಟ್ಟಿದೀವಲ್ಲ?
ಕೊಟ್ಟಿದ್ವಿ. ಆಮೇಲೆ ಕೋರ್ಟ್ ಮುಂದೆ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ತಾನೆ ನಾವು. Complainant files an undertaking in the pending criminal miscellaneous case, saying that he will not repeat all these things. He has blamed the judges, he has blamed the lawyers. By using filthy language, he gives an undertaking to that effect.
Barely. Yes. Heard the learned counsel appearing for the petitioner. There is no representation on behalf of the second respondent. List the matter 2 weeks beyond it. Interim order subsisting will continue till the next date of hearing.
Please.
Next.
25.
Three matters. could I request my lords to have 25.1,
That's all right.
case of a second FIR, doctrine of sameness.
I pay for the respondent number
The
2.
relevant
All right.
3 documents of,
Ready ಇದಿರಲ್ವಾ?
Yes.
Yes.
3 documents of relevance, my lords. The first FIR, my lords should get it at page 23.
Prasad sir.
In case, my lord, I also filed one petition for further
ಆಯ್ತು,
investigation.
ಆಯ್ತು. Wait, I'll come back to you. ರೆಡಿ ಇದಿರಲ್ವಾ?
Tomorrow, my lord.
ನೀವು ಯಾವಾಗಲೂ ರೆಡಿ ಇರ್ತೀರಾ ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ. Yes.
Tomorrow, my lord.
ಇವತ್ತೇ ರೆಡಿ ಇದೆ. Yes. No tomorrow.
Page 23.
Which I'm holding 13611.
Well, it's criminal petition 5887 of 2023.
All right. Yes.
Page 23. Complainant is one Rajanna. Well, the accused at page 24, accused 4 to 8 are the petitioners before my lords. 4 to 8 may be noticed here. Nagraj, Manjunath, Nikhil, Anasuya and Shilpa. Now this complaint we had challenged and my lords was pleased to stay this FIR at page 33. The order of stay at page 34, my lords. So far as SC/ST Act, it remains stayed. 7 and 8, no offense, absolute stay. Then, my lords, interim order of other accused, it will be considered after the appearance of the second respondent. Now, this order was passed on 28th June 2023. 5 days after this comes the second FIR, which is registered by the wife.
Same day.
5
Same
days,
incident.
Same incident in a different police station.
Now, which is that?
Second FIR, my lords would get this at page 12.
That is 3/7/2023 incident.
Yes, my lords. Very same, and the accused may be noticed, my lords, on the next page.
Same accused.
A3 to A7 were the petitioners before my lords. So, my lords, on the principle of doctrine of sameness, this FIR has to go.
Which the FIR in crime number 206 of 2023.
Yes, my lords.
That should go.
Yes, my lords. It has to go on the ground of doctrine of sameness, my lords. So far as the first FIR is concerned, investigation took place, and after the charge sheet was filed, my lords, petitioners were left off from the charge sheet. Charge sheet was filed against the other accused. Now, the first petition that we have at serial number 25 today is, they're asking for further investigation insofar as that FIR is concerned, which in my respectful submission could be done by the magistrate, my lords, because magistrate would have the power of directing further investigation.
Wait, I don't have.
My lords, I would point out 3 judgments. My lords has the power, but my lords, what Supreme Court would hold is, my lords, of the 3 powers that the magistrate has when a charge sheet is filed,
No doubt.
one power is that of further
173(8)
investigation
he has.
under 156(3).
156(3)
Now, without even
further
yes, my
investigation,
lords,
yes.
without approaching the magistrate court, in the first matter, they would seek the prayer of saying, have further investigation against them.
Yeah, 1 ನಿಮಿಷ. 13611 is filed by the complainant.
That's serial number 25. Yes, my lords.
13611.
And the prayer is further investigation.
Praise direct the respondent to conduct further investigation into the matter.
In this case, my lord, I am for the petitioner.
Correct, sir.
In this case, my lord, this honorable High Court, my lord, granted the interim order. One moment, kindly see, my lord, page number 39.
1 moment, sir.
Even though the interim order is there,
39.
page number 39.
ಏನಾಯ್ತು ಹೇಳಿ?
Even though interim order is there, as I can say, the accused number 8 to 11, they'll find a B report. Saying that, my lord, there is no, not to investigate the matter. Even then, my lord, they investigated the matter and only to favor the accused number 8 to 12, they find a B report. And
ಅದು protest petition ಹಾಕ್ಲಿಲ್ವಾ?
Pardon?
Protest petition ಹಾಕ್ಲಿಲ್ವಾ?
Because the matter is seized before the Honorable High Court when that writ petition was pending at the time of filing this writ petition, and they also challenged that initiation of proceedings. That is the reason for further investigation. I filed this.
All right, we will direct further investigation to be
My
conducted.
lords, could I just pass on this 2023?
No, which was the interim order granted? Where is the interim order?
My lords, if my lords has 5887, the interim order is at page 33. So if that petition is taken first, my lords, to notice the doctrine of sameness so far as the second FIR is concerned.
One moment. Which is the interim order?
Interim order, page 33, dated 28th June 2023.
One moment. In which case was this?
My lords, the first FIR.
Crime number?
My lords, this is crime number
218 of
218 of 2023.
218 of 2023.
Yes, my lords.
All right.
Husband is the informant. Husband Rajan is informant. And the order of state.
Now, one moment. B report is filed in which case?
B report is filed in this case, not a B report, my lords. A final report where some of them are arraigned as a accused. Against some of them, it is dropped.
Yes.
Now, as against the persons it is dropped, is their petition asking for further investigation, which is serial number 25. But coming back to this case first, my lords, on doctrine of sameness, my lords should notice the order.
We will quash that.
Yes, my lords. My lords, order in.
Now, 218, in crime number 218, when was the interim order granted?
That petition has been withdrawn. They filed for quashing and that petition was withdrawn.
This is withdrawn, is it?
No, that.
5387 criminal petition is withdrawn?
Yes. That was
withdrawn.
One minute, my lords. That is, my lords, criminal petition 5387 of 2023, my lords, which is challenging the first FIR where there was an interim order. Interim order. Subsequently, was this withdrawn?
Yes, it was withdrawn.
My lords, because may point out, my lords, subsequently, when
because you were left out.
Final report I was left out, I withdrew it, my lords.
That's
But during the existence of this interim order comes the second FIR, which in my respectful submission is hit by the doctrine of sameness, my lord's judgment in Bairegowda's case, my lords, and which is followed by now Supreme Court also same view.
Yes.
So, my lords, if this matter first is taken up and decided, my lords, then I will come to serial number 25, further investigation. In further investigation, my lords, I've just given a judgment of the Supreme Court, maybe noticed, my lords, that portion. 2023, the portion, I'm sorry, my lords, I've highlighted it.
That's all right.
How it would be the responsibility of the.
Thank you for highlighting. It saves our time.
Some places they feel.
No. They're gone are those days, sir. Yes.
And finally, 45.4 may be noticed after all that, my lords, how it should be done. If at all there is a case for further investigation, magistrate would look into it to see whether there's a requirement of further investigation. Then 45.4.
If you are dropped from the.
Yes, my lords.
Dropped from the array of accused. If the prosecution wants it or complaints, 319 is always available.
At a later point of time.
Yes, at a later
on the
point
basis
in
of
time.
evidence, it's always available. But if they still say they still want a further investigation, that power is available with the magistrate under 156(3).
No, that is.
And that is what the court says, my lords.
Available.
First is they have to approach magistrate, convince the court why there's a need of a further investigation, and then when it comes to the exercise of 482, they say it has to be done very sparingly after this exercise is done. Now here directly an application is filed, my lords, because the third matter, my lords, is 25.2.
ಅದಾಯ್ತಲ್ಲ ಡ್ರಾಪ್ ಆಗಿದ್ದೀರಾ ಓ ನೀವು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ
because they have filed charge sheet against me for even the SC/ST. My role is very limited. I work as a mediator and astrologer. I have introduced the one main accused person to the. I have the introducer. That's it. I have not taken single rupee.
No, I'll make.
I'll get back.
And they invoke section 3(2) of 325 of SC.
Atrocities.
Atrocities. For invoking 325 judgment, the offences must be IPC offences must be more than 10 years. Here, in the charge sheet, they have invoked section 419 up to punishable 3 years, and 420 7 years, 465 2 years, and 468 7 years. They will know section 3 to 5 of the SC/ST Act.
ನೀವು ಅಸ್ಟ್ರಾಲಜರ್
Astrologer.
ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ ಅಂತ?
ಗೊತ್ತಾಗಿಲ್ಲ madam.
ಅಯ್ಯೋ ಮತ್ತೆ ಫೇಲ್ಡ್
They are part of the same conspiracy.
astrological conspiracy
No conspiracy.
I will narrate.
or astronomical conspiracy.
ಎರಡೂ ಇದೆ.
No such, no
Lord.
single document.
ನಿಮ್ಮ ಮೇಲೆ ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಮಾತ್ರನಾ?
Atrocities and also the IPCs, my lord. 420 and 120B. Initially, my lord,
420.
420. Initially, they invoked section 392 of IPC. Then subsequently, it is dropped during the course of investigation. And now, my lord, the specific allegation against me is that, my lord, I introduced the other accused person to the complainant. That is the allegation. I have not taken single rupees from the complainant.
ಅಸ್ಟ್ರಾಲಜಿ ಹೇಳಕ್ಕೂ ತಗೊಳ್ಳಿಲ್ವಾ?
They found it in
ಮತ್ತೆ.
purpose I have not taken.
ಪ್ರೊಫೆಷನಲ್ ಫೀ.
Professional fees I have charged, my lord. Even as against
ಹಾ
other
ದಿನೇಶ್ ಹೇಳಿ.
May I take my?
Ask your client to sit back.
You please stand.
Did I call him? Yes.
May I take your lordships to my statement of objections I have filed?
ಈಗ ಫಸ್ಟ್ ಒಂದ್ ನಿಮಿಷ.
The
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹೇಳ್ದಂಗೆ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಸೇಮ್ನೆಸ್ ಮೇಲೆ ಅದು ಹೋಗುತ್ತೆ. That crime should go.
I'll make my submissions on that.
No, you can't keep, why husband and wife can't register crimes after crimes on the same incident?
I'll substantiate why it is. Not the doctrine of sameness is applied so that there is no double jeopardy for the accused.
No double jeopardy concept alla adu.
And article
Multiple FIRs cannot be registered on the same incident. Yes.
though arising out of the same incident.
Yes, sir.
In the subsequent facts and circumstances.
ಅದ್ರಲ್ಲೇ ಹಾಕೊಳ್ಳಿ ಎಲ್ಲ.
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ
218 ಅಲ್ಲೇ ಎಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ.
In the subsequent facts and circumstances that have taken place.
What is the time gap between the first
Offenses,
husband
new
registration and wife registration?
Yes, my lord.
Time gap ಎಷ್ಟು?
Time gap one ತಿಂಗಳ ಇರುತ್ತೆ.
1 month.
15/6/2023 is the first FIR, my lords.
Husband.
Yes, my lords. The interim order granted by my lords is dated 28 June 2023. 5 days after the interim order is granted.
After the interim order, wife registers.
Yes, my lords. 5 days after the interim order is granted, on 3/7/23, the wife gives his complaint.
All right.
There are new facts which are discovered.
Discovered. ಅದಕ್ಕೆ ಹಾಕೊಳ್ಳಿ ಎಲ್ಲ.
ಅದಕ್ಕೆ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದೇವೆ. ಈಗ the transaction was that they had to provide us funds.
For what?
For contesting an election.
Contesting election.
Oh, allegations in the complaint are that
election?
I was induced.
ಯಾವ election?
MLA election. I was induced by these accused persons stating that funds should be provided to contest the election by showing DDs and that we had to pay certain amount.
ಎಷ್ಟು ಕೊಟ್ರಿ?
And give our properties.
ಅದು ಎಷ್ಟು ಕೊಟ್ರಿ?
From 5 crores payment ಆಗಿದೆ.
ಪೇಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಹೆಂಗಾಗಿದೆ? ಆನ್ಲೈನ್?
ಹೌದು, ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ.
ಅಲ್ಲ ಹೆಂಗ್ ಪೇ ಮಾಡಿದ್ರಿ 5 crores?
5 crores are paid. They said that.
ಹೌದು ಸರ್.
Yes, sir. Under an agreement of sale, they said that if you are not able to pay the amount, you execute agreement of sale in respect of your properties. And in that, we will arrange the money for you and we will encash it. Thereafter, your funds will be released. So agreement of sale at annexure R1 to R4 I have produced. These are my properties and my husband's properties and my brother's properties. Where they called us to register this agreement of sale, promising that they will give us the funds. After execution, they showed suppress the, though transaction was for 60 crores and odd, they have registered for only less amount, 12 crores 60 lakhs.
ಏನ್ನ?
ಈ ಸೇಲ್ ಡೀಡ್ಸ್ ಈ ಅಗ್ರಿಮೆಂಟ್ಸ್ ಅನ್ನ.
ಅಗ್ರಿಮೆಂಟ್ಸ್ ನೀವು ಸೈನ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಅದನ್ನ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಅಲ್ಲ ನೀವು ಸೈನ್ ಮಾಡಿಲ್ವಾ?
ನಾವು ಮಾಡಿದ್ದು
ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್.
ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್ 60 crores ಗೆ ಅವರು ಮಾಡಿದ್ದು.
ಆಯ್ತು.
ಬಟ್ ಅಲ್ಲಿ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ ಹಾಳೆಗಳನ್ನ.
ಎಲ್ಲಿ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ?
ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್ ಅಲ್ಲಿ.
ಓ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆದ್ಮೇಲೆ.
When the scanning takes place, they have exchanged this and got it down for 12 crores 60 lakhs.
Sub registrar is office also is accused ಅವರೆಲ್ಲ?
Yes, I am naming them also as accused.
ಅಲ್ಲ are they accused now?
No, my lord.
They are not accused. So now I have discovered this because these are pending registration. Pending registration ಇನ್ನು complete ಆಗಿಲ್ಲ. ಈ pending registration I have discovered this now. Now these new facts have come into place where new offences have also been committed, which is not the subject matter of the old FIR. So ಆದ್ರಿಂದ.
ಬಟ್ ನೀವು ಯಾವ ಇನ್ಸಿಡೆಂಟ್ ನರೇಟ್ ಮಾಡ್ತೀರಾ ಸೆಕೆಂಡ್ FIR?
ಸೇಮ್ ಇನ್ಸಿಡೆಂಟ್ ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ದಿ ಸೇಮ್
ಇನ್ಸಿಡೆಂಟ್ ಅಲ್ಲ ಹಾಕೊಳ್ಳಿ. ಎಷ್ಟು FIR ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಸೇಮ್ ಇನ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ ಅರೈಸ್ ಆಗಿದೆ ಬಟ್ ನ್ಯೂ ಅಫೆನ್ಸಸ್ ಆರ್
ನೀವು
ಡಿಸ್ಕವರ್ಡ್.
ಈಗ ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ರಿಜಿಸ್ಟರ್ ಆಯ್ತಲ್ಲ, ಎಷ್ಟು ಅಮೌಂಟ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು?
12 crore 60 lakhs.
ಅಮೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಅವ್ರಿಗೆ?
ಅಮೌಂಟ್ ಇಲ್ಲ, ಅವ್ರು ನಮಗೆ ಅಡ್ವಾನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಯಾರು?
ನನಗೆ ಅಡ್ವಾನ್ಸ್ ಕೊಟ್ಟು ಮತ್ತೆ ಅದನ್ನೇ ಅವರು ತಗೊಂಡಿದ್ದಾರೆ ಆಸ್ ಕಮಿಷನ್. ಬೇರೆಯವ್ರ ಹತ್ರ
ದೇವ್ರ ಹತ್ರ
ಅಲ್ಲಲ್ಲ. ಈಗ there are many accused. These petitioners have conspired to register the sale agreement, stating that we'll register it for 60 crores, and they have exchanged the pages. 12 crore 60 lakhs.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅವರು ಅಲ್ಲಿ ಸ್ಕ್ಯಾನಿಂಗ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡ್ಬೇಕಾರೆ? ಸೈನ್ ಮಾಡ್ಬೇಕಾರೆ ನೋಡ್ಲಿಲ್ವಾ ಏನು ಅಂತ? You wanted to contest for elections, but you should know everything. ಯಾವ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ
ಇದು? ನೆಲಮಂಗಲ.
ನೆಲಮಂಗಲ.
Those advances which are shown in this agreement, they themselves have taken it back. They have asked me to collect, and again they have taken it back.
Why did you give it back?
Because I wanted the 50 crores, 49 crores.
Oh, exchange.
So
then where did you meet this astrologer?
Somebody told that to contest the election, I have to go to the astrologer.
ಯಾಕೆ? ಓ, ಅಂದ್ರೆ
and check whether our horoscopes are okay to contest the election. ಅವ್ರು ನನಗೆ ಮತ್ತೆ ಟೆಂಪಲ್ ಗೆ ಕಳಿಸಿದ್ರು. ಟೆಂಪಲ್ ಗೆ ಹೋಗಿ ಬಂದೆ. ಆಮೇಲೆ ಅವ್ರು ಬಂದು ಅವ್ರಿಗೆ ಗೊತ್ತಾಯ್ತು ನನಗೆ ಫಂಡ್ಸ್ ಬೇಕಂತ. ನಮ್ಮ ಹತ್ರ ಫಂಡ್ಸ್ ಇದೆ, ನಮ್ಮ ಹತ್ರ ರೆಡಿ ಇದೆ, ಡಿಡಿ ಇದೆ ಅಂತ ಡಿಡಿ ತೋರಿಸಿದ್ರು. ಇವ್ರನ್ನ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು, ಕರ್ಕೊಂಡು ಹೋದ್ರು. ಎಲ್ಲ ಮಾಡಿ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಸೆಕ್ಯೂರಿಟಿ ಕೊಡಿ, 5 ಕೋಟಿ ಕಮಿಷನ್ ಆಗತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು.
ಆಯ್ತು, ಈಗ ಅಗ್ರಿಮೆಂಟ್ಸ್ ಆಫ್ ಸೇಲ್ ಮಾಡಿದ್ರೆ
ಏನಂದ್ರೆ ಮೈ ಸಿಂಪಲ್
ನಿಮಿಷ ದಿನೇಶ್, ಈ ಅಗ್ರಿಮೆಂಟ್ಸ್ ಆಫ್ ಸೇಲ್ ಮಾಡಿದ್ರಲ್ಲ,
ಹೌದು,
ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಇನ್ ದೇರ್ ಫೇವರ್.
ಹೌದು,
ಅದನ್ನೇನ್ ಮಾಡಿದ್ರು ಅವರು?
ಅವ್ರು ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಮಾಡ್ಕೊಂಡ್ರು. ಹಣ ಏನು ಬಂತು ಅಲ್ಲಿಂದ ಇದರಲ್ಲಿ ಅವರೇ ತಗೊಂಡ್ರು.
ಈ ಪ್ರಾಪರ್ಟಿ ಯಾರ ಹತ್ರ ಇದೆ?
ಪ್ರಾಪರ್ಟಿ ನನ್ನ ಹತ್ರ ಇದೆ.
ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಏನಾಗಿದೆ?
ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಅಷ್ಟೇ, ಪೆಂಡಿಂಗ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿದೆ. ಸೊ ಈ ಪೆಂಡಿಂಗ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆದ್ರಿಂದ ಡೀಡ್ ನನಗೆ ಯಾವ್ದು ಸಿಕ್ಕಿಲ್ಲ, ಅವ್ರಿಗೆ ಸಿಕ್ಕಿಲ್ಲ, ನನಗೂ ಸಿಕ್ಕಿಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ, ವಾಟ್ ಅಗ್ರಿಮೆಂಟ್ಸ್ ಆಫ್ ಸೇಲ್ ಏನ್ ಮಾಡಿದ್ರಿ? ಎಲ್ಲ
agreement of sale in respect of petition still pending, because we filing the multiple complaints against us because of we are not
cancel ಮಾಡಿ agreements of sale.
Yeah, he has to pay 2 crores.
Who?
Yes, we paid through demand draft and by way of check. All checks are realized.
Yes, you have taken 2 crores.
We filed up false cases.
So
ಅಲ್ಲಿ 2 ಕೋಟಿ ನಿಮಗ್ ಬಂತಾ?
ಬಂದಿದೆ.
ಬಂದು ಅವರೇ ತಗೊಂಡಿದ್ದಾರೆ ಕಮಿಷನ್ ಅಂತ.
ಹೆಂಗ್ ತಗೊಂಡ್ರು? ನಿಮಗ್ ಬಂದಿದ್ದು ಆನ್ಲೈನ್?
ಹೌದು, ನಾನೇ ಕೊಟ್ಟಿದ್ದು.
ಆಫ್ಲೈನ್ ಕೊಟ್ರ ನೀವದ್ನ?
ಇಲ್ಲ, ಆನ್ಲೈನ್ ಕೊಟ್ಟಿದ್ದೆ. ಪೇಮೆಂಟ್ಸ್ ಹ್ಯಾವ್ ಗಾನ್ ಟು ದಿ ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸ್ಫರ್ ಹೋಗಿದೆ. My submission is simple on the doctrine of sameness. See, these agreements were discovered later. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ, ತಪ್ಪಾಗಿದೆ ಅಂತ. So there has been falsification of these documents where new offenses arise. Incident ಸೇಮ್ ಇರ್ಬೋದು, ಸೇಮ್ ಇನ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ 2 FIR ಆಗಿರ್ಬೋದು, but new offenses have taken place where the falsification.
You don't narrate about new offense, only that 13/7/2023 offense ಹೇಳೋದು ಎರಡರಲ್ಲೂ. How can it sustain? No,
there are facts which have.
ಆತರ ನೀವು ಇನ್ನೊಂದು ವರ್ಷ ಬಿಟ್ಟು ಇನ್ನೊಂದು ಹೊಸದೆಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್ ಗೊತ್ತಾಗುತ್ತೆ, ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಕ್ರೈಮ್ ಆ ಡೇಟ್ ಇದೆ.
ಇಲ್ಲ, I will
ಕೊಡಿ
produce this citation.
Yes sir, ಲೇಟೆಸ್ಟ್ ಒಂದಿದೆ, ಮಲ್ಟಿಪಲ್ FIRs ಯಾವಾಗ ರಿಜಿಸ್ಟರ್ ಮಾಡಬಹುದು ಅಂತ ಕೊಡಿ.
ಸ್ಟೇಟ್ ಆಫ್ ರಾಜಸ್ಥಾನ್ ವರ್ಸಸ್ ಸುರೇಂದ್ರ ಸಿಂಗ್ ರಾಥೋರ್ ಒಂದು ಬಂದಿದೆ,
ಹೊಸದೇ 2025 ಕೊಡಿ. ಅದು ಇನ್ವೆಸ್ಟರ್ಸ್ ನ ಎಲ್ಲಾ ಕಡೆ ಹುಡ್ವಿಂಕ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ರು, ಅದಕ್ಕೆ ಇಂಡಿಪೆಂಡೆಂಟ್ FIRs ಕ್ಯಾನ್ ಬಿ ರಿಜಿಸ್ಟರ್ಡ್, ಮಲ್ಟಿಪಲ್ ಕ್ಯಾನ್ ಬಿ ಅಂತ.
5 points which have been narrated there. But doctrine of sameness remains the same.
No, doctrine of remains. But the old ratio that no second FIR can be done.
No. There was no ratio even in TT Anthony when it can be done antane helidare. When it cannot be done anta last 4 lines of paragraph 20, I guess it is said that when it cannot be done. When it can be done also is said in TT Anthony.
In paragraph 8.2. Paragraph 8.2 in Kari Chaudhary versus Sita Devi, this court held. The learned counsel adopted an alternative contention that once proceedings initiated under FIR so and so ended in a final report, police had no authority to register a second FIR and number it as FIR so and so. Of course, the legal position is that there can be no 2 FIRs against the same accused in respect of the same case. But when there are rival versions in respect of the same episode, there would normally take they would normally take the shape of 2 different FIRs, and investigation can be carried on under both of them.
Adral facts nodi yak barudru anta.
Same investigation agency.
Alla facts nodi yak barudru.
Yes, ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಕೆಳಗೆ ಹೇಳಿದ್ದಾರೆ. Even that apart, the report submitted to the court styling is FIR so and so need to be considered as information submitted to the court regarding the new discovery made by the police during investigation that persons not named in the FIR so and so are real culprits. To quash the said proceedings merely on the ground that final report has been laid in FIR so and so is, to say the least, too technical. The ultimate object of every investigation is to find out whether the offense alleged have been committed, and if so, who have committed it. Even suppose this is quashed, ಆ offense ಏನು commit ಆಗಿದೆ,
ಅದ್ರಲ್ಲಿ ಸೇರಿಸ್ಕೊಳ್ಳಿ ಎಲ್ಲ ಹಳೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಸೇರಿಸ್ಕೊಳ್ಳಿ.
then in the
that is the principle of law.
Now the serial number 25 re-investigation has been sought in the same old this.
Adu I will permit you to seek it before the land magistrate, you seek it there.
Now there are allegations against the investigating officer also.
Adu alle ಮಾಡಿ.
Who has deleted these accused, who are the real conspirators. Larger conspiracy ಏನಿದೆ ಅವರನ್ನು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿಲ್ಲ.
If further investigation they can be drawn by the order of the magistrate. If you find it, then yes.
From 16/6/2023 to 9/9/2023, till 9/9/2023, the investigating officer issued 4 notices to the complainant. He has not appeared before the IO and he has not given further statement.
Why ನೀವು ಹೇಳಿಲ್ವಾ ಅವ್ರಿಗೆ?
ಅವ್ರು ಬರಲಿಲ್ಲ ಸರ್, ಅದನ್ನು ಕೇಳಕ್ಕೆ
ಅದಕ್ಕೆ ಅಸ್ಟ್ರಾಲಜಿ ಕೇಳಲಿಲ್ವಾ?
4 times IO issued. It is part and parcel of the charge sheet. And suddenly he comes before the honorable court and is filing his petition.
ಈಗೆಲ್ಲ ಇದು ಸೇವ್ ಆಗ್ಬೇಕಾಗಿರೋದು ಅಲ್ಲಿ 2 ಕೋಟಿ ಕೊಡಬೇಕು, ಇಲ್ಲೊಂದಷ್ಟು ಕೊಡಬೇಕು, ಅದಕ್ಕೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು. ಎಲ್ಲ ಅದಕ್ಕೆ ರಿವಾಲ್ವಿಂಗ್ ಅರೌಂಡ್ ದಟ್. ಕಂಟೆಸ್ಟ್ ಮಾಡಲಿಲ್ಲ, ದುಡ್ಡು ಹೋಯ್ತು, ನೀವು ನಿಮಗೆ ಕೊಟ್ಟಿರೋ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಲ್ಲ, ಅದಕ್ಕೆ ಕ್ರೈಮ್ಸ್ ಆಫ್ಟರ್ ಕ್ರೈಮ್ಸ್ ಕೊಡ್ಬೇಕು ದುಡ್ಡು ಅಂತ.
ಇಲ್ಲ ಇದು ರಿಜಿಸ್ಟರ್ ಮಾಡಿ.
What else, sir? Yes, anyway, we'll dictate at 2:30. ಇದು ಕೊಡಿ ಚೋಟಾ ಸರ್.
Both my lord's decision where TT Antony and the latest one, the 5 points which are there doesn't come within that.
We'll dictate at 2:30. ಇವತ್ತೇನು 3:30ಗೆ ಹೇಳ್ದಿಲ್ಲ, sit up to 6 o'clock. So,
but despite that, my lord sat at 10 o'clock.
ಅಲ್ಲವಾ, because I no list issue ಆಗಿದೆ.
That's one judgment of 3 to 5.
ಟಿಕೆಟ್ ಸಿಕ್ತಾ?
ಇಲ್ಲ ಇನ್ನು ಫಂಡ ಇಲ್ಲ, ಟಿಕೆಟ್ ಇಲ್ಲ.
ಟಿಕೆಟ್ ಸಿಗ್ಲಿಲ್ವಾ?
ಫಂಡ ಇಲ್ಲ, ಟಿಕೆಟ್ ಸಿಗಲ್ಲ.
ಯಾವ ಪಾರ್ಟಿ?
ಕಾಂಗ್ರೆಸ್.
ನನಗೂ ಗೊತ್ತಿಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ.
ಅವರೇ ತಾನೇ ಅರೇಂಜ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಫಂಕ್ಷನ್, ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ. ನೆಕ್ಸ್ಟ್ ಇಟ್ಟಿರಿ ಮೇಡಮ್ ಜೊತೆಗೆ.
26 for the petitioner, madam. Kindly have it next week, please.
1 minute, madam. List ಇದೆ. List.
498 offense. I'm totally stranger, landlord.
Param. Cost. Anything else?
Complaint one, sir.
Ready.
Page number 15. 4th line. ಈ ಮದುವೆಗೆ ನನ್ನ ತಂದೆ ತಾಯಿಗಳು ಸುಮಾರು 3 ರಿಂದ 4 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿ ಮದುವೆಯಾದ ನಂತರ ನನ್ನ ತಂದೆ ವಿಘ್ನೇಶ್ವರ ನಗರದಲ್ಲಿ 2 ಲಕ್ಷ ಹಣವನ್ನು ನೀಡಿ ಮನೆಯನ್ನು ಭೋಗ್ಯಕ್ಕೆ ಹಾಕಿ ಇಟ್ಟುಕೊಟ್ಟಿದ್ರು. ಅಲ್ಲಿಂದ ಸೀದಾ ಕೆಳಗೆ ಬಂದೆ ಲಾಸ್ಟ್ 4 ಲೈನ್. ಆಮೇಲೆ ಮಕ್ಕಳ ಸ್ಕೂಲಿಗೆ ಹತ್ತಿರವಾಗಲೆಂದು ನನ್ನ ತಂದೆಯು ಆ ಮನೆಯನ್ನು ಖಾಲಿ ಮಾಡಿಸಿ 4 ಲಕ್ಷದ ಜೊತೆಗೆ ಮತ್ತೆ 2 ಲಕ್ಷವನ್ನು ಸೇರಿಸಿ ಒಟ್ಟು ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ವಿಘ್ನೇಶ್ವರ ನಗರದ ಮರಿಯಾ ಸದನ ಸ್ಕೂಲ್ ಹತ್ತಿರ ಮನೆಯಲ್ಲಿ ಭೋಗ್ಯಕ್ಕೆ ಹಾಕಿಸಿ ಕೊಟ್ಟರು. ಈ ಮನೆಗೆ ಬಂದ ಮೇಲೆ ನನ್ನ ಗಂಡನು ಮನೆಯ ಮಾಲೀಕರ ಮಗಳಾದ ಗಿರಿಜಾರೊಂದಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧ ಇಟ್ಟುಕೊಂಡು ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಮರ್ಡರ್ 323
ಏನು ಅಸಾಲ್ಟ್ ಮಾಡಿದಾರಾ? ಎಲ್ಲಿದೆ? ಏನು ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ರು? ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ರು
all together. Accused number 1.
Anything else, sir? The petitioner is ಇದಕ್ಕೆ ಯಾಕೆ ಟೈಮ್ ಬೇಕಾಗಿತ್ತು? Why do you need time?
No, I just want the reason behind I was implicated is
the petitioner.
One more submission.
Anything else?
Subsequently, the lease amount given by the father of the complainant, when he asked for return the same, my lord, ಅದು ರೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ ಅಂತ ಆ ದುಡ್ಡನ್ನು ಸಹಿತ
ಅದು ಬೇರೆ ಪ್ರೊಸೀಡಿಂಗ್, ಅದಕ್ಕೆ 498 ಬರುತ್ತೆ. The petitioner is before this court. Petitioner accused number 4 is at the doors of this court calling in question registration of the crime for offence punishable under section proceedings in CC 8026 of 2024 registered for offence punishable under Section 498A, 323, 504, 506, and 3 and 4 of the Dowry Prohibition Act. Heard so and so. Facts in brief, germane, are as follows. The petitioner is accused number 4. Accused number 1, the second respondent is the complainant, wife of one Uma Maheshwar, accused number 1, who is not before the court. The marriage between accused number 1 and the complainant is said to have turned sour. On the relationship turning sour, it transpires that the wife has registered a complaint against several members of the family and the present petitioner for present petitioner, which becomes a crime in crime number 97 of 2024 for the aforequoted offences. The police, after investigation, have filed a charge sheet drawing the petitioner also into the web of proceedings as accused number 4. The registration of the proceedings, the filing of the charge sheet has driven the petitioner accused number 4 to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the accused number 4 is allegedly said to be a paramour who cannot be drawn into the web of proceedings under section 498A of the IPC and any other offence. The learned counsel appearing for the complainant submits that though 498A cannot be against a paramour or even the offences under the Dowry Prohibition Act, the other offences of 323, 504 and 506 are clearly met against the present accused number 4, therefore would seek dismissal of the petition insofar as those offences in the least, but would contend that even 498A is entertainable against a paramour who has been instrumental for the disturbance in the family of the accused number 1 and the complainant. The learned HCGP would toe the lines of the counsel appearing for the petitioner, appearing for the complainant. I have given my so and so, therefore narrated so and so. The relationship between the parties are as afore narrated. The accused number 4, the present petitioner, is admittedly a stranger who is said to be a paramour of the accused number 1. The complaint is registered by the complainant, which triggers the registration of the crime. The complaint so registered reads as follows, page 14 to 16. In the entire complaint, the narration against the petitioner is that when the parents shifted the house of the husband to be nearby to a particular school, the husband has developed an illicit relationship with the present petitioner. And when the advance amount that was sought, advance amount was lease amount was demanded by the complainant, investigation file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows. If the complaint and the charge sheet are read in tandem, what would unmistakably into the web of crime, she being a paramour and not a member of the family, alleged paramour and not a member of the family. It is settled principle of law, a total stranger, a neighbour or a paramour cannot be drawn into the web of crime for offences punishable under section 498A in particular. Insofar as the other offences, i.e. 323, 504 and 506 of the IPC are concerned, the ingredients of section 504 and 506 are found in section 503. Section 503 reads as follows. The interpretation of section 503 need not detain this court for long or delve deep into the matter. The apex court in Muhammad Wajid so-and-so 2023 SSC Online SC page 951 considers and elucidates what would become an offence under section 504 and 506. None of those ingredients are found either in the charge sheet, either in the complaint or in the charge sheet. What remains is offence under section 323 for which there is no wound certificate that would indicate that the petitioner has assaulted the complainant. In the absence of all these things, a paramour is sought to be drawn into the web of proceedings under the offence punishable under 498A, which is essentially a dispute between the family members. A petition deserves to succeed. Allowed cost. Yes, next.
27.
KP Act.
Accused number 15.
ಬೇರೆಯವ್ರದೆಲ್ಲ ಏನಾಗಿದೆ?
ಯಾರು ಹಾಕಿಲ್ಲ, ಇವರೊಬ್ಬರೇ ಹಾಕಿ
ಫಸ್ಟ್ ಬಂದಿದ್ದೀರಾ, ಹಂಗಾರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಬೇಡ. ಅದೇನ ಮಾಡುವ
covered by decision.
ಗೊತ್ತು ಕೊಡಿ ಇದು ಎಸ್ 7980 KP Act.
Please.
No permission.
ಇಲ್ಲ permission ಇದೆ. But it's a skill game. It is not a game of chance.
ಅಂದರ್ ಬಾಹರ
ಅಂದರ್ ಬಾಹರ್.
ಹಂಗಾರೆ ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡ್.
ಅಂದರ್ ಬಾಹರ್ ಕೊಡಿ.
ಧಾರವಾಡ ಬೆಂಚ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ has taken a meeting. IB meeting.
IB ನಲ್ಲೇ ಆಡಿದೆ. ಗವರ್ನಮೆಂಟ್ IB.
ಯಾರು ಗವರ್ನಮೆಂಟ್ ಆಫೀಸರ್ಸ್ ಅವರು?
ಗವರ್ನಮೆಂಟ್ IB meeting. Is in charge of IB.
ಯಾರು ಇರಲ್ಲ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಬಂಗ್ಲೋ ಅಂತ ಇದೆ ಪ್ಯಾಲೇಸ್ ಬಂಗ್ಲೋ ಯಾರು ಐಬಿ ಇದೆ.
Select a para number.
Almost 2.8
number
lakh
5
rupees, 2.8 lakh rupees is recovered
ಫ್ರಮ್ ದೆಮ್
from the place.
ವಾಪಸ್ ಕೊಡ್ಬೇಡಿ ಅಷ್ಟೇ. ವಾಪಸ್
Actually ಇವರೇ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟಿದ್ದು.
ಯಾರು ಐಬಿ ಅವರ?
ಐಬಿ ಅವರು ಇವರೇ ಬಾತ್ಮೀದಾರರು. Actually ಇವರನ್ನು ಅಕ್ಯೂಸ್ ಮಾಡಿದ್ರು.
ಇವರೇ ರೂಮ್ ಕೊಟ್ಟು ಇವರೇ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಇವರೇ ಬಾತ್ಮೀದಾರ.
ಯಾರೋ ಸೋತ್ ಬಿಟ್ಟಿದಾರಲ್ಲಿ ಅವರೇ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ರು. I will close this. Yes.
The amount shall not be.
Same order.
Amount shall not.
ಅದ್ರಲ್ಲಿಲ್ಲ ಬಿಡಿ. Yes. Petitioners are before this court so and so. The land counsel for the petitioner submits the issue in the list and answered by the judgment rendered by the coordinate bench so and so. Reasoning in the ಹಾಕ್ಬಿಡಿ. And doubt is the chamber.
28.
The load cost. Yes.
Lordship, I am for the petitioner, your lordship. The matter is settled, your lordship. However, the connected matter is not listed.
Parties are present.
No, your lordship. It may be listed tomorrow, your lordship. Connected matter may be tagged along.
The complainant is present.
The
Chet
petitioner is
ಅದ್ಯಾವ್ದು
not
ಮ್ಯಾಟರ್ ತರ್ಸೋಣ ಕೊಡಿ.
Your lordship, he has to travel from Shivmoga, your lordship. It may be posted tomorrow.
Right, tomorrow.
Writ petition number 17690.
ಹಾಕ್ಸ್ಬಿಡಿ ನಾಳೆ.
Interim order may be extended.
Interim order subsisting will continue to the next date of hearing. Yes, next.
29.
Darshan. 498.
Paramount. Which is last time. My lords.
Close ಮಾಡೋಣ?
ಇಲ್ಲ
ಇಲ್ವಾ?
Because statement of objection is ready below.
ಕೊಡಿ ಸರ್. Only paramar ಇದರಲ್ಲಿ?
Paramount, I mean, in-laws ಇದ್ದಾರೆ, connected.
ಇದ್ದಾರೆ. They continue to have this relationship even after marriage.
Divorce ತಗೊಳ್ಳಿ. 498 ಬರಲ್ಲ.
And there are sufficient elements in the complaint.
If you have found illicit relationship, you can't draw them under 498A. You seek anything. That's a good ground for divorce.
Husband has moved. Husband has filed.
For divorce, husband has filed.
ಆಯ್ತು ಮಾಡ್ಕೊಳ್ಳಿ. ಅದು that is on merits ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. ಪ್ಯಾರಮರ್ನೆಲ್ಲ don't draw here.
ಅವ್ರದ್ದು ಒಬ್ರು and husband and parents connected petition ಇದೆ.
ಆ ಪ್ಯಾರಮರ್ದು ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. ಹಸ್ಬೆಂಡ್ ವಿಲ್ ಸಿ. ಸಾರಿ ಇನ್ಲಾಸ್ ಆಮೇಲೆ ನೋಡೋಣ. ಪ್ಯಾರಮರ್ದು ಯಾವುದು?
First 29 first.
29.
394.
So ಸುದರ್ಶನ್ದು.
Please.
29 disposed. ಇದು ಮೇಡಮ್ ಸಾರಿ. ಕೊಡಿ. 26 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ಅದೇ ಮಾಡ್ಬೇಕು. ನಾನು ಮಾಡ್ಕೊಂಡು ಮಾಡ್ತೀನಿ. ಅದನ್ನ ಇನ್ನೊಂದಿನ ಮಾಡೋಣ.
ನಾನು I filed a joint statement of objections.
ಪರವಾಗಿಲ್ಲ, ಅದರಲ್ಲಿ disjointly will consider. Don't. Yes.
I'll file it in the registry.
ಹಾ ಮಾಡಿ. ನೀವೇನ್ disjoint ಮಾಡಬೇಡಿ, ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಂಡು. ಸರ್ ಎಸ್. ಪ್ಯಾರಮರ್ದ ಅಲ್ಲ ಇದರದು. Yes. 30.30 is paramar, is it? Sudarshan. Sorry, 29. Madam, 29 allowed cost. 29.1 list on 4th. Objections be filed before the registry. Yes.
Please.
30.
4th, I'm having some inconvenience.
11th. 11th, yes. List on 11th, madam. 4th alla.
Serial number
30.
30.1 millets is a case and counter case millets. Yes. Mine is first complaint millets. I have no objection for
family
dispute. I don't have any objection for quashing millets subject to his
Within the parties.
Close ಮಾಡಿ. What is all this? Close.
Yes.
ಅಲ್ಲ ನೀವು ಸೆಟಲ್ ಮಾಡ್ಕೊಂತೀರಾ?
Civil suit is there that is contesting because there is a.
It may be question of consent, my lords.
Petitions are there. Civil suit is not possible to settle because already there is a.
ಆಯ್ತು, ಕನ್ಸೆಂಟ್ ಅಲ್ಲಿ ಕನ್ಸೆಂಟ್ ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಮಾಡ್ತೀನಿ, ಬಟ್ ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ. 2:30.
Yes.
ಸೆಟಲ್ಮೆಂಟ್ಸ್ ಇದೆಯಾ?
Settlement, serial number.
2:30 ಬಂದ ತಕ್ಷಣ ತಗೊಂತ.
ಇನ್ನೊಂದು
ಮೆಮೊ ಇಲ್ವಾ? ಯಾವ್ದು? ಎಲ್ಲ ಹೋಗಿದೆ ಸರ್. ಆಯ್ತು, ಯಾವ್ದು ಹೋಗಿಲ್ಲ ಹೇಳಿ.
My lordship.
ಪಾಸ್ಪೋರ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಡಲ್ಲ ನಾನು, ಅನ್ಲೆಸ್ ಐ ಹಿಯರ್ ದಿ ಅದರ್ ಸೈಡ್.
My lordship.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ರಿಲೀಸ್ ಆಫ್ ಪಾಸ್ಪೋರ್ಟ್ ಯಾರ್ ಕಸ್ಟಡಿಲಿ ಇದೆ? Why did police seize the passport?
Decided in Dubai from 2012 onwards. On offense under section 420, my lord, they have seized my passport as and when I arrived at in Kochi airport.
ಕೊಚ್ಚಿ ಏರ್ಪೋರ್ಟ್. ಮತ್ತೆ ಇಲ್ಲೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Police charge sheet has been filed by the therefore my lord.
ಅದು ನಾಳೆನೆ ಬರ್ಲಿ, ಮಧ್ಯಾಹ್ನ 2:30 ಆಗಲ್ಲ. ಈಗ ಎಲ್ಲಿ ದುಬೈಗೆ ವಾಪಸ್ ಹೋಗ್ಬೇಕಾ?
Oh Allah, my daughter's lord and husband are residing in Dubai.
All right. Well,
there is no allegation in the complaint.
no, that will consider. ಅದು ಇವತ್ತು ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್, ನಾಳೆಗೆ ಹಾಕಿ.
My lordship, item number 62 may be taken up at 2:30. I am pleading in person.
We'll see. Wait. Yes.
My lordship, one submission.
My lord.
Matter one is tomorrow, my lordship. Tomorrow this one matter is listed.
Matter is listed already.
No, sorry, ಇದು ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಆಗ್ಬೇಕು ಅಂತ. is a very urgency because the respondent police is very harassment to the.
There is police harassment, not a ground. Yes, fresh matter. Wait, ನೀವು ಯಾರು? ನಿಮಗ?
Your matter.
You are the petitioner. Why harass? Wait, sir. Why harassment?
498 ತಂಗಿಗಂಡ ಆರ್ಥೋಪೆಡಿಕ್ ಸರ್ಜನ್ ಮಹಾರಾಷ್ಟ್ರದಲ್ಲಿ ಇರೋದು.
ನಿಮ್ಮ ಮೇಲೆ ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ?
ನನ್ನ ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ನೀವು ಗಂಡನ?
Husband.
ಬರ್ಲಿ ಬಿಡಿ, ನಾಳೆ ಕೊಡಿ.
My lord, one
fresh matter. FR ನಂಬರ್ ಇದ್ರೆ ಬರಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ. Yes.
My case was supposed to be listed today.
Who gave the date? Give it. When do you want? Today we can't. No problem, but today you can't. Which year is that? Which year is that? Which year? Nodi madam, one ನಿಮಿಷ. 25. You come on 4th February.
My lord.
4th or 5th February. We'll take it.
My lord, mine is also date given matter by the previous this thing, my lord.
Which year is that?
2024. It's a matter, my lord, where compromise petition was filed. 320 application was filed in a 376 and 420 this thing, my lord. My lord
said, to marry?
Yes, my lord. Rape.
I will not. No settlement in that. Come on merits.
ಇಲ್ಲ my lord. ಅದರ ಮೇಲೆನೆ ಅವರು ಕೋರ್ಟಿಗೆ ಬರಲಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ ಕೋರ್ಟ್ said I will consider it on merits ಅಂತ ಹೇಳಿ 21
ಗೆ be considered only on merits.
Please, my lord.
4th ಬರುತ್ತೆ ಕೊಡಿ.
Kindly, my lord. 4th.
Serial number 77 and 78 is 230. Motion for settlement at 1:15.
Settlement ಎಲ್ಲ 2:30 ಗೆ. 2:30. Oh ಇಲ್ಲ, I'll take it at 4 p.m.
Please.
All settlements I'll take at 4 p.m. Today I'm not rising at 3:30, so I'll take every settlement at 4 p.m.
Grateful. Madam.